Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How's it going this morning? It is way too early. It is way too early, East Coast. It is way too early, Florida. Too early, I say, for a murder. Holy cats. Oh, man. How's it going today, guys? Goodness gracious, getting everything organized here. Yes, you may, Uncivil. You may have the StreamYard link in just a moment as I continue getting everything set up here. Okay, where is it? All right, Uncivil. It's in the group chat there. Okay. I hope you guys are having a good day. I'm having a fine day, except for it's just a little bit after when I wanted to be on. Hey, what's up?
How's it going?
Good. How are you?
I'm having a very nice day today.
Oh, your audio was shit for a minute. Hold on, it'd probably bounce out.
Good news.
StreamYard, we love you. We love you. I think it's all good. So you're having a very good day today. What's going on?
Nothing in particular. I just decided to be in a good mood, and I'm going with that for the moment.
That's a good idea. I like that strategy. Wish I could do that.
Yeah, right. Exactly.
Okay. Do we have a link?
I had a nice successful batch record yesterday. Recorded, I think, like 6 or 7 stories yesterday for future daily releases.
Dang.
And I got about as many from my editor back from the week prior. So I've got some stuff to release now. So that's pretty exciting.
That's awesome, man.
It's fun.
Oh gosh.
I've got a nice one coming up on this Friday for a Supreme Court React where we do the oral argument stuff. There's an interesting case, FBI versus somebody, where they're trying to get access to information that was developed through a FISA warrant. So through a secret warrant. And there's a provision in the FISA Act that can be read to suggest that you can at least get the evidence to the judge. So it would be only the judge who could see it. It would only be in camera, but at least you can get that much. Right. And they could adjudicate based on that. So there's a Ninth Circuit case that's up before the Supreme Court right now about whether or not that statute means what the Ninth Circuit did. And so I'm going to be reacting to that and see whether or not there might be some possibility to maybe get access to FISA information just before the judge, who we'd all like to remember was Senate confirmed and all. So one would think that would be okay, but we'll find out, I guess.
Yeah, it's the FISA court is this beautiful, beautiful thing where it gets to be whatever the government wants it to be, and it almost never gets to be what anybody else wants it to be. But it should be open. The idea of a secret court is antithetical to the founding of the nation. I mean, it's the opposite. It was exactly what they were building our judicial system to get away from. But the only good thing about it is you can't go to prison from a FISA court.
Yeah. All they can do is authorize warrants to peer into every aspect of your digital life. So, no concern there. Just that much. That's, yeah. And then they can use that information to develop information that they will then present to you at trial, but they won't tell you where it started. And FISA is theoretically supposed to only be foreign intelligence, but how well they're doing that is debatable at best. So this entire conversation, I'm sure, is subject to a FISA warrant as we speak. That's fun.
Only because I heard you're a foreign agent.
Oh, good news.
Oh, I have to. So, guys, in the audience, I checked the current coverage of the Curtis Reeves trial is, I mean, it's just not really started yet. So, just so you know, Court TV is yakking. It's their cameras in court. So, there's just nothing happening currently right now. It is jury selection day. So we'll see. I'm not sure how much streaming is going to occur. There was a hearing 2 weeks ago. So if the actual trial itself doesn't start up, we could always review what has happened so far at the pretrial hearings, depending on if they want to actually stream the jury selection. But I think they probably will. It's just people aren't. Court's funny. Court says it's going to start at a certain time, and if you're not there, they'll dismiss your case. But court never starts on time unless you're not there. That's when it happens on time. Otherwise, it just doesn't happen at all. Okay, let me get you in the description here. Yeah, I'm not a big fan of the FISA court in general. And we have another guest this morning. Welcome.
Andrew.
Good morning, gentlemen.
How you doing, buddy?
I'm living the dream.
Well, I'm glad to hear that. I think we could all use a little sprinkle of that in our lives. I'm still living in a dream because it's too early to be awake. Why does Florida exist?
Well, yeah, that is to remind us all of the misfortune of others.
Yeah, to hold
Florida is a cautionary tale. We need it desperately.
I'm going to start hiring. I'm going back to Disney for another week.
Oh, good luck with that.
Yeah, my wife is a super fan.
Yeah, that's couldn't she be a super fan of something cheaper, like Walmart or something?
The diamond necklaces.
No. Dang it. Yes. What I was, I'm going to start hiring people to murder people in California or something so that the trials that I cover from that will be much later in the day. That's what I need to happen. I need this.
The Ricada law change of jurisdiction.
Mr. Ricada, can you explain why you hired this person to murder someone else? Look, I didn't even care about the murder itself. I just needed later in the day trials to cover. There were not enough California murders, or better yet, Hawaii. Oh my God. Maybe we should
get a Guam in there for you, just to throw that in there, because even later.
Oh yeah, that'd be like almost. That'd be like in the evening almost. That'd be beautiful. We should do that. Guam, get with it. Get some interesting murders. Yeah, I guess there's a Guam court.
Yeah, sure.
Yeah. That worked out okay. Maybe we should do a rundown of this case and tell people kind of what's going on in it, because it's every time I explain it to people, their face looks very funny. They're like, what do you mean that's a trial? That should just be over. It should just be guilty. But Andrew, do you want to kind of run through it, or want me to, or what do you want to do?
Sure. Well, it looks like it was a double date night gone wrong. The defendant here, Curtis Reeves, and his wife went to a movie theater to see a movie. I don't recall the name of the movie now.
It was
Lone Survivor, no less. So a shoot 'em up movie.
There you go.
That's good. A bad sign.
Good movie. Mark Wahlberg playing Marcus Luttrell.
So Curtis Reeves and his wife go to the movie, and Chad Olson and his wife independently also go to the movie. Chad and his wife, much younger than Curtis Reeves. Curtis Reeves is a retired SWAT captain, retired police officer, older gentleman, and his wife. And Chad Olson and his wife sit in front of the older couple and get on their phone. They're texting their babysitter. This is before the movie starts. But nevertheless, Curtis Reeves apparently was in bad humor at the time and started castigating Chad for texting on his phone. Chad basically told him to mind his own business, although reportedly used more profane language than that. Curtis Reeves went to the theater management, who apparently didn't want to hear about it, came back to his seat. They exchanged more words, and then things became physical. If you believe the defense, the verbiage escalated. Chad Olson got up in his seat, turned, and faced Curtis Reeves, threw popcorn at him, struck Curtis Reeves in the head with some unidentified object, at which point Curtis Reeves pulled out a pistol and shot Chad Olson once in the chest, wounding him fatally. Chad Olson would die in the arms of his wife there in the movie theater. The couple had a young child. If you believe the state, Curtis Reeves was never under any kind of deadly force threat that would justify his going to the gun. Now, the rationales for deadly defensive force here are twofold, partly because of an odd quirk of Florida law. One is just traditional self-defense, that Curtis Reeves, he claims, had a reasonable perception of an imminent threat of deadly force harm capable of causing death or serious bodily injury from the younger, tall, but rather thin Chad Olson. But the second basis is that Florida law has a provision wherein what would normally be a simple assault or simple battery, meaning an assault or battery that does not threaten deadly force harm, becomes a felony if the victim is over the age of, is 65 years old or older. And Curtis Reeves was over that threshold. So arguably, even a simple battery on Curtis Reeves would qualify as a forcible felony under Florida law. And one of the provisions of Florida law that allows for the use of deadly defensive force is to stop a forcible felony. Now, we need to be careful about this, because just because words mean one thing in one legal context doesn't necessarily mean they mean the same thing in a different legal context. So it's not clear to me that there's existing Florida case law on this issue, but I presume that's one of the arguments the defense will be making here.
Yeah, and that's that makes this very interesting, because typically the reason forcible felony would be a protected, or an act you would allow someone to protect against with deadly force, is the presumption that felony level violence would have a tendency, or even a requirement under the law, normally to lead to serious bodily harm or death. Right. So it fulfills the traditional elements of self-defense, that you're in imminent fear of serious bodily injury or death, reasonable imminent fear. So that's why it would work this way. But this is almost like slipping that in through a loophole, if we're just using the idea that that he is only in, or that he's not in objective reasonable fear, but that he is preventing a forcible felony. So he still has that traditional articulable argument if he can convince the jury that this guy was actually a threat to him, that would justify deadly force on his own, like you mentioned. But it seems like the other theory is that's really going to be the interesting aspect here. And now 8 years ago, he had a stand your ground hearing on this case, because in Florida, there's the opportunity to bring a pretrial motion to dismiss, which says, if I'm not mistaken, basically, if you can prove by a preponderance of the evidence a justifiable case of self-defense, so greater than 50% like a civil trial, then your case is actually thrown out and dismissed at that point pre-trial. So if you can raise that issue with enough evidence, and the judge denied that in this case 8 years ago and said, nope, you do not have an automatic stand your ground defense. You have to go through the traditional trial defense version of self-defense. Is that relatively accurate?
Yes, it is. It's another quirk of Florida law that their legal standard for getting self-defense immunity, not really stand your ground, although everyone calls it that, has changed since then. So at the time, you're quite correct. The burden was on the person seeking immunity from prosecution to prove by a preponderance of the evidence that they acted in self-defense. This occurs in a pretrial self-defense immunity hearing. It's kind of a mini trial. The state is there arguing against self-defense. The defense is arguing for self-defense. There's no jury, of course, but the judge plays the role of both judge and jury in that hearing. And at the time that hearing was held, the burden of proof was on the defense to prove self-defense by a preponderance of the evidence. At the time, however, no courts in Florida effectively were granting self-defense immunity under that legal standard. And the legislature concluded that the courts were in the wrong, that the statute was not serving its intended purpose. So they revised the legal standard. They shifted the burden of proof to the state to disprove self-defense by clear and convincing evidence, which is essentially means evidence that's unambiguously counter to self-defense in this context. So when Curtis Reeves was denied self-defense immunity under the old standard, and they changed the legal standard, he said, hey, I want another hearing now because there's a new legal standard in place. Maybe I qualify under the more relaxed for the defense standard. But the trial judge denied another hearing, and the appellate courts affirmed that, hey, if you had a hearing under the old standard, you're not required to be given another hearing under the new standard. So whether he would have qualified under self-defense immunity under the new standard is, I suppose, something we'll never know.
Yeah, so that'll be interesting to see. I didn't realize that no one had won at any of those previous stand your ground hearings, or effectively no one.
Yeah, I'm not sure it's literally none, but it was so overwhelmingly a matter of denials of self-defense immunity that the perception was that the self-defense immunity statute was toothless.
And am I correct in thinking that Zimmerman brought his motion under that old law as well and was similarly denied?
He never did. He never did. No, never requested a self-defense immunity hearing.
Oh, okay.
So if you talk to criminal defense attorneys in Florida, they'll tell you, well, many of them are disinclined to seek self-defense immunity. Well, depending on a variety of factors, but often there's a perception that the judge is disinclined to grant immunity personally, and the judge is the person making the decision. So if you don't think they're going to be amenable to granting immunity, there's really no point filing the motion. Also, remember, the self-defense immunity is kind of a mini trial all by itself. So effectively, the defense is laying out their playbook for the prosecution to see before the trial begins.
Right.
And the defense will be, attacking the state narrative. So this exposes everything to the state before the trial begins. Maybe the state realizes some of its narrative is weak, or some of its witnesses are weak, or they need to buttress this part of their case in chief, and they come to trial better informed, better positioned for a guilty verdict than otherwise would have been the case. So a lot of defense attorneys are disinclined to request a self-defense immunity hearing for that reason as well. But Zimmerman never did. Even after the trial, he never did. Now, I suspect if anyone had tried, there's all this talk about, well, for example, the Trayvon Martin family, Benjamin Crump was involved even back in that day. They could theoretically have sued Zimmerman for wrongful death of Trayvon Martin. They never did. And one would have to conclude the reason they never did is if they had, well, then Zimmerman would have, because you can request the self-defense immunity hearing post-trial too, because it would be pre-trial for the civil court purposes. And if Zimmerman won immunity, then the other party is responsible for his legal fees. So it was a losing proposition for Crump and the Martin family to try to sue Zimmerman civilly. He would have sought immunity. He would have been granted immunity. I mean, the evidence was really overwhelmingly in favor. There was no evidence inconsistent with self-defense in that case. So although Zimmerman never sought it, if he had, it certainly would have been granted.
That trial was so long ago that Benjamin Crump was merely a B. Ivory Lamar at the time.
It's amazing. 8 years ago. I mean, how old is your oldest kid, Nick?
14.
Oh, okay. So they were born, but that
Just
was
barely.
That was a certain number of Nick Riccata children ago.
Yes, we'll start measuring trials. That's the third kid ago. This happened. Yeah.
I have a question of clarification, because I was trying to go through the docket of the orders, and I did see the order where the judge decided the stand your ground motion, which is the classic self-defense, and found that lack of a subjective sense of harm being the problem. So I did see that order. But what I didn't see was a separate order dealing with the defense of the statutory immunity because of this idea of the aggravated assault, because he was an elderly person. So I didn't see if the court separately ruled on that. So I assume they must have at some point, but I couldn't find it. So do you know, Nick?
I mean, they would only rule on the arguments that were made before them. I don't recall now if the forcible felony argument was made before them.
I think the argument was, because I found that in the docket.
Okay.
But I couldn't find a response to it by the court. So
You looked.
I mean,
at the
I have
docket,
the
which is way more
self-defense
than I
immunity.
did.
The court. I have the court's ruling on that self-defense immunity motion. I
Yeah,
mean, it's an order denying the motion for immunity.
Yeah, that I found.
In fact, I've written on this case a number of times. So if people are interested in looking at those old posts, they can find it at lawofselfdefense.com/popcorn. And there they'll find a link to the blog post I did back in, when the hell was it? Probably 2017, quite some time ago. But embedded in that is the order denying immunity, where the court explains its rationale for why it's not granting the defense the self-defense immunity they sought. I don't recall offhand if they cover the forcible felony. It's very short. It's only 2 pages.
Yeah. I don't remember it either. Also, one other thing of clarification. I don't know if this is still true, but it was true in Ohio that the defense had the burden of proving self-defense. So I don't know if that is still true. It's true when I went to law school in Ohio, but that was 14 years ago. So
yeah, Ohio's changed that. So they were the last state in which they were the last state that placed the burden. Now we're talking at trial here.
Yes.
So we need to distinguish between where the burden
Yes.
is placed for the pretrial self-defense immunity hearing and where it's placed for the trial itself. But back in I'm trying to remember, March of 2019, I believe it was. Ohio was the last state. Now, traditionally, many states had placed the burden of self-defense on the defendant to prove self-defense by a preponderance of the evidence. It was a classical affirmative defense in the classic meaning of that term. But over the course of the last century, one by one, the states began to view self-defense as basically a negative element of the criminal charge and shifted the burden to the state to disprove self-defense by beyond a reasonable doubt. Ohio was the last holdout. So Ohio was the last state that still had the burden on the defense to prove self-defense by a preponderance of the evidence. But in 2019, they joined the other 49 states.
See, there you go. That's why I get some update on my continuing legal education. So thanks.
CLE credit right there.
There you go. I'm claiming this time.
But it's that's different. What happens at trial is different than in the pretrial immunity hearing. So for the purposes of seeking immunity, the state can place the burden on either party at whatever threshold they want. I mean, for many years, Florida was at the pretrial immunity hearing, the defendant has to prove self-defense by a preponderance of the evidence. And if that was denied, then the defendant simply went to trial. But at trial, the burden on the same issue, self-defense, was shifted to the state to disprove self-defense by, beyond a reasonable doubt. So you might fail at self-defense immunity in the hearing and still be successful at trial itself because the legal standard is so much different.
Excellent.
Yeah.
I was under the impression that Florida was one of the more aggressive states when it comes to the pretrial immunity aspects, that they get a lot of cases thrown out on pretrial immunity comparatively to other states. Maybe.
I don't know that there's good data on that, but a lot of judges don't, I mean,
I'd be skeptical as a judge, to be sure, because I recognize that if I grant this thing, it kills the whole thing in its infancy, and that could very well result in a guilty person potentially not receiving a full measure of justice in terms of a full hearing. So I think my inclination might be to view it a little bit skeptically.
Yeah, thanks Schrader for that. Thank you.
Are you calling me a bad judge? Is that what's going on now?
No, I wasn't. I was not calling you a bad judge.
You're calling me Schrader, which made me feel like you're calling me a bad judge.
No, I was merely using levity to allude to the fact that we've seen that sort of mentality from a particular judge where a case seemed to be very, very straightforward. There were several motions to dismiss various charges in the Rittenhouse case, and even on the really obvious stuff like the gun law, which is obvious to me, and some of the self-defense claims, which were a little bit more obvious than others. Judge Schrader still said, nope, we're gonna run this thing to trial just because we want the jury process involved in general.
A skeptical eye, or it's not necessarily implying an eye that is blind, right? I think the point I got sold in the Rittenhouse narrative was when that motion, or when the defense, or apologize, when the prosecution's information dropped. Their formalized charge is called the information. When that dropped, and I had basically the same reaction you did, Nick. It read like a motion to dismiss. I'm like, I don't even understand what we're talking about at this point. So a skeptical eye and a reserved eye doesn't mean a never eye. So yeah, I was with you on that one where it didn't make any sense, especially and even more so perhaps the gun charge, because this is like the factual element was never there. The state knew it was never there. They were not. I mean, the whole thing was annoying.
Well, they were trying to. They
want to get the issue before the jury. What issue before the jury? There's no fact to decide.
Yeah, what they wanted to do there, they wanted to utilize the court to rewrite that law. I mean, that's what they were trying to do. This happens a lot in, that Shockwave shotgun. It's like its barrel length is way too short for a shotgun under the NFA, but its overall length is like 24.5 inches. So the overall length qualifies as just a normal sort of shotgun. But if you measure the barrel alone, it's way shorter than the 16 inches that's required. So, so this thing exists, and it was made by the company as like a troll to the National Firearms Act and the ATF classification. But in Minnesota, they really want to prosecute cases that will have that gun be labeled in Minnesota as, even if they can't change the national level interpretation, but they want to get a case where they can get people to plea out and then, get that gun sort of recognized as illegal, even though it isn't. They want to legislate through the courts on this issue.
That's not what courts are for, though. I remember this. I remember this from Schoolhouse Rock. Just a bill. Only a bill.
Yeah. That's how it's supposed to go.
Yeah.
But we're in new age territory, baby. We just use the court to do whatever
I'm just the court, and I invent Wickard fee Filburn from nowhere, and okay.
And Marbury versus Madison, but that's a different discussion. No, but no, I was not actually implying that you would be of the caliber of a Schrader, Mr. Uncivil Law.
I appreciate that.
No, it's just I just wanted to put out there for people, because we do see stuff like that happening in trials that we cover. Judges are remiss to grant pretrial motions in criminal matters, which is weird, because to me that the aggrieved party there is the state, and who cares if the state is aggrieved, in my opinion.
This is a fair point.
Part of it is you have to keep in mind that, I don't know, 98% of self-defense claims are bullshit.
Right.
They're just criminal defendants, bad actors whose lawyers are raising the legal defense of self-defense, because that's what you do as a defense counsel. But it's nonsense. They're factually unsupported. And if judges just don't take claims of self-defense seriously. It's just the bullshit defense that's thrown up against the wall to see what might stick. So the lawyer looks to his client like he's doing his job, and you don't get pinged for ineffective assistance of counsel and that kind of stuff. But for every 100 claims of self-defense, 98% of them are that kind of nonsense. So that's the perspective that judges have anytime they hear self-defense raised as a legal defense. For them to take it seriously, they just don't, for the most part. They're ill disposed towards this self-defense immunity law. I mean, so the courts do what the courts always do when they have a law they don't like. They constrain it as much as possible. They limit it as much as possible. And they're more comfortable with the traditional process, which is, we'll go to trial, argue it out in front of a jury. The jury makes the call. It's not on me, the judge, anymore, which it would be at the pretrial immunity hearing. And it doesn't cost the judge anything to go to trial. He's going to be sitting there anyway. They're just much more comfortable going that process. Of course, that process, the reason we have these laws in the first place is because there's a perception of abuse by the system, using the process as the punishment on people who did genuinely act in lawful self-defense, but are going to be compelled to spend hundreds of thousands of dollars to demonstrate that fact to a jury. So the legislature is trying to provide, an accelerated less costly, less risky means for lawful citizens to have self-defense adjudicated without the cost and risk of a full-blown trial. But judges don't really care about that from their perspective.
Yeah, and I want to point out though that in this case, I do think pretrial dismissal. I'm not a fan of the technical legal argument, and on the well, because he's older, he's entitled to more of self-defense by statute, even if it's not, because self-defense law takes into consideration the physical condition, age, or whatever of the defendant. I mean, it's a reasonable person in the similar factual situation. So the jury's allowed to consider the fact that this is an elderly man when they're determining whether being assaulted with a allegedly thrown cell phone and some popcorn justifies self-defense. And I think at first glance, that's a stretch. Now, maybe he is justified. Maybe this guy, I saw one thing where he grabbed the popcorn that was thrown, and maybe this wasn't, I don't know if we made this clear. Popcorn that was thrown was Mr. Reeves's popcorn. It was taken from him and then thrown. So maybe in the act of taking it, he grabs his arm or makes an unwanted contact that puts him into reasonable fear. Maybe there's a sufficient level of force involved. I don't know. But at first brush, you're telling me you shot a guy over popcorn is a rough sell for me. So
I think maybe one way to interpret the statute at least is that the nature of the statute would give you an objective reason. So maybe that's the issue, but you still need the subjective element as well on top of that. So the aggravated assault, assuming that exists by law, which it seems to, provides an objective reason. But you still need the subjective on top of that. You still need an actual subjective fear of death or grievous bodily harm, which seems to be an element that's missing in this. So maybe that's the right legal interpretation.
I mean, it all depends on whether or not you believe Reeves, right? Of course, he's claiming a subjective fear. He claims he was struck in the head by Chad Olson with some object, hard enough struck that there must have been some object in Chad Olson's hand, although he can't identify the object. So, if you don't believe that, of course, then you don't believe the subjective fear existed. Then he was just pissed and he shot somebody because he was angry at them, and that's not self-defense.
No.
Can it be though? Can we get there? Can we change it so that I can shoot people when I'm pissed and it'll be okay?
Well, Nick, I'm not sure you want that standard for your own well-being.
I do not. I'm completely kidding.
Yeah.
Completely kidding. Let me grab a couple of these chats because there's some that came in prior to the show. And then there's, of course, the ongoing chats that are there now. There is, I don't know when Court TV's coverage of the case itself will start, but I am consistently monitoring it, chat. And as soon as we are in the courtroom, we will get there. Oh, the Waffle House shooter. Looks like the jury recommended life without parole for the crazy Waffle House guy. Although not crazy enough to be not guilty by reason of insanity.
No, that's definitely a different level of crazy.
Apparently, the jury was probably just mad that they had to see this guy's wiener. Okay. Pickillington says Nick leaves all of his emails unreaded. Yes, I do. Phoenix Lord Asterman says Leighton gunted. President-elect Four Doors More Horse says Gator deserves zero sympathy. He was doxing for Ralph. Bowtie Charlie says Nick, please raise a glass to my ex-wife who died unexpectedly in her sleep this weekend. We weren't a good couple, but she was a devoted mom and nana. Our GK Kaylee is shattered. Her name was Lori, and she was only 63. Oh, well, I guess I can. It's a little early.
It's a lot early.
I mean, I guess I'll pour just a little tiny bit. I mean, I'm still eating my first Pop-Tart this morning.
If you're putting whiskey in your cereal, you may have a problem.
I'm not doing that. I'm just,
would it be too mean to say, tell me you're not paying alimony without telling me you're not paying alimony?
Oh, man. Okay. So Bowtie Charlie to let's see. Okay, Lori was her name. To Lori, who passed away at 63. And though your relationship may have frayed beyond repair, the relationships and bindings between your offspring, your kin, your family, your friends persisted on long after that. And though, again, y'all may have drifted apart, Lori was still loved and gave love to others. May her passing be marked by the good memories and not the bad. Cheers. Sorry to hear that, man. Squizgar says late and gay, on paper, unbreaded. Oh man, that is not going to get old for me. Not for a while. Lancelot 652 says late and breaded. Ryan Clark says regarding FISA and American citizens, that's why we are part of Five Eyes. We just have our allies spy on our citizens for us, and we return the favor to them. Plausible deniability.
Yeah.
I mean, yes, but correct me if I'm wrong. Five Eyes evidence isn't any more admissible than illegally obtained U.S. evidence, is it?
No, but the problem is always that you get the derivative evidence, which is admissible, and then you can find some alternative path to getting it.
Yeah.
So if I know some evidence exists through an illegal channel, then I can, based on the fact I know the evidence exists, I can concoct a legal channel that would get me to it now that I know it exists. So I'll go through a separate alternate channel and create an alternative construction. So you'll never even know that I found it initially through the illegal channel, because I'll say, well, I found it through this entirely legal means and not tell you about the rest.
Right. But I would humbly suggest that exists with or without the Five Eyes.
Yeah, that's definitely true. It's just to the extent that the United States cannot spy on things because of our own laws, we always have our neighbors to help. So sure.
No, we get very mad at that foreign surveillance that happens. We do not. We stand up against that. Please give me the info. Please give me the info. Yeah, we do not. We condemn their actions. We do it to them too.
Even formally?
We do it the exact same back and forth. But okay, let's see. Gates of Above says assault on paper, unbuttered. There we go. Stuff and Stuff says, hi, Nick. Hi to all. Thanks for another stream. Will you follow this trial all the way? That is the plan. That is the plan. I will be streaming all of the way through this trial, although there is a day where I may not be hosting the stream, but I believe Mr. Branca will be hosting it on Friday.
Hosted by Branca.
So
can do.
Yes, I will be on a plane headed to Dallas to go to the You Are Here podcast with Elijah Schaefer and Sydney Watson. It's going to be a lot of fun, but because of that, I probably will be on a plane. Will not be able to live
from the plane. Get the Wi-Fi package. You can do it. Talk on the plane the whole time. They'll love you.
Yeah, yeah. I need to get that private plane Wi-Fi package. That's a need to get upgrade myself to chartering
the Law
jets.
Tube plane.
Yep. Get the Law Tube plane. We just. Oh man, I thought we could have a Law Tube plane with that trucker convoy. All we needed to do was convince everybody to hire us for all the mass arbitration and then just burn them to the ground. But no, alas, there is not a plane yet. Again, I'm not a Benjamin Crump yet. I am merely a B. Ivory Lamar. But at some point, I hope to upgrade to a gold-plated toilet airplane of Benjamin Crump. I don't know if he actually has that, but he might.
If he doesn't, it's not because he can't afford it.
Yeah. All he'd have to do is just settle another case. Then you're done. That's really an amazing gig. I mean, if people don't know how smart Benjamin Crump is, when you typically, when you're representing someone in a civil trial and you're doing it on a contingency, your take home is between 30 and 40% of the award. So now the caveat for that is that your firm is putting up the costs of the defense or the plaintiff's work as it were, because the person typically doesn't have it. They don't have the money to pay your hourly. They don't have the money to do this. And so you really are selective with your cases. You pick the ones that you really believe you can either win outright in court after considerable expense, or that you can win a settlement on very quickly with considerably less expense. So when you see a $27 million award, Ben Crump's firm is going to take home roughly $9 million from that.
Yeah.
Without incurring any trial expense.
Yeah.
Right. Because he typically is not going to trial at all. So his expense is a plane ticket, some media appearances, some hotel stays for him and whatever other counsel, and then maybe some court attendance that happens for pretrial motions in adjacent actions. But they're not typically doing a bunch of the legal work there. They're just attending on behalf of the family. They're doing what we do. They're watching the hearing. And
there are no civil proceedings yet at that time, because this is the criminal pretrial hearings that are happening.
Right.
And Trump's obviously not involved in that. He's not a prosecutor. So he's not doing anything except standing out in front of the courtroom with a microphone. And
it's a beautiful, beautiful gig, and I commend him on it. Wish we were all so lucky. Anytime there's even not even just civil rights issues, though, a use of force issue between the state and the citizenry. Lots of people hire Ben Crump. Lots of non-black people hire Ben Crump too. I mean, he gets a little bit of a reputation for being for grifting on the race aspect, which is true. He does that, and he deserves that reputation. He also represents non-black and he represents white people and stuff like that in these use of force issues where they believe they can squeeze the settlement out of the city. And he does very, very well for himself. So, man, that's the way to do it.
That's a good
Holy
hustle,
cow.
man.
It's a huge amount of money.
Is he hiring?
He might be.
I mean, he's got a real firm. I mean, it's a business. It's just not one dude.
Yeah. Yep. At those pretrial hearings, I mean, he's not there. His staff is there. And we saw that in the Jacob Blake, I believe it was. He had some woman as one of his counsel who was attending the Kyle Rittenhouse pretrial stuff. And I saw her make a couple appearances, and I was like, you are terrible at this. You don't know the issues. You're going on to the news and you're talking about this case, and it is not intelligible. It does not actually follow Wisconsin law or any other law. It was all messaging and marketing. So it was, that's their job, by the way. She probably does understand the actual law, but it's her job to portray it in the way that she was. But yeah, he has staff and they do stuff. And they, again, I think you've said it, and I would agree. If you were in that situation, you'd hire them. I would if I were an African American family whose family member was shot by police, I would hire Ben Crump in a heartbeat. Okay. Let's see. Andrew War Snowboard says, as Ron Toye, this is Monica country. Thank you, Andrew. That ruined my entire morning. I'm very happy that you sent that. Oh my gosh. I don't want to view memories ever. I don't ever want to view memories. Please don't send me those. Sorry. I'm just here trying to forget, and Windows is trying to get me to remember. So, should we, while we wait for the court, should we go ahead and run this, whatchamacallit, the hearing that they did the other day?
Oh, sure.
It's two
I actually
it's 2.5
didn't see it,
hours.
so.
Okay. So this is 2.5 hours is pretrial motion stuff. But I will wait, let me get it queued up here. How do I do this? It's almost like I've never done this before. Sometimes. Okay. So I want to rats. I don't have an easy way to do what I want to do. I need to I just need to rearrange some windows because I have to keep looking for the actual hearing, right? Like for today's stuff to start. I want to make sure we get that when it hits. So I'm just organizing things so I can share the screen. And we're almost there. Share screen. Unbreaded. Edge tab. There it is. There it is.
That's everything.
Hold on, I gotta back it up 5 seconds.
What kind of room is this in?
It's a courtroom. This looks more similar to the oh my gosh. More similar to a Minnesota courtroom. Than some of these other ones I've been seeing. Oh, hey, do I not have to do this?
Live court reporters.
Perfect.
And court reporting procedures in capital cases. That's everything.
Oh, okay. So she said nothing.
Everything else.
Perfect.
Let's see. Oh, I should have highlighted it, but I didn't. In a nutshell, trials in a second degree or less, not pretrial matters. So you're not entitled to a court report, a live court reporter every time. I'll just make that perfectly clear. According to the Administrative Order 2018-042. So if you feel you have to have a court, this is the official record. You can't even hire your own. It will not be an official record. She is expected momentarily, but I wanted to make that very clear. So we can do a couple little things.
Oh my God.
That's an unfortunately shaped microphone.
Okay, it is not liking this on Edge here. I might have to switch to.
So I did see someone in the comments mention that their local news in Florida is reporting that this forcible felony by the age of the victim statute may have taken effect after these events, after the shooting in the movie theater. I don't believe that's the case. The statute was originally passed with that language in late 1980s, to my recollection. But it has, there's been a lot of court challenges over this statute. There have been amendments made to it. The provision that says it goes from a simple battery to a felony if the victim's 65 or older was in the original statute in 1989, however. But there's been other quirks around the statute. Like there was initially the courts were saying that the person being charged under this law would have had knowledge of the victim's age. I believe that's been done away with, that knowledge requirement. But I guess we'll hear it argued out in court here.
Let's see. Sorry, I wanted to for whatever reason that was not stable video viewing. Who knows? Oh, he's having a stroke. Cameraman, fix yourself. Your mods are acting like children and fighting. Are they still? Are there any rules in place to prevent this in chat? It's distracting and seems unprofessional. Yeah, call my mods stupid fucking morons for doing it. And if they keep fighting, I'll just start. I'm going to remove all the mods. I'm not even joking. I'm going to remove all moderators from this channel. I cannot believe this fight between these two autisms has been happening for like 4 straight months. They cannot get over it. It's amazing.
What fight are they having? I don't even know what's going on.
Do
Do I have to pick a side in this mod war?
Yeah, it's between C. Goody and Angry Baneling.
Well, like,
What are their problems with each other?
yes. For
Oh,
example,
God only knows, man.
Okay. Guys, kiss and make up. You both are good people.
It's the most ridiculous thing in the world.
Well, this is compelling stuff.
This is great.
So have you discussed the Amir Locke no-knock warrant shooting death yet?
No, I saw a little bit of the footage of it, but I didn't watch it in detail.
I mean, there's really no use of force law issues there. There are obviously very important public policy issues there.
Right.
Around
So
no-knock warrants, but
basically they bust into this guy's house. They have a no-knock warrant, which means they don't have to knock and announce prior to entry. He's sleeping on his couch under a blanket. They come in, surround him, and then the video stopped for me because they want us to look at these issues, but they don't want us to be able to actually analyze them. So what
wasn't even his house actually, and he was not a subject of the warrant. He had nothing to do with why the warrant was there to catch a killer. I mean, they were looking for a murderer in the apartment. And Locke was sleeping under a blanket on the couch. The police had a key to get in, so they just quietly unlocked the door. Then they go in, start screaming, "Police, police, police!" Locke comes out from under the blanket with a gun in his hand. While he's being faced by police officers, and they see the gun and they shoot him. And to the extent that they're there lawfully, which certainly appears to be the case, it's almost certainly a good shoot under the circumstances. The question from a public policy perspective is, should we allow these things? I mean, it's a particularly emotional case because Amir Locke was not, by all appearances, a bad actor. He was not involved in the crimes for which the warrant was issued. He had a concealed carry permit. He was a DoorDash driver and got the gun specifically so he could protect himself from violent crime. By all evidence, he was simply a law-abiding armed citizen exercising his Second Amendment rights, and he ends up getting killed by police. So it certainly feels like that shouldn't happen. Of course, the other question is, so there's lots of screams now to just blanket get rid of no-knock warrants. And I guess that's one way to go. I mean, some jurisdictions have done that effectively. They've just simply prohibited no-knock warrants. But there are negative consequences to that too, right? So if you're going to a house, you believe there's a murderer in there, and you knock and announce where the police were going to be coming in momentarily, there might be a reasonable expectation that murderer is going to say, all right, well, this is a gunfight now, and arm himself up, instead of being able to take him into custody while he's still waking up in bed.
It's a two-edged sword. I go down the path of, I think I'm okay with no-knock warrants being gone. I think I'm okay with that. If police are showing up to arrest a murderer and they're anticipating the possibility of a gunfight, they have lots of protective gear that they can use. They're the ones who are in anticipation of that. They have the ballistic shields. They have other things that they can do.
And that's true, but I think the police would argue that it's not just themselves they're trying to protect. There could well be other innocent people inside the dwelling who now become hostages or potential victims of a gunfight in progress. And for the people in the comments saying that's not a good defense of no-knock warrants, folks, I'm not trying to defend no-knock warrants. I'm just presenting the arguments for your consideration. I mean, a big taint of all this, of course, is to the extent that you don't don't buy into the whole war on drugs paradigm, and I generally don't. Mostly these no-knock warrants arose because of the war on drugs, because it's so easy to dispose of the evidence being illicit drugs, if you're aware that the cops are polite enough to knock and let you know they'll be coming in momentarily.
Yeah, you just flush your heroin down the toilet like, cocaine like Penelope Cruz did in Blow. Right? You just, well, she tried to. She didn't get very far.
So page 3 of the administrative order.
But yeah, I don't know. The interesting thing you mentioned was one of the arguments would be that it puts other innocent people at danger. And in this case, it appears that Amir Locke was the innocent guy put in danger. The problem is he was put in danger by police. Can you imagine house you're living in or you're staying in for the night or whatever gets busted into? You've got a gun to protect yourself. You get up with the gun. You get shot by police because you had a gun. They were entering in. You had nothing to do with it. What a shit way to go.
And of course, it's not unusual that the police are actually sent to the wrong address entirely.
Yep.
So then you're just a law-abiding homeowner, snoozing away or watching TV or whatever, and the door gets kicked down. And sometimes a homeowner is armed. I mean, I'm usually armed. And if my door gets kicked down, I'm probably going to have a gun in my hand pretty quick. If it's not immediately obvious that those are law enforcement officers, it's quite possible the person kicking down that door could get shot.
Yep. It's well, and that happened. Right. Well, that's kind of what happened with the Breonna Taylor case. Although I think an officer did get struck in the leg there, didn't he? Where's Nate when we need him? Nate would remember. He knows that case. No, I'm pretty sure. Yeah, well, that wasn't a no-knock warrant. That was a knock warrant.
They had a no-knock, but they in fact,
they knocked.
Well, a neighbor heard them announce.
Yeah. Yeah, so that'll be that guy's trial's coming up, if I remember right. Also, the McMichaels.
I thought they dismissed the charge against him.
Maybe maybe it's a civil case, or maybe there's something coming up with that Breonna Taylor case.
Do you still have those?
I do.
Okay. I just want to make sure if you need.
I guess we should see what's going on in this trial, this hearing.
Bring that today, because I don't know that we're going to get to a lot of the things. I don't know. I've got it.
Okay.
But I
Start talking, lady. Address the issues in this
on
case,
the docket,
please.
And Jaws has come since we last were together, and I've enjoyed it immensely. I do.
It's very hard to
This
hear.
judge is so low energy. It's unbelievable. I would not have sought self-defense immunity from this judge. This is not the kind of judge that's going to do that.
Here, I can turn it up, Kurt.
Cases as well, the tab ones that we gave the court,
Mhm.
the actual cases that are in the memorandum.
You found a source. You found a solution.
I
This
did.
is the court knows the difference.
I found it. The chat didn't tell me about it.
You have that.
That's handy.
Is that a plug-in?
All right.
Yep.
Volume?
Martin, where do you wish to begin today?
Oh yeah, I'm supposed to send it to you.
Yeah, put it in the group chat.
Oh, I don't.
Maybe we could all use it.
Jury instruction, I think that'll be a quick way to get started.
Also, did you find a way to get real-time monitor for your audio output in your earphones from OBS so you can hear what you sound like when you use the voice distortion effects? Or do you not hear yourself?
No, I hear it. It's through my interface though. It's not through
I
StreamYard
see.
or OBS or anything.
I complied with all the rules, including giving notice and.
All right, I need to figure out how to set that up so I can get it out through my interface properly.
I would like the court to say to do the notice of.
Because I was trying to do it yesterday and I had delay and
Complied with
it
all
was
of the
not
rules,
working.
Including filing the notice and giving notice to defense counsel.
He said the judge is low
The rule
energy.
states that,
This
at least for the ones that I have.
this attorney's right up there with her.
It's a shall be granted. So I'm asking the court, I don't think we need to go through every one of them. You have judicial notice number 1, which is justifiable use of force, chapter 776. Judicial notice number 2, justifiable use of force, chapter 776.05. The first one, just so that you know the difference. Judicial notice number 1, justified use of force is 776.012. 012 is the stand your ground. 776.05 applies to law enforcement officers. I then filed a judicial notice number 3, asking the court to take judicial notice of the immunity hearing transcript, stand your ground motion, volumes 1 through 19, which you presided over.
Oh my God.
Judicial notice number 4 deals with several administrative codes dealing with maintenance of an officer's certificate to be a law enforcement officer, the law enforcement officer firearms qualification standard, and how the implementation of the Federal Law Enforcement Officer Safety Act of 2004, you might heard it referred to as an HR 218. But Florida, each state gets to interpret how they're going to administrate it. So those are the 3 there. And judicial notice
Oh my gosh.
5 is in fact titled USCA section 926C, carrying concealed firearms by qualified retired officers. And again, referring back to the HR 218, which Mr. Reeves had not only carrying concealed weapon license, but also as a retired officer, he had a authorization to carry under the Law Enforcement Safety Act.
You can't hear clearly because he's not talking into a microphone in the same county for whatever reason.
At this point,
Long story short, what he's doing right now is he's asking the court to take what's called judicial notice of several different things. And he's laying there. So they're going to make motions for the court to take judicial notice of all these things. He's laying out what those are. When a court takes judicial notice of something, it typically is another order or a statute or whatever that they're going to raise at either a hearing or at trial. And they just want the court to be aware of this thing, recognize its validity, and head off any potential objections ahead of time.
They say shall as to the statutory request, and they say may as to the others, but if you give notice, then the court shall. So the court shall. I also agree with the prosecution that just because the court takes judicial notice doesn't make the items that are requested and that the court takes judicial notice of admissible into evidence or to use in trial. So we'll deal with those as we come up. We do anticipate filing our own request for judicial notice as it regards the government's request for 18 USCA 926C as the government.
Good job with the audio there, court.
Request for judicial notice as to chapter 776, kind of the preamble. There's a similar part of that federal statute as well, so that's coming down the pipe. But in terms of what the court can do here, the court must take judicial notice. I'm agreeing with that.
Okay, and that's all pursuant to the evidence code 90.201.1 as far as the statutes, and then the rest are 201.2. And I will take judicial notice in accordance with the
yes,
rules.
01, 02, and 03.
Oh boy.
So, yeah.
Yeah, this is high, top shelf court audio going on here with this this judicial notice tomfoolery. So I'm guessing the guy on the left is the prosecutor because the other guy referred to him as the prosecution. Oh boy. Riveting stuff. Let me read some more chats. Jack of the Dead says, asking for prayers as we lost my dad over the weekend. Don't pour one out as it's early. He was a great man who touched the hearts of so many and brought joy with him. Thanks for streaming. It helps a ton. Also, see good, he is racist. Well, thank you for adding adding that bit at the end that turned a
And
sad
Before we move on.
chat into a much funnier one. Sorry to hear about your dad, man. Absolutely. We'll pray for your family.
Mr. Michaels, you made reference to something coming down the pike.
Yes, right. It's similarly situated, may and then shall.
Okay, but it'll be an easy, like
this.
moments to rule on as
Right.
opposed to.
I have no objection. If you just send it to the court, as long as you send me a first copy.
It's pretty bold to wear khakis with your suit as a prosecutor
Very good.
Yeah.
or an attorney in court. I wouldn't do that look.
And
Personally.
what next, Mr.?
Well,
What's
It
next?
seems-
Cargo pants?
fine, once you sign those,
Mhm.
if you wouldn't mind returning to me, I'll conform all the copies.
I mean, I guess for a hearing, it's a little bit easier than a full suit. So, okay.
It
I'll
just
give him-
looks
I'll
like
give
he's
him
at the
a break.
golf course or something. Not the golf course. That's the wrong one. I don't know what it is.
So, has the jury selection thing started yet, or what?
No.
No.
Okay.
No, they may
checking.
not be televising the jury selection.
Okay.
They're only impaneling 6 jurors and 4 alternates
Yeah.
for it, though. So,
What do you mean?
Uh,
They're only impaneling 6 jurors.
that's how many they're having. They're not. It's not a 12 juror.
Florida can do
Trial.
6.
What?
Florida can do 6 jurors for felonies. I think for everything except for first degree murder. What's the formal charge? Here, let's see.
Okay.
Judge, the next one, if I could suggest to the court,
Second
That's
degree
gotta
murder.
be unique. Is that unique in the United States?
jury instruction.
I don't know. Yeah, he's charged with second degree murder.
Right.
As far
I mean,
as
I've heard
can
of 6
tell.
person juries for misdemeanors, but for felonies? I mean,
Yeah. Yep.
okay. This has blown my mind.
Judge,
So on one hand, I approve of 6-person juries when I'm watching jury selection. On the other hand, I disapprove of 6-person juries in all other circumstances.
spell out
Hey, what's up,
Yeah.
Nate?
George Zimmerman
Yo!
had a 6-person jury too.
Nate just texted me to let you know to let him in.
Yeah, I was like, let Nick know I'm back here.
I didn't. Sorry, I did not see you down there in
jury
the
instruction.
green room.
Yeah, I heard the conversation. I was hearing
Nate,
the
did you
conversation.
know that in Florida they have 6-person juries, even for
Yes.
felonies?
Yeah, the number of jurors isn't static from state to state. So, for instance, Zimmerman had 6 people on his jury. For
Is this a
trayvon Martin.
uniquely Florida thing? Because I've heard of 6-person misdemeanors, but I was under the impression that all the states use 12 for felonies. Is this a uniquely Florida thing? Is Florida an
No.
aberration?
Well, it may be. It may be. I haven't looked at all the other states, but I do know. I know some lawyers from different states who they did do
There
6-person
is no-
felonies.
A definition
felonies,
in
so.
any of the standard and
Yeah, I don't think it's unique to New York. I mean, to there. And I know here in New York, though, if it's the way it works here, if it's a low-level misdemeanor, it's a judge trial. If it's a misdemeanor, you get 6-person jury trial, and then if for felonies, it's you get 12. So I think that's generally how it is in most states.
All right, you learn something new every day.
There we go. Tom Grawl says, "What do you think will happen to the ATF's new rules on 80% and pistol braces?"
And that's the definition.
I have
Courts
no
do not
idea,
have a
but
receiver or
if
frame.
if they take 80% lowers off, if they're like, "Oh, nope, this is illegal to sell," then someone will sell a 70% lower, and then they'll eventually just be making blocks of metal entirely illegal.
Yeah.
I don't know where they'll go, because eventually it's going to have to be illegal to just buy metal.
Yeah, Defense Distributed was making little milling machines that would mill, I think, from just a pure block.
Yeah, the Ghost Gunner 3. I want one. I don't know if it's any good, but I want one. I want to do a live stream with one. I thought that would be fun.
That sounds like fun.
That sounds good. Yeah.
Yeah, I saw one of those at a gun conference someplace. I forget. I think it was down in Texas. They had in fact, the guy who ran the company, who then I guess had to flee. I don't know whatever happened to him.
All right.
Oh, I can
Wow.
tell you, it
I'm
was
sure you're all
fascinating
well aware of the
'cause it looked like-
significant line of
it looked
cases
to me like a
regarding
setup.
special jury
It looked like a setup.
instructions. Okay.
So what happened was he was charged, Cody Wilson. He
Right,
was
I met
charged.
him. Yeah.
He was charged with solicitation of a minor for sexual activity. He met her on a website called sugardaddiesmeet.com, which you have to be 18. You have to be 18 to sign up to. She represented herself as 18. He sent out a car to pick her up. The car had defense distributed on the side, so they're pretty sure it was his. They had him and her on camera going into his hotel room in the hotel, but they could never prove the sexual encounter occurred. And so I think that was one of the problems. He got a plea deal, pled guilty to child endangerment, I think. No registry, no sex offender registry, 5 years probation, and deferred adjudication for dismissal. So if he doesn't violate his probation over 5 years, it's actually dismissed, and he has no felony record, and he gets his gun rights preserved and everything. It's a great deal for what happened.
That sounds like a very, very good deal to me.
Yeah, that's one of those. That's one of those tough cases because it's.
I mean, I haven't committed any felonies in the last 5 years, so you can go 5 years without committing a felony.
But it's like, what level of diligence do you have to do to see if someone's actually 18?
Oh Lord.
And the judge's answer on those questions is more diligence. No matter what you've done, you could have interrogated the doctor who delivered them, read their birth certificate and everything, and a judge will still say, "Well, sorry, you should just be attracted to people who look older than 18." Then,
when it comes to this for at least statutory rape, the states are a bit split on this. Some states will allow an affirmative defense if you had knowledge or belief of knowledge that they were over 18, but some states don't. Some states do not allow affirmative defense. They're either over 18 or not. In some states, it's a strict liability crime, which to my mind is really, really weird for a criminal statute that has no mens rea. It's like you just did the act, and that's enough. Okay.
Yeah, it's a strict liability criminal crime or criminal act, which is I'm not a big fan.
Yeah.
But then with the fences, it's funny because I remember I had a big argument with someone at law school about this. It's like, what defense could you use? If you're 30 sleeping with, let's say, a 14-year-old, it's like.
Well,
the act
it's
itself,
defense that you would use.
I didn't know.
I mean, if they're over the 18, a 30-year-old can sleep with an 18-year-old.
Yes.
A 50-year-old can sleep with an 18-year-old. So the only question then would become, in such a state, did you have a reasonable belief, for example, that she was over the age of 18? Did she show you, for example, a driver's license, which might have been faked or might have been someone else's, but did she show her driver's license? Did she represent herself? Was she in a bar or some other context that might give you an affirmative defense in some sense? And then it's up to a jury whether or not they believe any of that crap, but at least you can make the argument.
Yeah.
Yeah, and I mean, it becomes a different question. Here's my theory on what happened. Either it was a setup, or this girl got caught otherwise than with Cody Wilson by her parents doing what she was doing, and then suddenly it was let's pin the blame on someone else. When the police showed up to do the interview with the victim, she was in pigtails and she was wearing pajamas. She looked like she was 12, right? Like she was dressed down. And then, but of course, on the surveillance footage, she's in a black cocktail dress. She does not look like she was 16, which I think in Texas it's 17.
Oof. Yeah, I know a lot of these states have these weird laws. Like I know here in New York for a long time, it was you could marry a 14-year-old, but you couldn't sleep with a 14-year-old unless it was like some weird combination of the two, where 17 was the age, but you can marry younger. I don't know. It's all crazy.
The exhibits.
Yeah, it's weird.
Exhibit 5. And 6. The redacted is 6, and 5 is the original. That is.
Oh my God.
Filed secondary.
Whoever put this
to
camera angle is horrible, but
motion
they're assuming they
supplement
small courtroom
motion
and small jury
12-1,
box. That's why they got this
2020.
angle.
Well, this is a pretrial motion hearing that was going on, so I think I don't even know who was covering it
That was
at
my
all.
initial question. What kind of room are they in?
And the,
Well, you know, because I know where we were at, they had like there were some rooms where you had trial rooms, then you had conference rooms, then you had grand jury rooms. So it's like,
yeah, this is probably just one of the little side courts for motion hearings.
yeah. There used to be me over there, like on the DAs, and you see like a huge box of like 200 cases that you had to go through that day. And I'm like, oh my fucking God. Yeah. And then you can't read this shit. And it's sad because these are people's lives, right? I got major felonies and stuff, and I'm just reading off what somebody wrote on a damn envelope. Insane.
Did I read this?
Glorified reporter.
supplement.
Yeah,
Did I read this chat from Too High Strung that said "See Goody likes men"? That one's there. Ackles Floozy says, "Yay, need a new trial so I can pretend to work. So glad I found y'all during Rittenhouse." Well, I'm hoping I hope they panel the jury quickly and get right into this trial. I mean, if they're getting the 6 and the 4 alternates, I have hope that we'll actually get to some trial stuff today. No.
What do you guys feel about the new thing about the Ninth Circuit is talking about allowing all their cases to be live streamed now, even the trial cases?
Ooh, that'd be great.
That'd be
Yes.
federal court. That'd be crazy. They're doing now the appellate, the 3-judge appellate cases. They're live streaming those, but they're talking about doing it at the trial level.
Oh, please put it there. Matt Robertson, no, I don't have a creator link for the Brave browser download. I don't know where to find one. I just know I'm registered on Brave. That's about it. But I don't have the download link. I don't know where I'd get a download link. I'm sure there's some easy way to do it, but I'll have to do it after the thing. But
Hey, quick question: Have you guys ever heard of the phenomenon called late rape?
Late rape.
Yeah, it might just be a cop thing.
I'm always
Where
happy with
there's a phenomenon that usually happens with somebody who's underage. What they were finding is that, let's say if they were late to dinner or something like that, or their parents didn't know where they were going, they've had the phenomenon where young ladies would say, where are you at? And the parents would pressure them and say, I was raped. And then you had this whole big thing about, like it was an excuse for really not being in trouble. You're not supposed to be with this person, not supposed to be with that person. So they started having it, and they would, and some of the stories were very compelling. Like they would really, this person, and then they would find out that was nonsense. But it's interesting because you don't really hear a lot of that. You don't hear about it unless you're inside that law enforcement circle. When you're outside of law enforcement, you probably never heard of late rape. But it's a phenomenon that actually occurs. It's an excuse. So that's why, especially now when you're talking about Me Too and all that stuff, why it's even more important now to have some evidence, because right now it's just the accusation is the evidence and it locks you up for 100 years versus having some actual evidence, because this is something that actually happens in law enforcement, and they all very sensitive of it too.
Well, there's that, and the other place where this type of stuff can come up is with abortion, right? Because when someone goes in for an abortion and says that they were raped, then the questions stop right there, and there's no reporting to family or anything like that. All of the dynamics change very quickly when that happens, and so there's this there's the potential.
You should
that
make
there
them
will
mandatory reporters. That'd be good. Make them mandatory reporters. I mean, collect the DNA. We've got evidence, and then if the woman lied about it, which there should be some sort of penalties for that. Here's what I think. I don't think you should be able to make up rape accusations, and I think if you do, you deserve some sort of penalty.
But then what do you say to the people? Because every time I agree with you 100%. I want to make very clear I agree with you 100%. But then what do you say to people who are going to come back and say, well, what about the real victims, right? What about the real victims who can't prove it, and then and now they're going to be afraid of reporting because they don't want to be called to be liars and then go to jail?
Well, I kind of think that actually goes the other way. I think the fact that truly false rape accusations are not prosecuted is at least in part what leads to the perception or the reality that rape accusations might be false. Because they're never prosecuted, because the false ones are never brought out, there's no penalty, then they're not being dissuaded, they're not being discouraged.
Yeah.
So if we bring cases against, you have to prove beyond a reasonable doubt, just the same as you would anywhere else. But if you can do that, then it increases the probability that the remaining cases are genuine. That's the whole point of deterrence, of general deterrence theory of criminal prosecution. So I kind of think it goes the other way.
Here, let me give you guys a very interesting case that I was involved in, and with the Manhattan DA's office. So a woman goes to a club with this guy. She goes to a club with two guys and two of her friends. While she's in the club, she says she goes into the bathroom, and one of the people who she's with pushes her in the bathroom and sexually assaults her. So that happens in the club. They come out of the bathroom and get a cab, and she agrees to go back to the person who just sexually assaulted her's house with them. So she's sexually assaulted, and she agrees to go in a car with all these people back to this guy's house. When they go to his house, she then goes to his room alone with him. He says, "Come to my room." She goes to the room alone. She says she falls asleep, and supposedly another sexual assault happens. And he records the second piece of it. So the DA's office goes, and they say, "Okay, well, so he gets beat up by someone. He gets beat up by one of the people there because she wakes up and she starts screaming that she's been sexually assaulted." But the DA would not prosecute the guy because they said they could not convince any jury. They don't believe they could convince anybody that this was a rape allegation, because who would get in a cab with their rapist to go back to their apartment and then go into the room? But
good question.
So they did. So they dismissed it. They're like, "All right, he's not." But come to find out, this guy had done this something like 15 other times, and had like a whole catalog of stuff. But for that one instance,
all right, go ahead.
They didn't believe her. So it's like,
well, they might have believed her, but what they have to consider is, can they convince a jury unanimously?
Yes, that's a good point, Rob. Andrew, very good point.
Eyesight is good here, but standing up here, I can't read.
And the victim may not be,
I can relate
For anyone wanting an update on the riveting hearing that's going on, the prosecution just made a motion to sit down while delivering his arguments because his eyesight is not so good when he's standing. And no, I'm not kidding.
This is a significant factual basis.
Your Honor, I'd like to make a sciatica motion.
If I'm wrong, but I think we can dispense with that for these hearings.
They're finally getting this.
Puts a little donut
started.
pillow on his seat.
And in each of your motions, it does take up a lot of time, reading time and consideration time. And if we want to have it, each of you do one factual basis, I'm fine with that, but that's going to hold us.
Jesus, this looks like a Subaru commercial.
That throughout the course of all of these hearings. I'm fine if you don't go through them at all, but if you wish, if you must, for record purposes, I'm fine with that too. But
So, Kurt, we're going to meet up in Texas?
Absolutely. I'm looking forward to it.
Yeah.
Rehash that over and over.
When you head down,
Mr. Martin.
what's your exact travel schedule? When will your house be unlocked?
Yeah, I know. It's I don't know exactly, because I'm riding the motorcycle down, and I'm in Denver, so you never know if a storm comes up. I have to adjust the schedule by a few days here and there. But after this trial's over,
Oh, okay.
if it ever starts,
soon,
yeah,
while it's still cold, That's
late this
amazing.
month. Oh yeah, it won't be too bad down there.
Right?
It'll
No,
be
but
cold
just when
here.
you start,
Yeah,
it'll be a little chilly.
yeah. I don't mind the cold. I ride in the cold all the time. I have electric gear for that. The cold's not a problem. Ice is a problem.
Oh, you're hardcore. You're hardcore.
Hardcore.
That's the only thing that is relevant.
These court reporters who are sitting there typing every word, why isn't their job obsolete? Like we could just record the whole damn thing, right? Why do we need her to type all this shit out?
Because they've become part of the judge's family.
Because what about the candle makers, Nate?
What about the
What
candle
about
makers?
the candle makers? Do you get my reference? Do you know my reference? Please, somebody know my reference. Anthem by Ayn Rand. The street sweeper always wanted to be a scientist, but the party made him a street sweeper, right? He found an entrance to an old sewer, and down there he found a box with electricity in it, and he found some writings and stuff, and he found out how to make light bulbs again. And so he goes before the Ministry of Innovation and presents his discovery, and you know, he's trying to apply to be on the Ministry of Innovation. That's what he always wanted to do. And they're like, look, we just spent the last 5 years switching from torches to candles and training all these people. And he's like, but this is light. This is we don't need candles anymore. And their response was, well, what about the candle makers? What do we do with all of them? Did you even think about them? He's like, they could do anything. They could do anything else in the world.
People still make candles.
No. What about the candle makers? So what about the candle makers is what's up with court reporters. Just because their job is literally obviated by a microphone and a recording system, they're still there, and they worked hard to be there.
Well, thank God for
their
their
job
union.
is hard. Their job is hard as hell. You have to type everything these boring people say.
Thank God for their union. That's what we should be thanking God. This is a unionized job, and then she's not going anywhere.
So what I'm suggesting to the court is when we look at what is relevant to the proceedings, what is relevant to prove a material fact.
And you know what? I'm also going to say this. Every trial that we've watched, every court reporter has been a woman.
Yeah.
Think about that. Every trial we've watched with Nick, every court reporter has been a woman. We now have to
Now
sue
that you mention it,
for race
I'm not sure I've
discrimination,
ever seen a
for
male
gender
court reporter.
I
discrimination.
never really thought about it before, but now you mention it.
Well, you see, the real problem is that the female court reporters, they all got together and they had a competition with some high school male court reporters, and they lost 5-2. It was really a bloodbath too. So, but we're not allowed to talk about the famous female court reporter getting slaughtered by the adolescent male court reporter game.
They just cut our homegirl too, poor Megan Rapinoe, and what's her name? And
They cut
her.
Rapinoe.
They cut him, yeah. They cut
Wasn't
him.
she like 37?
Yeah, she's going to be 38 for the next World Cup, so they cut them for these tournaments because they're like, we got to give somebody else a chance, right? You
Get
can't
out of
have you
there.
beating
When
the
did they
women's
cut
team
her?
from Qatar.
Not soon
When
enough.
did that happen?
It just happened like a couple of days ago. It's all on
Okay, I
there.
totally missed that memo. That's hilarious.
So my dad messages me the other day, and he's like, hey, Honduras is playing the US in the World Cup qualifier match right now. And I'm like, oh yeah? And he's like, in St. Paul. They were playing in St. Paul, Minnesota against Honduras. It's like negative 15 out while they're playing soccer. Oh my God.
Wow.
Oh, brutal. And they had 20,000 people at the game. I couldn't do it, man. I couldn't. I like soccer. I would love to go to a World Cup game or some qualifiers
Oh, that'd
in
be
St.
great.
Paul, but man, I do not want to be out in 20 below.
Is mystery is what he knew at the time, what his perceptions were, whether or not the jury's going to find they were reasonable or not. That's why we're having
That court reporter should have a soundtrack, like a little child's piano.
Mrs. Reeves. There is no logical.
Her movement is very like rhythmic. It's interesting to watch.
So it's pure speculation.
I know that she's got to be typing I know this job has probably got maybe another 2 years left before they say, what the hell are they paying me the 6-figure salary to sit here and just type what these people are saying?
Turns out that's all she's been typing for the past 3 years, but no one's ever read her transcript to find out because they all just pull up the audio.
It's all red rum, red rum, red rum.
All type and no play makes Jane a dull girl.
She needs a transcript. She goes right here to a transcript and she downloads it. Okay, I got a transcript.
And I cited several court cases to the court, but I'd like to do, Your Honor.
I don't even know how their little stenography machines work because they have shorthand built into them. So they have a lot of commonly occurring words and stuff on the keyboard itself. So they don't have to type out every letter. But it's weird because it's like, where do you type out the actual letters? Like, I don't understand how they function. I don't get it. It's like a foreign language to me.
Yeah, that's not a full keyboard. Let me look, see what their keyboard looks like.
Have you guys all seen the my favorite writing of all time, which is Matthew Harris, the UCLA guy who sent his manifesto? Have you guys reviewed that at all?
I've looked a little bit at it. Yes.
What's your takeaway, Kurt?
We first have to start off with.
I'm not sure why you're quite as fascinated as you are, because there's a whole lot of crazy manifestos out there. But if it speaks to you, I guess.
Because this one came out of UCLA from a lecturer, that makes it so much funnier than any of the others.
And if the court would
I think this person very strongly needs mental health help, and I seriously hope that he gets it, because I think it's a tragedy. You know, it looks like schizophrenia. He's at the right age for it. So I very much hope he's able to get some sort of treatment, and I hope he's able to get better. That's kind of what I hope for.
It's a very unbreaded response of you, Kurt. I like it. Thank you.
It's a note of compassion.
That's what I said.
Passion.
It's unbreaded. Nate, have you seen this thing?
No, I haven't. I'm sitting here looking up court reporters. Come to find, I'll show you how I'm down the fucking rabbit hole. The goddamn court reporter records the whole thing and then goes back and re-listens to it and types up the shit again. I'm like, what the hell? Why are you there typing right now? You could just listen to
what's
this
she
shit and
doing
type
now
it later.
then? Is she composing a mixtape then? Like, what's she doing?
Like they use specialized recording machines with microphones or audio devices so they can check over their transcripts later and make any corrections as necessary. So what the
I wonder if she's like making notations then or something.
I think she's
like,
doing the actual transcript, but it's like she can do it later because they're recording all this anyway. Wow.
Well, would you want to sit there and then sit there again? Oh my God, that'd be horrible.
Maybe she's moderating. We're kind of long.
Yeah, that's C Goody. What up, Goody? How you doing? Okay, so Nate, the UCLA guy, his name's Matthew Harris. He's a black guy, and he's a postdoctoral lecturer in the philosophy department for a year. And then he just recently posted an 800-page manifesto to their message board, and it is it is wild.
Oh yeah, with the N word all through it. I know you just
10,386 times.
Wow.
It's a lot of N words.
That's a lot of N words.
Oh, they just arrested him here in Colorado.
Yep.
Oh, what would they arrest him for?
Threats of violence. But the crazy thing is, from what I've read, there's not actually a legal threat, a legally cognizable threat in there, in my opinion. I mean, maybe I missed something, but it's just crazy. I mean, that's what it is to me. It's crazy.
I guess he has videos too, right? Online videos. So those must have been, I mean, they were terrifying enough that a federal judge has him held without bail.
Yeah. The videos are, the guy looks
without
like
bail too. Wow.
He needs a mental health hold is what he needs. Like Kurt's right. The guy's crazy, clearly. But man, it's an amazing document. He really hates Jews, but he really hates Italians. Oh, boy, he does not like Italians. His comment about Italian women was they were almost as ugly as Greeks and Arabs. It's like, oh my God, this guy is like, jeez. But yeah. The crazy thing is, though, like, when reading his thing, I was like, this reminds me of being in Writer's Workshop, frankly. Like you get some weird stuff in your writers' workshops in college, man.
Yep.
Yeah.
There's always that one woman writing about her child rape.
Dude, there was a guy in our class, and like every story he had was a guy raping someone else, like a cop raping someone. I'm like, bro, you got some issues to work out, man. These are all fiction workshops
Creative
that I
writing.
was in.
In
Creative
theory,
writing.
fiction.
Yeah.
But where else can you get an audience? The rest of the class has to listen to you read that stuff.
Oh yeah, and he had a real bad heavy breathing problem in general. He's a big guy, and he'd start reading this thing, and you're like, "Oh, you sound like you're into it. you need to chill out. Write a happy story about like elves or something." It was weird. Writers' workshop was fun. Oh my gosh.
Oh my God, they've been arguing the concept of relevancy for 40 minutes.
If the evidence is logically probative, it is relevant and admissible.
There is just nothing.
For not allowing the jury to consider it.
I mean, this should be a short trial. I mean, the facts are not complicated. I mean, they're disputed, of course, but you just put both versions in front of the jury and let the jury decide. It could be long. I mean, it wasn't a movie theater, so presumably there could be a ton of witnesses, right? Everybody in the theater could prospectively be a witness, which you wouldn't expect to be permitted. I mean, it would all be, they also have the same thing. It would all be cumulative.
Yeah.
But,
Well, the question is, how much does this judge care about that, right? Because Schrader didn't care about cumulative evidence at all, but Borowski, he handled cumulative evidence really, really well.
no, we're not doing that. No.
Which I appreciated personally.
Yeah,
I appreciate his willingness to actually make decisions, control his courtroom, and say this is shit is stopping. So,
but it's not as a high. It's
Chambers.
not as high profile, unfortunately, as I think that trial would have ran a lot differently if it wasn't as high profile.
No, this is a weird case. I remember maybe 4 years ago, I was writing about this case, and I was like, I can't believe it's been 4 years. It's like I began to suspect that maybe the prosecutor just wanted to delay this until this defendant died of old age. I mean, he's old and he's not in good health, and then they wouldn't have to put a ex-cop on trial. And now it's 4 years later, and they're only getting around to it. I mean, this happened 8 years ago, folks.
Wow.
it's a long time.
Yeah, it's a long
Yeah,
time
again,
ago.
when someone in the chat wasn't here earlier, was they didn't hear the movie that they were watching was Lone Survivor, the story of Marcus Luttrell, played by Mark Wahlberg, which is it's a good flick. I enjoyed it quite a bit, but I mean that was a long time ago when that movie came out. While they chat, can you give us a TLDR on how this could be self-defense? I haven't followed this one at all. Just a second.
Are they arguing self-defense here?
Yes.
Oh yeah,
Yeah.
that's the defense.
Like 99.9% of the times they argue self-defense is a loser.
I don't think the jury is going to buy self-defense. It seems unlikely, unless there's more, unless the particular words that were used, or there was more shoving, or some other facts.
Apparently,
that
there's
would-
some surveillance video inside the
that.
inside
Okay,
the
that's good
courtroom,
news.
and the judge saw that video during the self-defense immunity hearing. It was on the basis of that she denied immunity. That the defendant is claiming that Chad Olson was lunging at him over the chair, and she didn't see any of that in the video, so that's why she denied immunity in this case. I saw a clip of video from inside the theater years ago when this first happened, but it didn't really capture
grainy.
what I saw. Didn't capture the action very well, but maybe there's more.
Well, it's 8 years ago video surveillance technology.
Right, it'd be Super 8
when-
film.
When you think about how different, I mean, even 8 years ago, we had 1080 TVs, but we didn't have 1080 cameras like we do today. I mean, everything now is.
I mean, a lot of surveillance cameras still are pretty shitty, even today.
Yeah.
Even today.
Even the 10, that's one thing I was going to say. Even the 1080 surveillance cameras, they're doing like a 4 frame per second frame rate or whatever to save space. They condense and compress everything to hell. It's a mess. The popcorn was Orville's buttered hollow point. Okay, there's Let's see. Here we go.
So the arguments for self-defense, folks, are going to be that the defendant here is elderly, frail. The other guy is much younger, stronger. I think he was 24 years old, Chad Olson, maybe a bit older than that, but much younger, much fitter than the defendant. That he struck the defendant in the head with an object is the defense claim. So there was a blow, and the defendant had a reasonable perception. Doesn't have to be true or accurate, but the defendant had a reasonable perception of an imminent deadly force threat, a threat likely to cause death or serious bodily injury, which, you don't need a lot of blows to the head to cause serious bodily injury, especially to someone who's older. And if you're old enough, you become exceptionally vulnerable to injury by an attack of a younger person, which Florida statute recognizes because they escalate what would be a simple assault or battery to a felony if the victim is 65 years of age or older, which the defendant here was at the time.
No, do you think, because I know some states take into account like a blow to a head, that your head is going to put you in a different state of mind, it can make you a little foggy and everything. I'm not sure if Florida takes that into account, but I know here in New York they do take that into account.
Well, you can. I mean, it's just an argument
about
you
it
would
right
make.
now.
About extrapolating one person's emotions and
I believe.
prove another
Hold on.
person's emotions. So that's where the gap takes place.
This prosecutor is like listening to paint
Friday
dry.
report was Johnson versus State at 595 Southern 2nd, 132. Referring to.
So what's your feelings on this one, Andrew? Because Andrew's you're my go-to guy with when it comes to self-defense. You're pretty much my go-to guy. What do you feel?
I mean,
about
I think they have video of the event, so I'd love to see the video that the judge used in denying immunity in the first place. That would be interesting. I don't know. I mean, there's a version of the facts here that would support legal defense of self-defense, and there's a version that would not. So until I hear the evidence actually argued out in court, it's hard to know.
So to the chat who may be just joining us, this is not the actual jury selection. This is a motion or several pretrial motions that they were dealing with a few weeks ago, I believe. So far, literally, it has been completely a waste of time for an hour. And we've been talking over it there, but there's been nothing going on. They just started arguing, but the idea is we're waiting on jury selection to, I guess, occur. It sounds like they're not streaming the jury selection itself because it doesn't appear to be available. I'm checking it's Court TV's cameras in the courtroom, and there's just nothing particularly happening with that right now. So,
I mean, a complicating factor here, of course, is that this didn't have to happen, right? These were two guys having a dispute in a movie theater. At one point, the defendant leaves his seat to go complain to management about Chad Olson. Folks, if you've left your seat to go to complain to management about someone else in a theater, go home. Don't go back to your seat. I mean, just go home, get your money back and go home. Come back and watch the movie some other time. But when you go back to your seat and now you're going back to a point of confrontation where things could escalate, it begins to look a lot less like self-defense.
Yeah. I don't know about that. I don't know that you should necessarily let some jerkwad get you out of a place that you wanted to be to enjoy yourself.
Well, it shouldn't be a law. You don't have to. It would be the prudent thing to do. Or you could end up here.
I suppose there's that.
yeah, well, and especially if you, I don't know, the one thing that always stuck with me while with the whole while carrying, don't ever put yourself into a situation of confrontation ever. Like,
That's for
at
damn
all.
sure.
And in this case, I mean, the management, he went to complain to management. They didn't care. He came back and then he made it an issue. And I'm not saying that he provoked legally or anything like that, or that he defeats his justification, because maybe he does, maybe he doesn't. I don't know. But he has, similar to the attorney, right, in the Edgecombe case. Like, why are you following this guy who just was comfortable riding up on his bike and punching you in the face through the window? That's not normal behavior. And if you follow someone like that, you may end up dead, whether they're justified or not, you don't really care when you're dead in the ground.
Or
And
you
so-
may have to act in perfectly lawful self-defense. I mean, let's imagine this was perfectly lawful self-defense. He still had to kill somebody.
Yeah.
That's not a good outcome.
Yep. Oh man. Can I get this pulled up over here? Hold on.
I'm like so infatuated with the damn court reporter. Like even the way she's hitting the keyboard, it's like she's typing like.
Next
don't-
week she'll be on The View.
Don't simp, Nate. Don't simp. Here, hold on. I'm gonna bring up this video. This has some of the footage from in the movie theater.
So that's the wife.
Calling Reeves' demeanor that night.
I see you've put your phone away now that I went to get management. I remember
Wife is cute.
feeling this should have been over. He's got what he wanted. Why is he still doing the haha, you did what I told you, I won? That's kind of how it felt.
Okay, so here's the video. So the theater's actually
Yeah.
relatively empty.
Yeah, there's nobody there.
This is the video I've seen. And they're all at the far right edge of the video. It's very difficult. And you can only see the defendant, really.
Well, look, the whole purpose of movie theater video is just to catch someone getting a hand job in their popcorn bag.
What the hell?
That's
So
when
that
the
was
shot was
it.
fired. That was debris from the ceiling.
I mean, the guy's hand does come at him with a quickness.
Yeah.
I can't see anything.
He takes his
That's a blow to-
popcorn.
to the head
Is
there.
slowed down there. No, that was him grabbing the popcorn and throwing
was
it
it?
at him. Yeah.
Oh, okay. Yeah, you're right.
So here, he's gonna grab.
And there's the popcorn bin.
Oh.
Let's see.
Well, good work, Court TV.
Yeah. So. Yeah.
And she was there with them, huh? So she was in.
Yeah.
Yeah.
What is all this shit that's in the frame?
That
That's
was
just
debris.
debris from the ceiling.
Caused by the shot?
Yeah.
Did he hit the ceiling?
No, I don't think he hit the ceiling. I think just
The sound of it,
Yeah.
I guess.
Okay.
This is a very.
That doesn't make any sense, though. Movie theaters are pretty loud. Why is there all this random shit falling off the ceiling? I'm still
They're not
confused.
gun loud.
Fair point.
Guns are. I mean, most of us shoot guns when we wear hearing protection these days, so we never
Yeah.
really hear an actual gunshot. But if you ever go to the range and you forget to put your hearing protection on and fire
you
that
know.
gun,
Fast.
Oh, you know. You know.
So that's okay. Get that weirdo off there. But here, I'll pull the court audio back
More or
up.
less probable. And so we don't have to do the high jump here. We just have to step up to the curb. And clearly, that's what this tendency is eliciting. Now, I know that Mr. Martin talked about apples and oranges, and that's interesting because all these cases that he presented to the court have no factual basis that's similar to what we're looking at in this particular.
Andrew, what's your concealed carry of choice?
We do cite
I just got a new pistol actually for Christmas. My wife bought me one, so I'm currently carrying a SIG 365 XL
That's a good choice.
Nice.
with the Romeo whatever red dot on it.
That's a good choice.
They were scared, nervous, shocked, and terrified during a bank robbery. As courts routinely
I did get the Wilson Combat grip module for it. It's got a slightly different shape than the more of a 1911 type grip shape than the SIG OEM grip module. And I carried a 1911 and shot it competitively for 20-25 years. So that's a personal preference.
I was going to ask you guys. So the city has not responded to my request for a concealed carry. For one, and the reason is because I refuse to get the affidavits from everyone else because the way it works here in the city for you guys don't know, I got to get an affidavit from every adult living in any of my properties where the firearm is going to be, saying that they're okay with me having a concealed carry firearm, not even a concealed carry firearm. So I refuse to do that. But now they're refusing to process my application until I do that. So now it's kind of like, well, what do I do? Do I sue, saying that I shouldn't get this, or should So it's like I'm like in this whole thing because I was putting it forward, so I could sue. So I don't know. It's a weird quandary.
And there aren't just federal cases. Here's a state case.
Because I need.
So they're arguing right now. They're arguing right now over his ability to testify to his own fear and to the intimidation of the deceased. It seems.
That seems odd. Why wouldn't he be able to testify to his subjective state of mind?
I don't know, but that's the case law this guy's citing right now is that they are.
There's an aggravated assault. It's a second DCA case, 154 Senator 1164. I think I said that. I did say second DCA 2015.
Yeah, so I mean, it'll be interesting when the defense argues that this was a felony assault, a felony battery based on that statute that applies to people 65 years of age or over. Because if I were the state, I would argue that that's really a sentencing enhancement statute. It's not intended to really define the nature of the underlying conduct.
Maybe they want the wife of the old man to testify rather than him testifying.
Oh.
Yeah, I mean, she can't testify to his subjective state. She can only testify to what she observed.
Right.
Yeah. That's how you'd get it in, though. He was shaky, he was sweaty, he was nervous. Yeah.
It's the wife.
But she would only be able to testify to things that she observed, not to.
Yeah. If he's a big, strong guy, he's got a hunch over. It doesn't mean that if a child comes in, we gotta make the child look like a grown-up. I mean, those are human emotional things, and it's not.
I mean, you could ask her how he seemed. I mean, you're his wife, so presumably know him reasonably well. So yeah, he seemed very afraid. He seemed very scared.
But that's a good way to get it in without having the defendant have to testify to get it in. You want to get in that he was afraid and all that, and the way to do that if you have the wife or somebody there who can testify to it.
Right. I mean, you can make reasonable inferences from what you observe, right? That's what we saw with Richie McGinnis in the Rittenhouse case, right? Well, you couldn't read his mind. How did you know that Rosenbaum was? Well, he said "fuck you" and grabbed for the gun.
Yeah, that would have made it pretty easy for us to know.
That's pretty good. That was a good answer. That was a good answer.
Don't get me wrong with that trial. I'm surprised this guy hasn't been brought up on any type of charges, though. He straight up lying to the court, like the violation of constitutional rights. It's like, what's going on up there in Wisconsin? They don't, can lawyers just do anything now without any consequences?
A rumor has it Binger's out.
You have a group of individuals.
Is that right?
Yep.
I know he lost the next trial, right? Because the jury mostly didn't believe him after written out.
So he lost the next trial. Rumor has it. These are courtroom rumors, but rumor has it that Schrader basically said, "You will not appear in my courtroom anymore" to him. And then the most recent rumor is that he's actually taken a new job and won't even be prosecuting Zeminski.
Inconsistent with the fact that Bryant, where all of those individuals observed the same incident. So I don't believe
Couldn't happen to a nicer guy.
Bryant is on point. The other case is cited by the defense. You talk about a victim of a robbery where one of the elements is in a robbery is that the taking was by force, and have the victim say, yeah, during robbery, which they were not charged, against the defendant who was charged with robbery, they're providing elements that the jury considered in order to convict the defendant. Vivian Reeves is not providing evidence against her husband, which the jury can use to convict him. So you see the difference. I mean, that's the difference. And when you can say, well, I was afraid or I was not.
So what they're trying to prevent her from testifying to her own fear because they believe that it will prejudice the jury to say that her husband would then be afraid because of her fear.
Okay, that seems kind of reasonable.
If you're trying to prove what a reasonable person would have been afraid, then other people at that moment, given their present sense, saying I was afraid because of the way this person was acting, it should be admissible, right? It's like if you were there.
Yeah, should be. I mean, I know why the state's trying to get it out, though. like a 70-year-old lady up there going, I'm so scared for my husband. You know, this brute yelling at my husband, right? Hard to get mad at Nana or whatever.
My call, by the way, was trying to get internet installed at my new apartment that I'm moving into, which is proving to be challenging. So
good luck, brother.
My quest continues.
Oh, everybody also remember, change your router every year. I just found out. I had my router for 5 years, and the cable company's like, you're supposed to change it every year. I'm like, I didn't know that shit. I don't know who knew that. I didn't know that.
Who says to change your router every year?
So my internet's been.
You mean your modem?
My modem. I should say my internet. My modem and router. They said you're supposed to change it every year. So they spoke to me of that.
I'm going to.
That's bullshit, man. That's total bullshit.
They told me I should bring it every year to upload it to upgrade it.
No,
you should bring it every year to upgrade it. I was like, okay, well, I'm taking this one, and I've had it for 5. So,
well, if you're using the router that they provide, which I would never recommend.
Several cases, most of them.
Like because Spectrum, when you get the gigabyte internet, they demand that you use their router, and they won't even let me give it back. I'm like, I'm not going to use your stupid router. It's not. My house is too spread out for that. It won't work. And they're like, no, you have to keep it though. It's like, okay, that's dumb. But if I was using theirs, yeah, because they do updates and stuff, and they don't always tell you when they do it.
To be legally relevant, evidence must pass.
On the modem, it would make more sense to me than the router, though.
Bearing on a fact to be proved.
All right, it's coming up on 10 o'clock. I'm going to try to actually get some work done at my day job.
Oh yeah, I got.
Have fun with that.
Yeah, right. Talk to you guys soon.
All right,
see you, buddy.
Later, bro.
If she was scared. And because that does go to the question of whether or not Mr. Reeves was scared. And I understand Mr. Martin's argument against that. And certainly that is what the jury will ultimately have to do, is decide Mr. Reeves' state of mind and if he was reasonable. But I can't help but think if Mrs. Reeves said she was not scared, that the state would find that to be very relevant.
Of course.
Yeah.
So, I find it to tend to prove or disprove of material element. And
so the question of whether evidence is admissible hinges primarily on whether its probative value outweighs any prejudicial impact. Probative value is just something that makes a fact more or less likely to be true.
And so, tendency to make the fact more or less probable, certainly.
There it is.
Like I said, she said,
stop giving the judge notes.
That would tend to make Mr. Reeves' reasonable argument less probable. And if she said she was scared, more probable. I think it fits squarely within the case law.
It seems an odd argument by the state. I mean,
you throw it out,
especially in a self-defense case where the totality of the circumstances is relevant to the self-defense claim.
Yeah.
They make an argument, just hoping the judge throws it out. Pray, but it was a dumb breach anyway. Obviously, it's going to come in.
Is that what her inconsistencies were so de minimis that it really didn't matter. So if it doesn't matter, then
there's my girl typing it up.
She was scared at the time of her.
We need more men.
So I'm asking the court.
Where's Jordan Peterson when we need him? Where are all the men court reporters at?
I'm not going to. I put it in my motion, but I wasn't.
Wasn't what?
On page 6, that if the court rules that they can't get out of the fact that she was scared at the time of her law enforcement interview, then I would waive that type of cross-examination. I have the case law of Bell, which I know it's not even dicta, it's a concurring judge indicating that that type of anticipatory rehabilitation shouldn't be allowed if other party waives, crossing on it. So, but I mean, if the court's going to allow, that she was scared of death at that time, at the time of the incident, then.
So for folks who don't know what dicta is, when we talk about appellate court decisions having precedential value, having authority over subordinate courts, anytime there's an appellate court decision, there'll be some key issue or key issues being decided by the court. But they may also chatter in their opinion about other stuff that's not really relevant to the actual issues being decided. And that chatter, that commentary that's not relevant to the key issues is what's called dicta. And it should not be, it's essentially deemed not to have precedential value because that's not actually what the court was deciding. And the court may have just made an off-the-cuff comment or not really considered all the issues from every perspective, which we presume they do when they are deciding a key issue. So if it's
like
dicta,
yelling fire in a crowded theater is dicta, by the way. That whole
right? Yep.
I mean, they were so minor that I didn't care.
shockingly, there's a bunch of times when you can yell fire in a crowded theater.
Like when there's a fire, that would be a good time.
Or you're in a play where you're delivering a line.
Inconsistencies. There's often I might be in the minority, but whether a object was beige or brown, typically doesn't need to be beaten to death.
So it sounds like there's some
I'm sorry, the whole beige versus
beige or
brown,
brown and then beaten to death. That's
What the
not
hell?
not a good look, Florida.
What I did, anticipation of Mr. Martin maybe.
It seems like there's some inconsistency between what her testimony is anticipated to be and maybe her statements to police at the time about her level of fear
I might choose to do that.
or apprehension.
So that he had been up and said, well, he said it's blue, he said it's brown. The whole point is, saying, well, getting into her state of mind. At the time she gave various statements, I think that's certainly reasonable. That's like asking the victim of a sexual assault. Well, you didn't tell him you had gloves on that day. Is there a reason for I was scared of whatever? So I don't think that's improper. And I don't know that I know that I wouldn't take any offer to Martin to weigh that sort of cross examine in order for me to not be able to talk. So I don't know if it's much of an issue.
This guy's old school. He stands up when he talks to the court.
We're going to trial in 2 weeks, so whatever you rule, we're rolling.
Did he just say they're going to trial in 2 weeks?
Yeah, this was 2 weeks ago.
Oh, right. Okay. Sorry.
I don't
Still waiting for an up-to-date.
I don't really.
I need to.
find those to be significant inconsistencies.
So this prosecutor prosecutes in front of this judge a lot. That's why he's sitting down and he's able to talk with the defense attorney.
Well,
He's
he
standing
asked
up.
permission.
Well, that's why I pointed out.
Oh, he asked permission.
She was scared when I was taking
Yeah,
the
because
I mean, that's fine.
he's got some issue where his eyesight is impacted by how tall he's or how high he was standing, or maybe he was sick or something recently. Don't know. Or he's just old.
That's the kind of person she is.
All right, so what is it that you're asking me to do?
Well, Judge, I just brought that to your attention. That's why I said it's not, the case is not controlling, it's not even vacant. It's just a concurring judge saying, hey, if I was the judge in this one, if they waived it, I wouldn't do it. So.
Then why would you bring that?
Denied the motion, we can live with it. I have a form motion here that you can sign, and we can move on to the next.
It sounds like he's arguing that concurring opinion agrees with his point.
Well, that's because that issue.
But a concurring opinion is not
You're willing to
precedent.
waive-
I'm not waiving it now.
Okay,
You denied it.
okay. So I'm there, that's what I just want to clarify. So, you can ask and you can.
He wanted to say, hey, if you say, the court says that we can't bring out that she was scared, then I'll waive.
Okay, I got you.
But since the
Okay,
court
but
said, hey,
I
she's scared,
agree, said you can. Okay.
because that way then I-
Homeboy who keeps coughing in the microphone needs to be uppercut into orbit. He's killing me.
Okay.
So I can do that.
Gotcha.
Like, oh my
Just as
God.
you would do if you were in trouble.
Okay. Got it.
That's all I can find.
All right, let's
You
take
have-
a 10-minute recess. We've been going an hour and a half, and take a 10 minutes.
Oh my gosh. In an hour and a half, they have done nothing. They have done nothing. They seriously have resolved the issue of whether or not the wife will be allowed to testify to her own subjective fear. And that is all they have done in an hour and a half. Oh my God.
Two things though. Why wasn't this done on the papers? Because usually these motions are just, here's what I want to do, blah, blah, blah. It's all done. To have them sitting up here arguing it seems to be.
Yeah, well, it sounds like they had submitted a bunch of papers, and judge just said,
I'm not reading all this.
and they were going to have the hearing on all the issues, all the pending issues before court. But I mean, that's such a waste. And that's such a long shot argument, because of course someone else is like, she can't testify. My husband was very afraid at that moment. She can't do that. But it's always going to be relevant in a case like this, where you need to, as you guys were saying before, where one of the elements is the objective reasonableness, the objectively reasonable fear. Well, one way to establish objectively reasonable fear is to show that other people in the area were afraid or would have been afraid. They were concerned. And we saw it with Rittenhouse. That was the testimony they elicited from Gage Groskowitz, was that when Anthony Huber was hitting Kyle Rittenhouse in the head with a skateboard, Gage was concerned for Kyle. He said, yeah, that looked bad as a medic. So, not necessarily his brightest moment for his perspective, but credit to him for at least being honest about that moment, right? Like that. Yeah. But of course it's relevant. And I love what the judge did there. Like, yeah, if she would have said she was not afraid, the state would be begging to have that testimony included. Of course they would. Yeah, we're going to keep that in. So, but that's
this goes back to your original point about the probative versus prejudicial. Even though obviously it's the 403 exception, right? Here the probative value is obviously, how people felt in that moment, but then the prejudicial value is his wife is going to be essentially saying that she was afraid. So
yeah, and the prejudicial, they were trying to add in extra prejudicial value due to the circumstances of the wife is elderly and the husband is a former police chief. He's going to have probably a confident demeanor. He's going to be old, but I don't think he's particularly frail. He's still a substantial individual. So then they're going to instead have a diminutive old woman go up there and talk about her fear. And they're saying that circumstance itself adds to the prejudicial value. But, the fact that she happened to be an old woman there that doesn't make much difference, frankly. What are these guys yakking? Oh, it's muted.
One thing I do like is that you get to see it real time for if anybody goes to law school in the chat. One great thing is you see they went through first. You have to go through the relevancy. Is it relevant? Then there's a presidential. Then there's the presidential. Then there's the prejudicial value. Then okay, we're going to let it in because the probative value outweighs the prejudicial effect. So it was a long way through it, but it seems like they touched on everything.
Normally, it doesn't take this much talking. Yeah. I mean, Borkowski would have settled this in 3 seconds.
Listen, we've been sitting here listening to these arguments for days, weeks, months.
It's done, I tell you.
It's done. I ruled on it. It's over. You're going to move on, counsel, right now. Right now.
Chambers.
I wish that guy was a judge in just about every trial that we watch, because he was a riot. I don't know that I'd want to be in front of him as a defense attorney. But
well, isn't he coaching? He's coaching Packer football now, isn't he?
Yeah, he should be. Special teams, you're done. You're done. Yeah. I've watched you kick field goals all day. You haven't made a single one. Get out. You're fired. Oh, man.
Well, I'll give the defense here one thing is they managed to drag this out for 8 years. I mean, for if your client's this old delaying the trial for 8 years, that's a win right there.
Yeah, I think he's been
That's
on an
true.
ankle monitor, but that's better than prison. And yeah, the real trick will be if they drug it out for 8 years and then they argue that he's elderly and infirm and he should just be, at sentencing, that he should just be, what's the point of putting this guy in prison? It's not going to do any good. I mean, that'd be the argument. Well, we'll house arrest him till he dies in hospice that he's been in for 3 of the last 8 years already. I made that last part up, by the way, but that'd be the big reveal. The big reveal in court. Yeah, he's actually got terminal cancer and he's been on hospice for the past 3 years. Putting him in jail would be a gross injustice, Your Honor.
I want to see how this thing plays, because this looks like it's going to be a very interesting case. A youthful young man gets shot by this elderly person. The wife is there, so she's talking about she's scared. It's
With a young child.
And she was off. Yeah, this is going to be crazy.
I mean, the child wasn't present, but yeah, they had a little girl at the time who's now 8 years older.
Why are you watching The Recess? This isn't live. I was giving us a chance to talk without the din of the background noise. Nothing's going on in the actual jury selection is not being aired. Court TV said their cameras would be there, and I'm sure they are, but they're just not broadcasting anything. So for whatever reason, so we're just kind of stuck waiting for whatever happens with.
Yeah, folks, I'm sure he did not want to go to trial. I mean, the delay here is in his favor. The longer he could delay, the better. And you have a constitutional right to a speedy trial, but you can waive that. You don't have to press that claim. And it would be different if he was 20 years old or 30 years old and you put your life on hold basically for 8 years, right? You don't get married, you don't get a degree, you don't do all the normal things because you don't know if you're going to go to jail for the rest of your life. So you may have a more powerful incentive to get that case over with sooner rather than later if you're younger and want to get on with your life. But if you're 70 plus years old and you can put off your second degree murder trial for 8 years, and that's a win. I mean, put it off long enough and you'll never have to go to trial.
Yeah. This is what we were talking about earlier. Jim Bobbington says the girl in the Cody Wilson case confessed her prostitution to a social worker / therapist. Knowing the girl was underage and her most recent client, it was the therapist who encouraged the girl to go to the police. So there you go.
But the therapist would be a mandatory reporter, though, in that situation. Yeah, I know in New York they would be. In New York, for sure. If an underage person says they had sex with someone, you're as a mandatory reporter, you got to report that.
Yeah. Usually if you're some sort of counselor working with kids, although I guess it depends on what level of person, because there should be with attorneys, right? For us to have any sort of duty, and it's really questionable what level of duty we have, even if we think violence is imminent. It's really questionable about how much they can compel an attorney to break privilege on it. But it finding out that there was past abuse would not be sufficient for a breach of attorney-client privilege, right? Like,
yeah, correct.
We could not do that. So even if someone comes into our office and says that they did horrible things to some specific minor a year ago, but that minor lives in another country now, and there's no reasonable chance that there's any imminent danger, and we were to report that, we would actually be in trouble. And a lot of times attorneys cannot be mandated reporters for that very reason. So I don't know if there's some level of protection for therapists in the same way, because if she was talking about a past thing, especially with the whole prostitution thing, I mean, it's that weird argument where it's a statutory danger that is imputed upon the child rather than actual like danger in the, you know what I mean?
Yeah. Well, I'm thinking, I know here there's a state statute that certain teachers, therapists, counselors, so forth, are mandatory reporters when it comes to if they're working with children or anybody underage, right? So they have to report abuse, this stuff, blah, blah, blah. But then I think lawyers, we like, I'm not a mandatory reporter, even if I was working with the kids. So you're right. I think it's different in that sense. But if you're a doctor and you have a child who presents maybe some type of sexually transmitted disease, I'm assuming that doctors has to report that to authorities because they're a mandatory reporter in that sense. So I'm not sure, but first how old this person was. But if she's underage and is having sex with adults, which would be technically statutory rape, I'm assuming, if other than the lawyers, I'm assuming that whoever she's telling that to would be mandated by state law to report that.
Yeah, could be. It seems typically I would think yes. I just didn't know if there was some level of relationship that would trump it in the way that attorney-client privilege might trump it. So
there is a privilege for social workers, though, right? That was, I forget that latest Supreme Court case with the privilege. Social workers and counselors had the privilege that they recently fugazied in there some way.
I hadn't heard.
Like there's a medical privilege for doctor patient, penitent priest. So I have to look it up.
Keldrig says school band concerts have better audio than this. Yeah, the court audio in this one. And remember, this isn't like whoever was recording this. My man's over here doing stretches. Whoever's recording this is this is probably not the official court TV reporting. Actually, it's some local news station, 10 Tampa Bay, which is recording this. They're probably not setting this up to do, their higher quality stuff. So it'll be interesting. Ovid says years and years of court writing, and this lady's manifesto puts Matthew Harris to shame. More bingers than all of 4chan. No. SSJ2 Rich says, I know you don't do worldwide cases or news. Well, sometimes news, but would love to hear your take on NSO Pegasus news coming from Israel, which in my opinion, is already in use at USA. Basically removed our prime minister using illegal use of hacking. Well, good. Here's my perspective on any international law case that involves fundamental right, what I consider to be fundamental rights, like the fundamental right to not have your government snoop on what you're doing constantly. Good. Israel has a lot of hallmarks of of tyrannical paranoia state action. It's, I guess, how I can put it.
And to be fair, though,
they have good reason.
Yeah, they
have good reason for it, right? I am not denying it, but that's in my envision of society, and this is their country to build. They can do whatever they want, but in my vision of society, I prefer the risk to the government intrusion. In my nice, coming from my nice, cushy American, very low risk lifestyle that is not surrounded by like 9 countries that all want to murder everybody in my country. So there are differences there, but that's where I go.
Isn't it? But that's always a trade-off, right? Security for freedom, security for freedom.
Yep. And Americans believe in the principle that I shouldn't say Americans believe that. America was founded on the idea that more freedom, less state security, but that also gives you the freedom to impose your own security as well. That's the other trade-off. We were supposed to be an armed society, and the initial army came from the populace, armed themselves. Not that they went to a barrack. I mean, they could go to a barracks and get a gun if they were not otherwise armed, but they were expected to bring their own gun if they were of means.
Yeah.
And so that has always been a difference in the U.S. to every other country, is that there was an expectation that you would do this. So it's of course in Israel they have mandatory military service and stuff like that. So.
Well, also a lot of those countries back then, when our country was founded, they had a monopoly on state-sponsored violence. So, for instance, you couldn't have weapons if you were in England or a lot of these monarchies. So that was one of the reasons why we had the Second Amendment. It was so the state doesn't have the monopoly on violence, right? And you could protect yourself even from the state. because the Second Amendment was also to protect you from the state itself if the state became tyrannical. So,
Right.
But we can't talk about that now. We'll be labeled extremists. We say that.
Yes.
But that's true though. Just read some of the stuff from back then. They were afraid the state would become tyrannical.
Yeah, and it's funny that that's even controversial because they literally fought. I mean, they fought a war over state overreach, and the state overreach was a 2% tax on tea. I mean, it was phenomenally insignificant to what we deal with today, right? Like, imagine they everybody smoking cigarettes right now is like, wait, what? A 2% tax on tea? Oh my God, please give me a 2% tax on cigarettes. Good Lord. But that's what it was. It was that equivalent. It was that being imposed by a foreign government. Well, what they considered to be a foreign occupying government from overseas, making those things and them not having the ability to even have a say in that discussion. So kind of wild. True and honest shop at a bad pressure, bad calf care says, what kind of router do you recommend for a spread out household? I have the Orbi. I think it is. Is it Orbi? It's a really, it was fairly pricey mesh network setup. I think it's Orbi. Hold on. I'll see if the Orbi. Orbi, is this the one? Yeah. It's the Orbi professional top end one that they had at the time. It was a lot, but it's got it's a mesh Wi-Fi setup. So my house is kind of spread out and there are 2 levels and we have tall ceilings. So all of that meant that other routers just did not reach all parts of the house. And from where our internet is, especially. So that's what we got. And it works really, really well.
I got 5 minutes to get on this client call. Listen, brother, take care. I will definitely be back to finish watching this trial because I find it to be fascinating of this old man. I think he's got a shot. From everything that I've been hearing today, it looks like he got a shot, but we'll see. Bad camera angles, scary old man, scary wife.
Yeah,
looks
it'll
like
be
down the barrel for not guilty.
It'll be interesting. I mean, we'll see. But anyway, yeah, go do your call and you're welcome back anytime, brother.
Later. Take care, Andrew.
Take care, Nate.
And then there were 2. This
The
has
defense
been
is chatting up the court reporter here.
This has been significantly longer than 10 minutes. I just want to point that out. And it will go on for another couple. Judge comes back here. Let's skip ahead. Here we go.
There's 4 other motions to deal with relevance.
Oh, there's 4 other motions.
Exactly. There's no reason to read it again and go through it again. The only thing I'll do with each one, I'll put on the record that I'll rely on the case law that I previously provided to the court.
Okay.
So I think we can streamline these next 4 to get right down to the facts, the case law. And so that's what we'd like to do if that's okay.
Fantastic.
The next one is the state's motion ad limine to exclude the testimony that in December of 2014, the defendant fell and broke his hip.
All right.
You have that one up there?
I just put that.
No, I can provide it to you.
Okay, thanks.
Did you ever do exhibit?
You want to give me the it?
Yes, you doesn't have it.
Yeah, I've got it. I can do it. And now I've got the defendant's response. And I've had it up.
Okay, so that's earlier the year of the shooting, or maybe later the year of the shooting, he broke his hip. If it's prior to the shooting, I think it's relevant.
This file, even in JAWS, takes a long time to load it up.
I have a copy of the exhibit for the court.
The exhibit being the transcript?
Yes. Well, it's probably not going to take that long.
Okay. Do you need it to argue?
Well,
Okay. We'll take it.
Yeah, go ahead, proceed.
Uh-huh.
Judge, in this particular motion limited, you tried to call during the hearing, Jennifer Shaw was asked if she was aware that her father had fallen, and at that point the state objected. I provide you the transcript from that hearing where we argued whether or not something that occurred in December 2014 when the offense was in January of 2014, to what extent that was relevant. And if the court were to take a moment to refresh the court's memory.
Yeah, that's a tough sell for me.
But the bottom line is, after argument from counsel, you indicated that, I think your words were, you got it, I don't need to hear stuff, but it was afterwards, and you sustained my objection. I'm asking you to do the same thing.
That's right. It was after this, as I recall, after the shooting in January 13th, that he broke his hip. Is that correct?
It is.
Okay. Yeah, I still feel the same way. You know, I get it, the testimony of Dr. Bedore about self-efficacy, and I know that's where you think the relevancy is, but,
Judge, if I may just make some argument, because we've got some cases that are on point.
okay.
That the court, I think.
Let's see if that's a true statement.
Or dictate.
This case is somewhat unique because of the fact that the jury has to, number one, stand in the shoes of Mr. Reeves. In other words, it's not Rick Escobar determining for Rick Escobar whether it was reasonable to pull that gun and fire that gun. If I was a juror, I've got to stand in the shoes of Mr. Reeves. I've got to stand in the shoes of a 71-year-old. So I've got to figure that into my equation. I've got to stand in the shoes of Mr. Reeves as a 27-year decorated veteran that started the first SWAT team for the Tampa Police Department and all of the courses that he took on use of force. I've got to stand in the shoes of Mr. Reeves being 71 years old.
That's all true, but there's a long way between this and stand in the shoes of Mr. Reeves, who 11 months later is going to fall and break his hip.
Remember, Dr. Foley did say these happened just now. They were long-standing degenerative changes to the skeletal systems. I've got to stand in the shoes of Mr. Reeves as the head of security.
So he's arguing
Busch Gardens, dealing with similar places.
broken down old man.
Busch Gardens is a place where individuals come and entertain themselves in that facility. This is,
I've been to Busch Gardens. I like it. Fun place.
Theater, you have masses going to
Been there as well.
Entertaining themselves.
My parents get season tickets. Whenever we go down, they take the kids.
Of entertainment. And so because of that, it is very, very relevant and very probative to be able to prove that Mr. Reeves' perception of vulnerability, that his perception of vulnerability was accurate. And if you look at the cases that we cited, we did a pretty robust response on this particular issue because it is so important, frankly, to the court. And
I mean, in 8 years, you should have reviewed every potential relevant appellate court decision from all 50 states.
First of all, I think Mr. Michael was correct when he argued in his motion that the issue of relevancy is really a very low threshold. In other words, we don't have to meet a high threshold in order to be able to introduce evidence in a criminal case, especially a defense case. Because as the court knows, the Supreme Court of the United States has bent over backwards to say, hey, listen, if someone is charged with a crime, you've got to do whatever you can to allow that defendant to actually prove his defense in that.
I mean, I like his argument.
And so when you look at
I don't know that's going to work.
This Tenard case, which is a U.S. Supreme Court case, and I'd ask the court to read that case because it is a very robust case dealing with this low bar and what happens in these particular cases and what we should be looking at. But most importantly, on page 5 of my memorandum, you will see that certainly there is a section at the very bottom of page 5 talking about subsequent events, because for some reason, there's this general perception out there that if if an event happened after the accusation, that you then can't use that event because it's not relevant. In these cases, the cases that I've cited,
there's a presumption.
one being Ruiz, which is located at 39 Fed Sup, 3rd 1264.
This is the defense.
As Mac versus United States versus Mac, which is at 643 Fed 3rd 119, all stand for the proposition that no, just because it happened after doesn't necessarily mean that it is not relevant to an issue before the court. And so you can see that in the Ruiz case, there were subsequent violations of the liquor laws. And the government sought to introduce those particular subsequent violations in order to show the intent of the individual that was being accused. And the court said, absolutely, because it is relevant to that particular issue. Despite the fact that it happened after, it is still relevant to that particular issue, considering obviously that low bar. Likewise, Your Honor, in United States versus Mac, which is at the very bottom of that, again, the government was prosecuting someone for drug sales. And in the fact that these sales occurred after the fact, was relevant and admissible to show the state of mind, that being the intent of the defendant in the prior sale. And so just because this particular injury occurred after the fact does not make this.
Did he have an intent to break his hip
Talk about why.
earlier?
Yeah, but I guess the argument is going to be, one of the arguments they'll want to make in terms of the subjective reasonableness of the conduct, the subjective reasonable perception of a deadly force threat is his exceptional vulnerability due to his age.
Right.
If I was to,
And we know he was exceptionally vulnerable because look, even if he just fell over, his hip would break. We know that because it happened.
It's just a matter.
Right.
But the minute that Dino becomes 65, if I do that same act,
But did he know that if he fell over, his hip would break?
because the law in Florida has recognized.
Right now they're talking about that felony statute for age of victim.
And so remember, throughout this entire defense, we're trying to determine and trying to prove, myself and Mr. Michaels as part of the defense, that it was Mr. Reeves's reasonable belief. We've got to be able to prove that. We've got to be able to prove that, hey, look, yeah, it was reasonable for him to perceive his vulnerability. And how do we do that? We do that because of two things. We're going to introduce Dr. Foley, who Dr. Foley will testify to the fact that, yes, the fact that he got his broken hip is probative, okay, of the fact that he had these degenerative changes going on in his body. Number two, we're going to show the jury exactly how he fell.
Man, I feel like I've got degenerative changes going in my body.
Doing anything out of the ordinary, just merely walking in his back patio, falling and breaking his hip. I think the court would recognize that someone in their 50s, if they fall on a patio, are probably not going to break their hip. But the minute that you become Mr. Reeves's age with those types of changes to their skeletal system, then it becomes more likely. And the word likely is what we're trying to prove. Yes, it has a tendency to prove that, in fact, Mr. Reeves's perception of his vulnerability was accurate. And that's what the jury has to do. If we're not allowed to do that, then we're stripping Mr. Reeves of this very vital defense. And that's the jury instruction. It even tells you in the jury instruction, Your Honor, and I don't have it here with me, but it tells you in the jury instruction that the jury should consider the physical capabilities of both the defendant and the victim. That is the jury instructions. And so if the jury instructions is telling you that, and this deals with an individual that his physical capabilities were much more vulnerable because of his age and his deteriorating condition, how can it not be relevant? How can it not be probative? I'm sure Mr. Martin doesn't want that because it is so powerful for us. But to take it away from us based upon case law that's directly on point, these cases are directly on point in that these were subsequent acts. And in every motion that we responded here, that was our goal, was to give this court cases that have done what we're asking this court to do. so that this court can be on solid ground to say, okay, if that court has found that that is in fact relevant and it was a subsequent act, and it has a tendency to prove the fact that Mr. Reeves was right, that he was vulnerable, it's crucial to our defense.
Thank you. Mr. Martin?
Judge, I refer the court back to the standard jury instruction 3.6 right now. When we're talking about self-defense.
Guy sounds like Mitch McConnell.
Puts forth a claim of self-defense. What is relevant is what that individual knew at that time. That is what is judged. Now, we're going to have some arguments and issues later on with Dr. Foley, because remember Dr. Foley's testimony was, I didn't examine Mr. Reeves. He also indicated people have different thresholds of things. He doesn't even know if Mr. Reeves was aware of the changes in the bones incident was going on, because it just happens under the skin and you don't know about it. So when we're talking about the self-defense,
And this will be a more compelling argument, the defense argument in Florida, right? Where it's such an elderly population, and everybody who's older knows, you know, you don't bounce like you did when you were 25. Everybody gets up with aches and pains. Everyone is increasingly debilitated to some degree simply as a result of age, and they don't necessarily need to know that they have osteoporosis or they're vulnerable to a hip break. They just know they're frailer.
Yeah.
Or ostracizing, whatever that word is, getting the bones changing the density. If you're not aware of it, then how can it affect your decision-making process? Now, Mr. Escobar says, well, because these cases are very robust, these things happen afterwards, therefore they're relevant. Well, what cases did he cite? He cited Williams Rule cases, where we talk about state of mind and intent, where bad acts after whatever the crime charged was to prove the individual's state of mind at the time of the crime charge.
Which is a horrific thing, in my opinion.
About that at all when we're talking about.
Look, well, 2 months after you sold drugs, so therefore you intended to sell drugs the first time automatically.
As opposed to a self-defense claim where the relevancy is what he knew at the time. So
It's like post-dated propensity evidence.
This guy just argued, like just now argued that in a criminal case where there's a defendant, what they intended at the time is provable by what they intended at a later time, but not applicable in a self-defense case. See, he's losing me on this one.
About he knew all the little things that Dr. Foley was talking about. I mean, he did his physical, I can't do this, I can't do this. Is this consistent with? But it didn't cover it all. And so that's why the state brings this to the court. It's what he knew at the time. That's what's relevant. The state's, the defense cases are not on point for this issue.
Judge, a couple things that are incorrect factually, that Mr. Reeves did not know the state of his condition and the state of his degenerative bones is absolutely incorrect. And we will be presenting testimony of Mr. Reeves concerning his perception. The court remembers, even when he was questioned by law enforcement, he talked to law enforcement about his arthritis, his back was a wreck. So that's not true. He has a great deal of knowledge about his skeletal system at that time. It's incorrect, and I asked the court to read those cases. These are not Williams Rule cases. That is incorrect. If the court knows what Williams Rule is, you have to have some very unique set of facts in order to introduce Williams Rule. These are not Williams Rule evidence. These were introduced specifically as relevant evidence to show the state of mind of that individual at a time prior. So let's think about that. A subsequent event that's being introduced by the government in order to prove the state of mind of the accused at a previous time. Somehow, Mr. Martin thinks that what's good for the goose is not good for the gander. Meaning that, oh well, if this was in a prosecution, the prosecution can do it. No. What's good for the goose is good for the gander. Whatever the prosecution can introduce to prove that state of mind, so can the defense prove that state of mind through the evidence. And so, Your Honor, I would ask the court, if the court has not read thoroughly these particular cases. I know the court had made a decision previously These particular cases were not presented to the court at that time. This is really a very crucial issue for the defense. And frankly, I think that if for some reason, and I say this with all disrespect, if the court were to get it wrong, it's clearly reversible. The problem
You say
is
with all
that
disrespect?
if the court gets it wrong and it's reversible and Mr. Reeves goes to prison, the chances that he'll be able to come out after the second district makes the decision, it's not good. He lost 40 pounds when he was in jail and we had to go to the second district to get him a bond.
40 pounds in 8 weeks.
So the only thing I
Ooh,
asked
that's quite the diet plan.
Giving you a very thorough memorandum, but I asked the court to read the cases that we cited because
The bologna sandwich
think
diet.
that they are on point, and there's no distinction whatsoever. And the unique issue that this jury is going to have to decide is, was Mr. Reeves' perception of vulnerability at that time, taking everything that Mr. Reeves is all about, including his skeletal system and his degenerative changes, I've got to be able to prove that. And one way to prove that is to say, you know what? He was right. He was walking on his patio, fell down and broke his hip. I think that's.
I'm liking the defense's
that's
argument
very, very
here. I'm
relevant.
liking a lot more in the
Remember,
states,
the threshold of relevance.
especially knowing that Florida recognizes that
Especially in the
horrific
defense
idea that a later
very
criminal act can be used to prove intent in a previous
And I
one.
also have to remember a 403 analysis. If
And it doesn't seem to me like it really guts the state's case. I mean, they're going to have to argue that it was unreasonable despite the frailty.
You know, as I often do when I have an analytical decision to make, a question put to me, I just,
Let me say that with the caveat that they're going to have to show that he had awareness of his degenerative condition. I mean, they'll have to convince the jury of that.
Wasn't true. That's not, that's not how it works. And I'm well aware that there are, that subsequent acts isn't an automatic bar to admission, so let's get that out of the way. But in this case, there's no way that Mr. Reeves would have thought that he's going to break a hip. All of his aging and
I don't know if that's true. That's a pretty common
frailties.
old
He's
person
71
falls,
years
breaks
old.
hip.
Of course
It's
he
a,
can testify to
it's a meme.
his, he's certainly able to testify about how he felt about himself, that he knew he wasn't the guy that he was in his 30s. No problem, of course, but
Knew I wasn't the
there's
guy I
no
was in my
way
30s.
that
Hell,
he
I'd
could
break
have
my hip 11
predicted
months later.
that he was going to fall and break his hip. And there's no way that that could have been playing in his mind at the time of the incident. In general, his frailties, certainly, I don't have a problem. But the problem I have is that's almost bolstering, if you will. See, he was right. No, that's not really how it works.
Your Honor, you know that Dr. Cohen is going to testify. You remember Dr. Cohen?
Mhm.
She's going to testify that is at the forefront of elderly people's minds, meaning falling. The reason being is
Yeah. I mean, absolutely.
Okay.
How many times, and not only breaking their hips, when elderly people break their hips, their incidence of death
Mhm.
is enormous. So no, I think that, Mr. Reeves' vulnerability in realizing that, hey, if I get hit by this guy,
I could break a hip.
I can.
Not a problem. Not a problem. But not the fact that he did break his hip.
But that's
Why
I
not?
prove that it's reasonable.
No, you don't. No, you can't prove that it's real. It has to be, the jury has to find that it's reasonable. And would it be reasonable for a 71-year-old man to feel that he was frail? You don't have a subsequent act that happened as proof. See, I told you he was frail. No, that's just not, I take distinction from all the cases offered and your arguments. I'm going to draw the line on this one. No, the probative value, it calls for sympathy from the jury, and
You should
I
petition
don't
for
find that
mandamus
it
with a
has
stay.
any probative value.
Get this thing pushed out another
other
year.
than bolstering the, what he's already going to testify to, that he felt frail. Okay.
Well, in Florida, they
we'll move
can
forward.
appeal
Yeah,
directly these
You know,
evidentiary
I
decisions
read
immediately to the appellate
transcript of
courts.
his description, I believe what he
They did that
said
several times in the
was something
Zimmerman
about
trial.
being wrecked. He's wrecked. His body, his hands, and couldn't even pull the trigger. That's all fair game. But a broken hip after the fact simply can't, under any case law or stretch of the imagination, have been playing on his mind, other than what you indicated, Mr. Escobar, about all aged people probably worry about breaking a hip or knocking themselves in the head or any number of things. In general, that's something that he might have worried about, but to point to an actual event, no, I'm not going to allow that. So I'm going to grant the state's motion as to testimony about his hip being actually broken.
That's what I thought would happen at first, but then I was swayed by the argument.
Okay.
I thought the defense had a better argument there, personally.
Your Honor, if I could give my bit of background.
Yep.
If you're finished.
Sniper's Nest says no-knock warrants and red flag laws are legal murder methods for police. It should not be easy for the police to do their job. Fourth Amendment.
Okay. Next.
Judge, I'd like to take up one of the motions I filed earlier, Friday of this week, dealing with the fact that Mr. Reeves
Somebody found a microphone?
followed with the police department about cancer.
Yeah.
The argument is the same that I made with the broken hip. He did have a bout with cancer. Apparently, he successfully battled that. But to go through, my life history, I had cancer. Again, it's a state's position, and it's not relevant. As far as the decision-making process at the time of the incident, getting hit isn't going to cause me to have cancer again. It just doesn't factor into why he responded the way he did. That's no relevance to that. It can't factor in because there's nothing that Mr. Olson can do to cause him to have cancer again. Nothing. So that just can't factor into it, and it only goes to the sympathy.
Wait, so he's a cancer survivor too? Old man cancer? How recent?
Then you grant the state's motion 11 to exclude the
Sometime in the last 8 years.
Well, no, the cancer was prior to the event, he said.
Oh, was it?
Because he said there's no way.
Is in fact they become more vulnerable in many areas. And somehow Mr. Mr. Martin thinks that people that have cancer, that it's not going to affect them other than during the period that they had cancer. That somehow, their muscular system, somehow their
I think cancer prior to the incident is definitely relevant.
Yeah. Become normal again. Because now you don't have cancer anymore in your body. That's just not the case. I think that all of his ailments that he's had throughout the years are relevant. And it plays, if you listen to Dr. Cohen's testimony, those things play on your mind because the minute that you do have cancer, you realize as an individual that you're that much more vulnerable and that you can't do the things that you used to do prior to having cancer, depending upon how that cancer has affected you, within your abilities to move around, with your abilities to have the energy that you used to have, with your abilities to function as a normal human.
Yeah, and every argument for why the broken hip shouldn't be admissible is an argument for why this should be.
Something that he's not.
Yeah.
I think that's a big mistake. I think the fact that he's had all of these conditions play to the fact that he, in his mind, got up that morning that he went to the theater like he does every morning, and finds himself that much more vulnerable every day that he has another ailment. And that's part of the aging process, and it's a very real issue in this case. One of the things that I want the court to consider, let's assume that Mr. Reeves was not 71. Let's assume Mr. Reeves was 4 years old. And let's assume that because Mr. Reeves was 4 years old, Chad Olson was going to pop that 4-year-old in the head. How would we feel about that? Would we feel that that 4-year-old, because of the 4-year-old's age, is vulnerable? Of course we would. Of course we would. It's no different when people get old. It's just like when people are very young. They can't sustain the type of abuse that individuals can sustain when they're a robust 30-year-old going to the gym, lifting weights, pumping weights. Yeah, you may be able to take a punch.
Lifting weights, pumping weights,
court,
curling weights, heaving
that even
weights.
their witnesses talked about one-punch homicides. And so you don't have a very high threshold on this issue of great bodily harm. I think the court knows that, a broken nose is great bodily harm. And so for us to say that conditions that Mr. Reeves has had, and serious conditions, cancer is a serious condition, that did not affect his perception of vulnerability, I think is wrong. I think we all, it's the arthritis, the degenerative changes to your skeletal system, it's the broken bones, all those things in accumulation of one of the other make us feel reasonably vulnerable. And so I would make the same argument that him having cancer, as well as him having all of the ailments that he has, that we're going to, elicit all of the ailments that he's had throughout, his life, especially as he got older, are relevant. And Dr. Cohen is going to talk about that as an expert in this area.
Okay. What, I'm more than likely going to deny this, but what sort of cancer are we talking?
He had prostate cancer around there.
Okay, no. I just, if it was a little mole on his nose,
No.
come on, we'll kind of put you in impact.
I wouldn't do that, Your Honor.
Okay, I'm going to deny that. I know what you're trying to prove with the vulnerability.
The mole defense.
Having cancer, but he knew he had cancer.
Yes, ma'am.
The difference there. So that could certainly weigh on his mind. I'm going to deny as to that one.
Okay, so he gets to introduce cancer evidence.
There was no other testimony regarding that.
There was no other what?
Testimony regarding the cancer, he just said he had cancer. Dr. Cohen didn't testify about cancer.
Judge, I will tell Mr. Martin, there's a lot of things that we bring out in the immunity that will be brought out in this trial. A lot of stuff.
I taught you well. I know.
Yeah.
You're going to do the same thing.
To life.
So the Arbery, I think I started to mention this earlier, but the federal hate crime trial begins for the McMichaels today, or jury selection.
Yeah, now we're going to check you out. Well, you were very honest. You pointed it out to the court meeting, so I commend you for that.
Judge, the next one I'd like to discuss along the relevancy is the state's motion and wanting to exclude testimony defendant handled a delicate situation by the
Stop coughing into the microphone.
Talking about the he didn't go into what it was, to what extent that is relevant in the claim of self-defense. As to his decision making at the time of the altercation, it has no relevancy whatsoever. So I've outlined my argument in the motion with all the cases I cited in the court. We've had a lot of discussion about what is relevant and not relevant, what's relevant in a self-defense case. suggest to the court that life experience has no relevancy.
I'm sure you're gonna tell me why.
Judge, this is the issue, and I'm not gonna show my cards to Mr. Martin as to what Mr. Reeves is gonna testify about concerning his life experience as a law enforcement officer. But that life experience as a law enforcement officer, even Bedard in the hearing that we had testified how unique, that was for a case like this, to have Mr. Reeves have the background that he had with use of force. And I want to start there because I think it's very important for us to talk about that. Mr. Reeves was selected by the captain back many years ago in order to form the first SWAT team ever for the Tampa Police Department. That was
how old this guy is.
that he was asked to do. Because he had the responsibility of not only educating himself, going throughout the country, taking these particular courses, dealing with use of force, but more importantly, educating the men that were going to be working under him. He was a captain of the SWAT team at the time. And so, as the court knows, and I believe Mr. Reeves testified about this, he had extensive experience out on the streets, both as a patrolman and as a detective, on how things and how quickly things can change in the life of an individual out there in the community. We've argued the cues that law enforcement has to adhere to in order to prevent something tragic happening to themselves while they're out in the line of duty. It's important to look at the self-defense instruction because the self-defense instruction is a preventative instruction. In other words, it contemplates.
I would think the state would want testimony about his experience as a police officer because they would say this guy's been there. He wouldn't be as scared. He's been through worse stuff.
And that particular
capable, he's trained.
Felonious act of striking that can cause great bodily harm or death. You don't have to wait to say, okay, give me the first punch, and then I can pull my gun out and kill someone. Because after that first punch, you won't be able to pull out your gun. You may be dead. And so his life experiences out there as a law enforcement officer in narcotic cases, in domestic violence cases, in homicide cases, in SWAT cases are all going to be factors that this jury is going to have to hear and consider. Because again, it is not Joe Blow jury that is a surgeon at Tampa General that puts herself in those shoes alone. She's got to put herself in Mr. Reeves' shoes. And so anything that would enlighten the jury concerning those particular risk factors and how something can be totally benign or look totally benign and all of a sudden turn and be drastically violent is something that he is going to be able to testify about. One of the things in this case that is monumental in the evaluation of this threat assessment is the theater. I go to theaters all the time with my wife. It's my Sunday routine. We go to the theater, we go to the Cine Bistro, my wife and I, late in the afternoon, because then, I go to bed and I'm
okay. I don't need your life story, buddy.
And I can tell you, I'm 64. In my 64 years, as I stand here today, I have never had anybody stand up in a theater yelling, screaming, cursing, threatening anybody. And so as a law enforcement officer, when something so outrageous is taking place in that setting, it is a cause, it is a cue that particular individual
wasn't he the guy yelling,
and that
being
individual
loud?
is more dangerous with or without a weapon than anyone can imagine. Those are the experiences that Mr. Reeves uniquely brings to this case. Most individuals that pull a gun and shoot someone in self-defense don't have this background. Mr. Reeves has this background, and the jury has to consider that background and all of his life experiences while he was out on the road, when he was doing homicide detective work, when he was doing SWAT work. In order to determine, that jury's got to say, okay, Mr. Reeves has told me about all these instances, these one-punch homicides, which I've defended one-punch homicide. I've got to take that, I've got to listen to it, and if Mr. Reeves is believable about that, then I've got to use that in my evaluation as to whether or not it was reasonable for Mr. Reeves to
Yeah,
perceive
it
his
clearly all
vulnerability.
goes to his state of mind. I mean,
And so that's what this particular
Yeah,
issue is
his
about. I know
experience as a police
Mr.
officer should
Martin doesn't
absolutely.
know
I mean,
the
it should be
particulars
relevant.
of
I
it.
don't know
He
why it
took
wouldn't be.
extensive,
and
you
the,
know,
the state can argue that it's relevant
of Mr. Bedard.
for purposes of
I don't
guilt.
believe that he touched
Yeah, that's what
upon
I was
this
saying
issue
earlier.
with Mr. Bedard. But there's going to be testimony of this issue and many other instances that Mr. Reeves was out there serving our community as a law enforcement officer, protecting our community, that gave him
A
the
new
knowledge
meme.
and the experience to be
I saw
able
one
to
punch homicide
deal
open
with
for
a
Jefferson
situation
Starship in
in the
1973.
right way, in a reasonable way.
Do we know what we're talking about here?
Stop coughing.
No idea.
Situation?
I have no idea. I
You
I
what?
have no idea how Mr. Escobar in the last 10 minutes even addressed this issue. I'm sorry, it didn't address it. The bottom line is, we have a situation where he testified he handled a delicate narcotic situation. And part of his 3 hours of who I am, which I will deal with later, not today. So I have how can that apply to his decision-making process as far as use of force in handling?
Or is he arguing for a specific police incident?
And it just leads to speculation and guesswork on part of the jury is what we're talking about or anything. So again, I'm back to 402 and 403. You just throw it out there and hopefully it sticks. I'm asking the court to find that it doesn't stick, because that's nothing to do with this case.
Certainly, if the delicate situation involved an individual who's pretty tall and lanky and hollering and screaming, who maybe then went on to fire a firearm, I could see that would be pretty relevant, that he might have that on his mind. But, you know, other than that, I don't know. I'm inclined to just leave this and, we'll have to do a proffer, I guess.
Yeah.
Shouldn't be long, I wouldn't think, and, I'll determine if it's relevant or not. I understand your argument about life experiences, but I don't know, you know, a 403 analysis here. I don't know. I don't know about the probative value versus the prejudicial impact. So I will reserve for contempt.
But this is a decision you can make. I mean, listen, if he's going to tell a story about being a cop and saving a child from a burning building, that wouldn't be relevant. But if it's use of force related, of course it's relevant.
If he's dealing with an unruly individual or someone who's like belligerent, I think that's one that should have been saved for trial.
How that typed up and how it's placed on.
All right.
What you got next, buddy?
But that's what the judge should just have said. We don't need another motion and a proffer. It just said, listen, if he's going to talk about use of force stuff that goes to his state of mind, fine. If he's going to talk about being a hero, maybe not.
Object to trial.
I'm sure you do recall that. There was testimony, I believe, from not only Mrs. Reeves, but you possibly from
God, I hate how this guy talks. I hate it.
Dealing with what her physical state was. I'm suggesting to the court that
Oh,
Her
God.
physical state is not relevant to the extent that it's not known to the defendant. If the
Okay.
defendant takes a stand and says, my wife has A, B, C, then that's fine. But we can't infer that what he knows of her ailments.
well,
He
that
can
sounds.
testify to whatever was in his head. That would be fine. But for her to make a laundry list of everything that's wrong with me,
I think it's reasonable that the husband would have some understanding of what his wife's health condition was.
Probably.
Because of speculation on part of the jury as to what he actually did.
So are they trying to have him avoid testifying?
No, they said several times he's going to testify. But of course, you want him to say it and the wife to say it, right?
Yeah.
He was frail. I was frail. Everybody frail.
Old Mick SWAT team broke his hip falling on his lawn.
I argued that it was.
What does his wife to do with this? She was there. If some guys, if your wife's sitting next to you and some guy's screaming in your face, he's also screaming in her face, and she might be in danger.
She talked about her knee replacement, the treatment that she's had over the years, and this was Jennifer Shaw talking about her mom.
You're right. Her husband probably doesn't know that his wife had a knee replacement. Probably has no idea.
The way it came about is Ms. Shaw indicating what her mother told her. I objected as far as being hearsay, and you sustained the objection. So that's why I ran the motion, depending on what Jennifer Shaw testified to about her mom, and what Vivian Reeves testifies to. It's not relevant to infer exactly to what extent Mr. Reeves had knowledge and to what extent it factored in. Like you all already pointed out, it's fair game. Mr. Reeves can take a stand and say whatever he wants, and I'll object when I feel it's appropriate. But have the other witness come in to infer it, it's not appropriate, especially based on hearsay. So I'd ask the court to grant the state's motion.
Response?
The plan is this. Vivian Reeves is going to take the stand. She's going to talk about these infirmities. She's going to say that her husband knows about them because he took her to the hospital when she woke up and had bandages all over her knees. He was there in the hospital and held her hand. He took her to physical therapy when she learned to walk again. He was right there. He made her breakfast at home. She's going to be able to testify that certainly he has knowledge. He's been married, I forget how many years now. It's so long since the hearing. I think the math. However many years.
At least 8 years.
Same with the breeding. I took her, she took me to the doctor. I had trouble breathing. And so certainly it's relevant because in this case, with self-defense, it's not only defense of self, but defense of others. So I certainly think that's clearly relevant. And I don't think there's any evidentiary problem with getting that information out. Certainly, Mr. Reeves doesn't even have to testify. That's why he got me testify. But certainly, Vivian, Mrs. Reeves, I should say, testify about those information. In terms of, Jennifer Shaw, the daughter, saying it, I don't see where that's even going to happen. We have Mrs. Reeves up there talking about it, and certainly she was very close to us, right next to her husband. Certainly, we all know Mr. Olson was in front of her. So all of that makes this relevant and I think appropriate in this sort of case.
Some point, it comes to, well, that's more appropriate for cross or whether not to do that. But you might recall that Mr. Reeves left his wife alone after the conversation. after the confrontation, altercation.
Thad the man says, did Andrew tell you that Olson's wife got shot through the hand because her hand was on his chest holding him back?
So, to say that
Well,
what is in his head and how
we don't know that she was holding him back.
what he did, it kind of begs the question.
She may have just been telling him to calm down.
Can you
I mean, it sounds like
infer
both these guys are acting like a-holes.
what he knew
Oh,
about
yeah.
her and how that played into
Interestingly, he was tired. He didn't want to be disturbed during the movie, and then he ended up disturbing the movie quite dramatically.
on part of the jury about what he knew, especially given the fact he left her there alone with Mr. Olson sitting right in front of her.
This is a bad argument.
Yeah.
The question is whether he reasonably perceived Olson as a threat at the moment he shot him, not whether he reasonably perceived him as a threat when he went to complain to the manager about the cell phone.
Right.
As far as anything that he didn't know about, Mr. Marcus is correct. I'm sure he did. I mean, was there something that happened afterwards major that came out, or is it just like her knees and her breathing?
Her knees, her breathing, her arthritis, the things that he knows about from living with her, taking to the doctor.
Oh, and I think that my prior ruling was basically sustaining a hearsay objection primarily.
Jennifer Shaw, it was.
Right.
I think there was a hearsay objection with Mrs. Reed knowing what her medical condition was, and so that caused me to go down the line and say, well, did you have pain in your knee? Did you go see a doctor? Did you wake up one day after surgery or that sort of thing? But yes, sir.
Yeah, no, I'm gonna deny that one. And just to clarify, that as I recall, Jennifer Shaw was asked, what did your mom tell you about her injuries? Isn't that how it went, something along those
Yeah,
lines?
you can't do that.
Sustained on a hearsay objection about that.
You sustained on hearsay objection.
All right. That's, yeah, I'll.
So the prosecutor's logic on this one was, she sustained it on a hearsay objection, therefore I'll write a motion to have it excluded entirely from any witness on completely opposite ground, on completely different grounds. Good job, guy. Really overachieving there.
And you said you'd have something typed up. Either you or somebody in your office, your autocorrect or something must automatically make everything that's supposed to say proffer and approval. Have you noticed that? I've seen that 100 times on the docker. I'm like, what? What is that? What is it? What is approval? Did I misquote that? And then, it's, I thought that was comical.
Yeah, Mr. Michaels gives me grief about my grammar.
It's just a funny looking word, a proofer.
Well,
What does that mean?
Grammar's good, it's just the type.
The
Yes.
typing's awful because my B's are P's and my A's are whatever it is. And it's awful, so. I
Well.
chalk it up to a learning disability.
Oh, well.
I passed the bar.
That's it.
That was important.
That was important. You can harass me all you want about the other stuff, I'll take it to try.
I'm still
But
lamenting
it
the
is
loss
embarrassing.
of word perfect that I used to use in private practice.
Yeah.
Everything's word that it makes, I feel like it's calmness or something. It makes you do what it wants you to do.
But
You can't have
it tells you, you put in a word and it tells you, no, you don't want this word, put this one. I'm like, no, I want the word that.
Yes, yes.
They're waxing poetic over
Well, I beg.
autocorrect.
Long as you understand what I was trying to
I do.
write,
I,
then I appreciate that you,
all right, what next? We're getting close to wrapping it up probably.
Oh my
the rest
gosh.
will be kind of long.
Um,
But we're done with the quick, we did 5 quick after one long one. So
Yeah.
what we have left is 3 dealing with defendant's character. Mr. Escobar would argue one of them doesn't involve that. But we have those 3 left,
Okay,
and the state's motion
Oh
to
my
redact the statement.
okay, right.
That's all that's left as far as the state. defense has the motion for a material witness, I think they want to do probably before we do. And maybe now's a good time to stop, because I've got some stuff to do to Mr. Escobar tonight, so I'm gonna be working on.
If we can, hopefully finish tomorrow, do you think the court, I'm willing to stay a little bit late if need be, but I'd love to.
I
do
think
this
we're gonna
job
finish
tomorrow.
tomorrow.
Okay.
Yeah.
No, God, there's another one of these.
As much as we can now. One thing, didn't I see, do we still have stuff outstanding on Mr. Knox?
We do, Your Honor, and this is what I'm gonna propose. We brought Mr. Knox in, on a scheduled motion date. And then we had this issue with the court reporter. And so that day was canceled. Every time we bring in one of my experts, I just got a bill for, paid for $17,000 for one appearance here. Mr. Reeves is not that kind of wealthy, individual. And so what I would propose, with Mr. Knox is, maybe I haven't spoken to Mr. Mark about this, but that we have that argument before he testifies, so that we can avoid that additional charge. I think Mr. Martin and I agree, the motions have been well.
What? Oh, that's it. Got it. Well, that was riveting.
It's not like in the movies, folks.
No. And if you noticed, there was a bunch of wasted time going on in that courtroom. For as busy as courts are, they are still people running them. And those people, they get bored and distracted and joke and laugh with each other. And that adds a bunch of wasted time. But that's the way of the world.
I mean, it is amazing that we're still having these discussions 8 years after the event. You would think this would all have been settled long ago.
Yeah, you'd think so, but yeah, and just at any point, really. Okay, I'm trying to see if there's any alternative coverage of this out there that actually has something in the courtroom, but I'm not seeing anything yet. So just waiting on court TV to actually turn the cameras on or whatever. So that's good. But okay, what do we got? The Moonbeam Medium says, just read an article in Scientific American that the loss of smell with COVID is caused by swelling around the olfactory nerves, and that if steroids helped, maybe a round of prednisone would let you eat real food again. Maybe, I don't know. I did have prednisone, but that was prior to losing my sense of taste. So, I didn't lose it. I have it very well, except it's terrible taste is what I have now. So that's nice. SSJ2 Rich says, just a note, you sort of missed the point. This is about the Israeli hacking thing. The police hacked the prime minister, his wife, his son, official at government, newspaper CEOs, and so on, to fabricate a case against the prime minister to remove him. Well, that's interesting. Okay, so the result is now they're not allowed to. Were they allowed to do that before? I guess the police should not be allowed to hack the government to then fabricate cases against them. That's for sure. So I don't know. That's kind of wild. I'm just trying to figure out like what the idea is, because it seems to me that would already be illegal. So I don't know what new thing would have occurred. Let's see. Thomas Jefferson Starship Troopers says, woe is me, I'm old and scared to fall and injure myself, but not so frail as to go to the movies with all those steps. Did he use handy-capable seating? I don't know. He appears to be in the front of the theater. And yeah, I'm not sure how the theater's laid out. So if you come in, you might actually be onto something, because if you come in at the front of the theater, like where I used to work, you walked in at the lowest level of the theater and then would have to walk upstairs. He appeared to be down near the front row. I mean, there was like nothing on the surveillance footage. There's nothing in front of him. So it's very possible he stayed on whatever level the entrance was, but I don't actually know the layout. Lancelot 652 says, if he had such a laundry list of issues and ailments, why get into a fight, leave to be a Karen, then come back and continue? That's a good question. Any comments on that one? Yes. No, I want you to talk with your mouth full, please. That's the, or is that saved for OnlyFans? Probably.
Sorry, I got
there.
super hungry. Yeah, OnlyFans.
Yeah. No worries. I'm just kidding.
I mean, he's just having the defense would argue that before he goes to the manager, he's just having a verbal dispute with Chad Olson. There's no apparent threat of physical violence, as evidenced by the fact that he was willing to leave his wife behind. Apparently, he didn't think there was any particular physical danger at that point. But that doesn't mean there wasn't a reasonable perception of physical danger at the point he fired the gun. That was a different set of circumstances.
Right. And that was a particularly odd sort of, well, I mean, it wasn't odd. Prosecutors do this in general. Like it's their job to make the case. But he's like, yeah, why did he leave his wife if he was so scared of this guy? It's like, well, he wasn't scared of the guy. That's why he went to go get a manager. Apparently, when he's scared of the guy, he shoots him. So I guess you could make the same sort of ridiculous argument. Well, he hadn't shot him at the time, so he wasn't scared yet. Obviously, is well, if he was so scared, why would he leave her? I mean, that's the same reasoning behind both of those things. So yeah. But I think not to the legal point, but to the practical point of, this guy's really pissing you off. You've got a gun on you. You should be very careful about what you're doing. You are also older and perhaps frail, and you may know about that or be contemplating it. So you should really pick your battles. I mean, was it worth the verbal altercation in the first place? Is a question this guy's probably been asking every day of his life for the past 8 years. And I think he has said if it happened today, he would have done it differently. Because of course you would. People don't like shooting other people. Razor 39T says prior law enforcement experience may actually hurt his defense. Prosecution can argue that as someone trained in law enforcement / use of force, also trained de-escalation off-duty procedures on how to act / react in a situation of conflict. Excuse me. Yeah, I think there's an argument.
Maybe, although when he was a cop, I'm not sure how much, that was some years ago, right? I'm not sure how much emphasis there was on de-escalation.
Yeah, but I think I would imagine I see what you're saying on de-escalation itself. But I would imagine that the state is going to make some sort of argument in that direction that, look, this guy's trained. I mean, right now he's presenting as a frail old man, but this is a strong guy who's been doing this forever. He would have confidence and coolness where other people would not. He's supposed to be the calmer head. It was his job forever, those type of things, to try and make it look like his actions were unreasonable for him at the time. And that's what their job is to do. So they're certainly gonna try it. So Viva has 36,000 watching the convoy. Very cool. Very cool. Congrats to Viva. Hopefully it keeps blowing up. That needs all the coverage in the world, and it needs, in my opinion, we need to support those truckers as much as possible. So hopefully, I'm just kind of sad GoFundMe reversed course and decided to refund everyone because I really wanted to see them get sued into the dirt. I thought that would be hilarious.
Yep.
But
what an amazing degree of arrogance that they would even have the thought that they can just take everyone's donations for a particular purpose and then redirect it to their preference of purpose. It's amazing.
Yeah. Oh, it's crazy. And the interesting idea now, of course, is This is in Canada, so I don't know exactly how this works, but I would assume it's a similar legal principle. The state asked GoFundMe to take down the campaign, and GoFundMe complied. In the United States, when the state asks someone to do something and then they do the thing that the state asks them to do, that puts them potentially under the idea of what's called the state actor doctrine, which then means that there are constitutional considerations to their actions that would otherwise not be present. And so it's possible that there would be something similar up in Canada, where this would put them under the Canadian government's umbrella, and that they may be able to be sued as quasi state actors or state actors. And I don't know. Again, in the U.S., I could tell you what that means. That means that the federal government ends up paying the bill, which is a good thing. And it means that you get to say, they took this down. This was our free speech rights. This is our free association rights that are impacted, and that needs to meet strict scrutiny. And we don't like the honking is not strict scrutiny. Therefore, this should have stayed up. You caused us damage. Now pay it out. It would be the idea in the U.S. Not sure on Canada, but yeah, ask the elf. Next time I see Runkle, I'll ask him about it for sure. Or Viva. Both elves in their own way. But yeah, what do you think about that whole situation in general?
Well, we live in interesting times, right? It's I mean, the arrogance of government, I guess, is always limitless, but you rarely see it on this kind of display. This is just a protest that the state doesn't like, and so they're doing everything they can to crush it, including apparently removing fuel necessary to operate the trucks to keep people warm in these frigid winter conditions. I'm sure there's women and children in that crowd too. And the government would not do this to one of their favored groups.
Nor would GoFundMe. Just to be very clear, the amount of hand wringing and teeth pulling that occurred before any fundraising for Antifa or BLM came down was quite significant. I mean, they had, well, part of the problem was there weren't really any prosecutions happening, though there was a lot of objective violence of various stripes against people and property going on, but there weren't really many prosecutions, and things weren't tied directly to the association or the organizations themselves. So, individual actors. But I think the same could certainly be said of what's going on up in Canada. But GoFundMe just took a completely different approach on that one. So I guess good on them. That's what they. Nope, that's not what I want. Okay, trying to get this organized again. Still nothing.
And of course, it just contributes to society being more divisive, divided, towards society being a low trust society, especially when it comes to social media. If you're on the wrong end of the political spectrum from the social media preferences, they're not going to treat you in anything resembling a fair or reasonable manner. You're the opponent to them. You're the enemy to them.
Yeah, it's crazy. 200 Watt Studio says that the Give Send Go for the truckers is up to 4.6 million, which means they've almost or they're about halfway towards replacing the GoFundMe itself. So that's actually that is a good thing, in my opinion. I hope people support it, and I'm glad that Give Send Go took a step, even though it is probably in their business interest to do so. Took a step to say we'll take up the cause for sure. But the crazy thing is that GoFundMe should have never taken up the cause in the opposite direction. That just should be as a fundraising company, the amount of discrimination that you put into it when your fundraising is done in the way it is, where anybody can come on and make a fundraiser for anything. And then of course it's subject to review or whatever, but when that's the way it is, to me, less interference, the better. You've set it up to not be your business, so let it not be your business.
But everything they do is guided by this, I don't know what you'd call it, this secular religion of the progressive left, and their things like their social standing within that secular religion is far more important to them than even money or profitability of the enterprise. It means everything. That's why you see these organizations like the NFL apparently make decisions that you think to yourself, well, they're going to lose fan base. They're going to drive down the value of their brand, but they don't care about that nearly as much as they care about how they're going to be perceived at the next cocktail party among their peers.
Correct. Marsupial Gamer just asked a very good question. He said, is Vic's GoFundMe going to move? Yes. I am. I have just gotten all of the permissions and everything to move. I will be composing a departure from GoFundMe. I'll probably put up a video about it. But yes, I am moving the GoFundMe off, or the VIX fundraising campaign off of GoFundMe, specifically for this reason. It was one of the first things I considered when they did this. And I do not want to be directing people to a platform that is willing to take this action. So I have to just compose the language about it. And again, I had to get permission because I don't want to put any political messaging onto Vic or Ty or anything like that. But I've gotten everything worked out. I just need to actually get that done. I'll be opening a Give, Send, Go with substantially identical information. And when that is done, I will make a video about it. I will post it up, and so everybody can see that. The good news about our relationship with GoFundMe is that for the past several months, it's just a few dollars a week will come in here or there, and that stuff is immediately distributed out. So we don't really have a lot of money moving through there at this time, and so moving it is not of any particular consequence. So that's that. But yes, look for the
Vic.
Vic is a voice actor named Victor Mignogna.
Oh yes, okay. I remember you mentioning it.
Right. So his GoFundMe hit 290,000, I think, that we raised on that. But yeah, and I'll move it over to Give, Send, Go. I don't really promote it much anymore since the case is on appeal, and I didn't really want to ask people to give any money for an appeal. I want to have a landing place for, if the appeal comes back, I want people to know that this thing is there and will be fully ramped up, but it'll be on Give, Send, Go from now on. So, oh my goodness. All right. I've got some other chats to read here. Andrew Smith says, Nick, I started a merch store. You'd be proud. Lamau, take a look. I messaged it to you on Discord. I'll have a laugh. Yep, I'll take a look at it. Probably talk about it tonight, buddy. Ackles Floozy. Wait, read that one. AP says, Nick, well, time to go stream. Nick's kids. Mommy, is daddy going to start drinking and yelling about the bikes and the N-words again? Yes, always. Mary Zeri, welcome to Paralegal Status. Very happy to have you here. And I have directed my editor to get some new emotes and stuff for members. It has not happened yet, but it will be coming. That's on our list of things to do. So by the way, thank you for joining memberships here on YouTube. I would humbly direct people over to locals, but I'm appreciative of people joining here as well. Tyler Mueller says, loved your coverage of the Rittenhouse trial. I miss Judge Schrader. I have a lot of criticisms of Judge Schrader, but I like him just in general. I think he's an interesting guy, and he seems he seems good natured, even when I disagree with his rather permissive approach to the rules of evidence. I think that was a problem. But True Anonymous Shabbat, a bad pressure back half care says, what are they going to use the donations for when the police are stealing their gas? The state is evil. So this must be a new development. You just mentioned it. I've seen it in the chat. What's going on with that?
I guess the police just went through and started gathering up all the fuel cans and of gasoline and kerosene and propane. I figure if the protesters get cold enough, they'll go home. Or
Wait,
if they
so
think their vehicles are going to be stranded there.
They're going to the protesters and taking those things?
Yep.
I mean, I'm sorry. What? Seems audacious.
Well, apparently they feel they can do anything. I mean, they label it an unlawful gathering, and that gives them blanket permission to do whatever they like.
Just confiscate your stuff. Well, I mean, we do similar practices in a little bit different stripe, but with asset forfeiture and stuff like that. I mean, I don't know that a gas can is usually considered an asset forfeiture, but we would have the abstract legal theory at least to encompass that. But that's a little bold for me. Yeah, we're just gonna go ahead and we're just gonna take the gas. What do you mean you're gonna take the gas? Yeah, we're gonna take all the gas cans, so you can't fill your truck up with gas. That's crazy.
In Canada in the winter.
Yeah, but can you this is aside from the propriety of that action. Don't those trucks have 130-gallon tanks?
Oh, bigger than that. The tractor trailer's bigger.
Yeah, could you imagine
300-gallon tanks?
Hauling
maybe 300 liters.
5 gallons of gas at a time, in one of those cans. Glug, 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 glug. Go back. Glug, 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 glug. Oh, God, that would take forever. Anyway, yeah. You know what? Again, to hell with the Canadian government. To hell with the Canadian government. I guess the other thing they could try and do is say, well, we suspect arson or fire attacks. We're removing the incendiary devices that they're using. Mr. Hazo says Viva on his stream just asked the cops this. They are claiming, and Andrew, yes, they are 125 to 150 gallons, but they can have 2 tanks. The incident, this is from a snitch told the police about people using farm fuel, which is illegal to use on the road. They weren't taking all gas. Oh, okay. Okay, so just farm gas.
Maybe.
MacGuffin does. Yeah, I mean, who's testing it? Who's proving that out?
It'll have a dye in it. That's how you can tell the difference just by looking at it. It's a different color. At least here in the US, that's how they do it.
Gotcha. Marsupial Gamer says Rumble just publicly offered Joe Rogan $100 million to move over to their platform. Tug is trying to get them to make you an offer. Well, I mean, that would be great. I don't it'd have to be significant. We'll say. I don't know. I'm skeptical right now of exclusivity agreements, and I'm not speaking about Rumble, speaking about in general, because if $100 million exclusivity agreement from Spotify is at risk because some people got their panties in a wad over some words Joe Rogan used several years ago, and the idea that he interviewed the guy who invented mRNA vaccines, and they didn't like what he said. If some whining and bitching on Twitter is enough to jeopardize $100 million contract, then did you ever really have a contract in the first place? I mean, that's insane to me.
Get that money up front.
Yep. Get it up front. I agree. MacGuffin Doe says, what are the top 5 Supreme Court cases you think every citizen ought to read and understand? Oh my God, that's a tough question. I think they ought to read and understand DC versus Heller. I think they ought to read and understand. Let's see. I had another one in my brain just a second ago.
I mean, con law is a full year, folks. So
yeah, and it's not enough of a year. Like,
No.
or it's not enough. It's nowhere near enough. But the 5 cases, yeah, I mean DC versus Heller. Oh, Castle Rock versus Gonzalez, I would say is a great case. People need to understand that according to the Supreme Court, the police do not have a duty to protect you. They do not have a duty to investigate. They don't have much of any duty at all that they have to do. So you should know that the police are, that even though many of them try valiantly to do those things, they don't have any duty that you can enforce against them. I think maybe Kilo. This is a weird one. Kilo versus New London. Is it?
What a travesty.
The case that's where people's homes were taken through a process called eminent domain, and they were given to a private company to create a shopping mall. And then, of course, the best part of that whole story is that the shopping mall was never made, but everybody's homes were taken and demolished anyway.
Was it a shopping mall? I thought that was Pfizer.
Or
The Pfizer
strip mall, I
R&D
thought.
facility they wanted to build there.
Oh, was that the one? I thought it was.
So
I
Pfizer
thought
built they built their facility about the same time, but Pfizer built a giant R&D facility in New London on both sides of the river right around this time. So I thought it was part of that case. The irony is that within 7 or 8 years, Pfizer basically abandoned the entire structure. So it was all for
Yeah,
nothing.
that's what I'm thinking of. But yeah, so but yeah, the idea that your government can take your stuff and give it to another citizen is crazy. And then I think that's 3. I think Wickard versus Filburn is an important case. That's where the government can, through the Commerce Clause, control not commerce, like specifically the action of not commerce. They can control that. That's a really important case. And then the last one, what other FU do they have? God, I was thinking, Korematsu. Korematsu is another one where our government decided that Japanese Americans could be put into concentration camps, including soon to be, well, not really soon, to be famous Japanese Americans like George Takei were put in concentration camps based solely on their race. That was something. And the Japanese got it particularly bad. However, the Germans and Italians didn't fare a whole lot better. They had a little less property confiscation, a little less incarceration, but they were all individually distrusted and interviewed and interrogated and put under scrutiny based on their national origin. These were American citizens too. These are not immigrants. These were not anything like that. So I find all of those concepts that were occurring during World War II to be particularly disgusting. And our Supreme Court was okay with it because it met with a particular agenda of a particular party with a particularly popular president. And so we should all know that everyone's in danger when the Supreme Court is politically motivated and falls to those things that they're supposed to be opposed to. So, and they said, I mean, Anthony Kennedy said that it was definitively overturned, that Korematsu was definitively overturned in a case that had nothing to do with Korematsu or the issues thereof. So in dicta, he said it was definitively overturned. So that means it's not overturned at all. So it's still technically good law. The government can lock up people based on their race if they determine that they have justification for it. They have Supreme Court precedent for it. That was a lot of answers. So there you go, my Guffindo. Andrew Smith says, don't forget your giant gummy worm dildo is arriving Tuesday and you got to show it off on stream. How could I forget?
By the way, folks, if you're really interested in constitutional law, Hillsdale College does a pretty good online course, like a lecture series. It's completely free. I think it's free. But you might want to take a look at that if you're actually interested in in-depth understanding of constitutional law.
I can't
and don't want to go to
believe-
law school.
I cannot believe you right now. You're wrong about this. What you should do is you should Google CNN interviews Erwin Chemerinsky and learn your constitutional law from Erwin Chemerinsky whining about it on CNN. And if you're curious who he is, he's the guy who wrote the book called Constitutional Law that is taught at several law schools. It's about that thick. And when you look him in the face, or when you see a picture of him, you'll understand why he was able to write a book that was that thick. You have it on your shelf there?
I do. Yeah.
Yeah, there, I can see it. It's the big one.
Well, that's how often I access it. I can't get it out of the shelf.
Yeah, I see.
It is actually Chemerinsky's book.
It's too tall. Yeah, I was when you mentioned it, I looked back there. I was like, oh, that's it. That's it. It's the one that's thicker than all the other books. Right. Erwin. What a weirdo. He was all in on the impeach Trump train. And I'm just sitting there like, buddy, I've read your book. There's no way you can think that this is a valid impeach or that these are valid legal theories. I mean, certainly impeachment being entirely a political process, it could be brought just because they voted on it. But oh man. RPG or 90 says, hey, Rackets, if you're asking for after California murder trials, there's a crazy guy who recently shot up a Greyhound bus and then ran away, got arrested after completely stripping his clothes off. What do you think about that, Andrew? So let's say you don't have a self-defense. You've murdered someone because you wanted to, you're mad at them or whatever, and you're like, I'm going to kill this guy. Would your legal advice be to run around like naked and act as crazy as possible? You think that like you're like, oh God, I gotta present as a nut job here. That's
it's probably not helpful. I mean, usually, of course, the legal defense is you try to hold the state to their burden of proof beyond a reasonable doubt on the case. But sometimes you just kill someone, and it's, most murder trials are 1 or 2 days for a reason, folks. Most murder trials are not that hard to get a conviction on because the evidence is so patently consistent with criminal guilt. But people misunderstand what it means to not be held legally liable, criminally liable based on insanity. It doesn't just mean that you're crazy. Crazy people can be convicted of crimes. It means whatever the specific act you committed, you didn't know it was wrong at the time. Not that you also happen to be crazy in some other way. And in the case of a murder, the standard is pretty high. You effectively have to have believed in your mind that you were shooting a space alien or something, somebody other than a human being. And that's pretty hard to pull off.
I just want to point out the difference in legal strategy that we have here. And when you guys are picking a lawyer, you got to pick the right one. See, do you want to go with the guy who's like, well, we're going to raise the state's burden and do that? Very boring, bland defense presented by my opponent here. Or do you want the guy who's like, look, here's what you got to do. You got to get naked and run around like a crazy person, roll around in mud and filth, dig in a toilet, whatever you got to do. We're going to keep you out of prison. That's the legal defense you want to buy, ladies and gentlemen. Don't listen to these legal theories and all of that stuff that Mr. Branca is putting forward. No. I just want a California murder trial because it'd start later in the day and I could sleep a little bit later because God, this one's going to be rough. We've got, here we go. Here's some other video, maybe a little bit better video of the shooting at the theater. In this case, let me pull it up here. As I dig through looking for this thing to start. Okay, here we go.
Video released late this afternoon of the movie theater shooting Wesley Chapel shows us many new angles of what happened before and after the deadly shot was fired. Our Andrew Dowd brought this video to an expert to get some insight into what the video might tell us. Andrew?
Well, this new video shows how all this played out from multiple cameras set up around the movie theater. Immediately after the shooting, we see people run from Theater 10, pointing to someone off screen. But
I don't know if running is the...
Before Chad Olson and Curtis Reeves ever even met each other, we see Reeves and his wife walk in after buying their tickets. Before the shooting, we also see Reeves leave the theater and go talk to an employee at the front desk. In court Friday, we saw this video for the first time when Olson supposedly throws popcorn at Reeves before Reeves pulls a gun and fires. This new angle from a camera on the opposite side of the theater shows people rushing to help Olson after the shooting while Reeves is seated next to an
These descriptive words aren't very accurate.
this afternoon, specifically about that moment Reeves goes to talk to that theater employee.
We also see Mr. Reeves come out of the theater. We see him approach the man who is at the service desk. And it would appear that the man at the service desk, although we had a conversation with him, took no action as a result of Mr. Reeves coming out to see him. And it's very clear Mr. Reeves is, from appearances, agitated.
Now, Schwartz says he does
Okay.
not believe the video helps Reeves' claim of self-defense on Friday.
Those videos were useless. They were useless. Sorry, guys. I was hoping they would be better, but I mean, there's new video shows how Wesley Chapel theater shooting played out. It did not do that. That was false advertising. I'm suing them. Goodness gracious. But are these people surprised that a movie theater employee did nothing? I mean, is that shot? Have they ever been to a movie theater? The employees don't ever do anything at all for any. They barely even clean the theater.
They're barely breathing.
Oh my God. Okay. So I was hoping that would be a little bit more clear, but alas, it is not. Okay. Yeah, but yeah, those descriptions, people running out of the theater, they're all walking quite calmly out of the theater. That was wild. Okay, back to these things. AP says, Branca, few people talk about the impact of the once a machine gun ATF BS and how it impacts surplus import and access to cheap combat tested firearms. I grew up broke and relied on them. Thoughts?
Once a machine gun? Is that what it says?
So I'm guessing they were fully automatic, but they've been mechanically disabled to semi-auto. Is that a thing that exists? Because
I mean, yeah, there's special parts and manufacturing that goes into making something full auto. The sear has to operate differently. It wouldn't be hard to disable. It would, but then you just put the full auto parts back in. It would be fully automatic again. It's yeah, the federal government's pretty touchy about all this full auto stuff. There's lots of requirements. They don't like things that can be easily made into full auto. Although, I mean, anybody with machining skills can do it. It's not at all technically complicated. But you know, the ATF has done things like just caught people with a full auto sear, and that's enough for them to prosecute you. So,
did you see the recent thing where so there's a YouTuber, CRS Firearms, and they took a sponsorship from a company that would print out these metal cards, right? They look like a credit card, but in size, but they had on them etched the outline of something where if you were to cut this thing out, it could be used to make a semi-automatic rifle into a fully automatic rifle. They weren't actually cut out. They weren't perforated at all. It was just the etching of it. And the YouTuber was arrested on like conspiracy charges because he took a sponsorship from the company, and he got married after getting arrested. And so they've now charged him with obstruction of justice for getting married.
because he's going to argue spousal privilege, or
I have no idea, because you can't do that. You don't have a spousal privilege because you get married after you said something.
Right.
You would only have
despite
a
what you might hear in the movies.
Right. Yeah. Your spousal privilege starts with statements that you make during the marriage, not prior to the marriage. You do not have privilege in those statements. The statements are actions that came before. So, but yeah, it was called a lightning link, I guess, is what people are saying in the chat.
Yeah, any of those NFA items, folks, I would just make sure you jump through all the hoops and don't get even close to the legal boundaries, because ATF doesn't like it, and they can make your life thoroughly miserable on a whim. So things like full auto sears, things like components for building suppressors, or what do they call those things? The oil trap things. Just don't do any of that. If you want full auto, move to a state that allows full auto. Lots of them do, even Massachusetts, believe it or not. And then pay the $200 tax and go through the background check filing requirements. In fact, we just did a whole show. I just did on gun trusts. I had a friend attorney come on as a guest. I don't have any expertise in gun law, but he does, and we talked quite a bit about setting up NFA trusts for being the ownership of those NFA type items. But I would be very, very careful to check all the boxes, because if you miss one, you're looking at serious federal time.
Absolutely. So what was the takeaway? I saw that video. By the way, people, if you're interested in that video, Andrew's channel is linked down in the description below. Law of Self-Defense. You just click on that. It'll take you right to his channel. You can subscribe and presumably find this particular video. But I saw that. I've written a couple NFA trusts in my life, but it's been a while. I don't have much cause to write them right now since I'm just doing YouTube. But what the time that I wrote them was prior to the rule changes that they made. So at the time, the NFA trust would allow you to avoid the fingerprinting and picture requirements that were involved in having these items, because the trust couldn't be fingerprinted and pictured. It didn't exist. But they changed that. So now that trustees, I believe, have to get the fingerprinting and picturing.
Right.
So it's a little bit different. So what was his take on the usefulness of them now?
Well, they're mostly that they're useful kind of in a estate planning kind of context. So you own a bunch of machine guns or suppressors or whatever, you get hit by a bus, and now your wife is in possession of all that stuff, and she's not entitled to be in lawful possession of that stuff. In fact, now she has a bunch of illegal machine guns. But if they're in the trust and she's a trustee, then she can have possession, either to keep them herself or to sell them or whatever she wants to do with the property. But you do not want to be in a position where the government can argue that you're in unlawful possession of a machine gun or a suppressor, because you're looking at 10 years in prison, even if your possession is completely innocent in terms of any criminal mental state. That doesn't matter as far as the ATF is concerned. And this is also true for lots of things. I mean, even non-NFA guns. If you have a large enough collection, you want to keep that stuff out of probate, because probate's a train wreck.
Right.
Having it in the trust avoids that kind of hassle as well.
In general, trusts are, in many cases, a better vehicle to handle the affairs of your estate, because they can be done while you're alive. You can make sure that things are distributed the way you want them to be, whether your family is not fighting over this after you're dead with no say on it. Trusts are an excellent way to deal with that. But yeah, that was the interesting thing with the NFA items was that it would allow quick and easy ways to grant possession authorization to people without getting them to go through this long process, the NFA. So if you're wanting to, or if you and your adult son or whatever have a hobby of shooting, and he wants to take this fully automatic gun up to the range one day, if you own it and just give it to him without some authorization, that could be gun trafficking.
Even with authorization, it doesn't matter. You would need to be physically present.
Yeah. So
you would need to be in a position where you still exert control over the weapon. So you can't just give it to your son, say, take it to the range. Whenever you're done, bring it back and we'll put it back in the safe. That's when he's at the range with that gun. If you're not there, he's in unlawful possession of a machine gun.
Right. So with the NFA trust, it used to, and I assume it still would. There's just few more hoops now, but it would allow multiple people to have access to this gun. But prior to that, it would allow you to skip the fingerprinting and the photograph requirements. But now you can still do that multiple person thing. There's still a benefit or value to that, but you just have to get fingerprinted and you have to have a little passport type photo, I believe is how that works.
Right. And
for all
I guess the
trustees.
concern previous to the change was that people who were effectively prohibited persons were getting access to firearms by doing it through the trust, because they didn't have to go through the normal background check, and that was done away with. The trade-off was, in the old days before this change, you also, if you wanted an NFA item, had to get the permission of your local law enforcement officer, whoever the chief was or the sheriff was in your county. And if they didn't like you to have that gun, they would just not give permission, and you couldn't own it. Now you're not required to get their permission anymore. You're still required to notify them that you possess the item, but they can't deny you the opportunity to possess the item.
Well, that's a mildly positive change. If there is some sort of licensing and permission structure, you would want it to be a shall issue sort of idea. And that's not the best way to put it, but that's how they put concealed carry states, or shall issue, so that as long as you are not prohibited, the government must and is compelled to give you the thing that you're asking for from them. But there's some places where,
and of course, there ought not be any requirements at
right
all. No background checks at all on any of these items. It's all facially unconstitutional. It's ridiculous. The bad guys don't go through these background checks. They don't pay these $200 taxes on NFA items if they want them. They just go get them. So it serves no purpose. It doesn't keep bad people from getting guns. It doesn't keep bad people from doing bad things with guns. It does nothing but infringe the rights of the law-abiding to own guns. Having said all that, please obey the laws on this, because they will put you in prison if you don't.
Yeah, and that was the interesting thing that you were saying, is that it's like, well, now or previous now they can't deny you the thing, and it's like, that's good. At the same time, they never should have been able to deny you in the first place. It's a ridiculous sort of idea that they can, nope, you can't own a thing. Like, okay, I thought this is America. I'm sorry. I thought this is America. But they can.
And just if you
clicking on the wrong thing there. Still looking for this trial footage to ever actually begin. I wonder if, I guess there'll probably be a news story if they actually finish seating the jury. Set to begin Monday. Okay. Set to begin Monday was written 38 minutes ago. So that's, not really the best headline for that. Okay. Jim in Ohio says, wait, Uncivil went to the University of Akron. Akron, Ohio. Got it. Apparently. Strategic Defense Concepts. Did you hear of the recent shooting in Florida where a guy videoed himself shooting like 10 to 15 rounds at another car, then called the cops and claimed self-defense? Video on YouTube and Wild AF. Ironically, his name is Popper. I did, but maybe we should watch that real quick. Have you seen this video?
I don't think so. But people do this kind of stuff all the time. There was a case a few years ago in Texas where a guy got into an argument with his neighbors, and he had a cell phone out recording, and he just repetitively recites, I'm just standing my ground. I'm just standing my ground. And then he shoots and kills somebody, as if saying those words are some kind of magical phrase that makes your conduct lawful.
Yeah. Well, that's what you learn actually when you watch enough Sovereign Citizen videos, is that there
are magic words.
Yeah, there are magic words, and legal concepts operate much like wizardry. Here we go. Let's see. I've got this. Here we go. So here's the road rage leads to gunfire.
I have seen this video. Yeah.
Today. Look at this. This was all caught on camera. One driver is now facing charges after a morning rush hour confrontation. Fired off nearly a dozen shots, and this was in the middle of the interstate. Our Victor Okendo is in Miami with these details. Good morning to you, Victor.
Good morning,
Okay.
TJ. That's right. Nearly a dozen shots fired here along I-95.
What's he charged with? Reckless endangerment?
Was hurt. This
Sure looked
accident took
reckless.
place last June, the driver turning himself in, handing over that video, which we're now seeing for the first time.
The video is wild. This driver opening fire during the morning rush in Miami. All of this caught on the driver's own dash cam. Now he's facing 2 felony charges. According to the arrest report,
Did that guy have a
30-year-old Eric Popper cut
gun
off another
shoot?
driver who then started tailgating and honking. Moments later, he reaches inside the car's center console and pulls out a handgun. The other driver catches up, and according to the report, he throws an unknown object, hitting Popper's car. Popper opens fire, later telling police he thought he was being shot at.
I hope he works for an auto glass company.
Not having a gun.
When he was shot,
That's
he pulled
wild.
out his gun in self-defense and was justified in pulling out his gun.
According to AAA, in 2019, road rage contributes to approximately 30 deaths every year in the U.S., and nearly
That was
80%
wild.
of drivers have expressed.
I guess so yeah, somebody threw something at his car. He must have heard a noise or saw the movement, and so he's already got his gun out though. It's not like that was he was already ready for that. So that's
His lawyer didn't look all that confident.
yeah, I would not think that case is going to be super easy to win. Oh God! What if he would have killed the guy? That's what he's got to worry about, man. Killed that guy, then he swerves off and runs over a family or something like that.
Yeah, I mean, it's rush hour, right? There's other cars on the road. They're all full of people, men, women, and children. And now he's got 9mm rounds flying all over the freeway.
And he ends up blasting out his own. That's what gets me. It's like that's a lot of damage you just caused to your car from the inside out. But whatever. I mean, I guess people will do what they're gonna do. All right. Josh Vermillion says, "Did you guys see? Oh, excuse me. Did you guys see Audrey Cole last week successfully use self-defense in the killing of her boyfriend who was unarmed but attacking her?" I did not. But yes, unarmed people can be dangerous. So, unlike Binger, it should be recognized that unarmed people can be dangerous. It just depends on if they are or if you perceive them reasonably to be dangerous. Carol Rodenberg says, "I'm going to get in front of this and say Nick and Uncivil Law did not hang themselves." Oh, that's good. I did not. Justin P says, "Hi, Andrew. Not sure if it's true, but my local ABC News, I'm in Florida, said the law about assault of an elderly person was not in place was put in place after the event." We addressed that earlier, but you had said you thought that might not be accurate.
Yeah, the original version of the statute, which did have that enhancement from misdemeanor to felony for people 65 years of age or earlier, was 1989. Now, it has undergone a number of revisions since then, and there's been a number of appellate court decisions around the statute having to do with things like whether or not a defendant convicted under the enhancement needed to have had affirmative knowledge of the victim's age, or whether it was more like a statutory rape thing where you don't need to know. It just, all that matters is the strict liability of what their age is. So there have been, modifications and permutations of that statute, but it's not like the first time it became law was after this event. That's not the case.
What the hell is going on here? Okay, that was weird. My phone was trying to get me to join some video call, but it wouldn't let me actually decline it or anything else. So that was odd. Okay, what sorry, I'm looking at the Core TV page to make sure I'm oh my god. Every time that comes up. Yeah,
They're terrible.
Everybody in this one's terrible. No one's covering this until I'm guessing they're just not going to cover it until the jury's already seated. Which I wish they would just cover the jury selection. Personally, I think jury selection's instructive. You get an idea to see what sort of strategies each side is kind of planning. You get to see what they're afraid of. I like jury selection. It gets a little tedious depending on how it's done. Judge Regina Chu's jury selection made me want to hang myself. But yeah, it's a little annoying there that they're not doing it. Bad Dragonite says Nick's nose is so large that he takes allergy meds and magazines when he isn't going full belt fed. And then Bad Dragonite says unfetted. The Dragon's Treasure says make T-Man a mod, buy T or banned. That's why you're not a mod. You've just figured it out. Andrew Smith says just mod me, Dad. Lamau. No, I want to get less mods, not more. Oh my God. Why would anyone want to be a mod? Bad Dragonite says all these wrenches, but no hammer and sickle. John Crump Live says enjoying the stream. Hey, what's up? John Crump, by the way, is the guy. He is involved in. He is not the guy from the CRS case, but I think he's friends or associates with that guy. And you can check out the John Crump Live YouTube channel. There should be more information. I do intend to talk a little bit more about the CRS firearms arrest and see how the case is progressing. But you can check out information from John Crump there. Not to be confused with Ben Crump. They are different people. One is named John and one is named Ben. Kinda X122 says, wow, I can't hear shit from the court feed, and it's not even Nick talking over it. That's the problem. No, it was a really bad feed in that room. I'm guessing again that as the trial goes, they'll probably have more competent audio and video going on when they're making the trial records. They tend to do them as more of a production. Let's see. Oh gosh. Oh, they've probably been at lunch for the past hour too. So who knows?
I mean, the jury selection should be pretty straightforward. The case is so old, no one's going to have a personal memory of it, really. So, and it's not, there's no, I hate to say it, racial energy around this.
Right. It's a shame that we have to talk in that sort of way, but you do, because that is what is driving so many of these cases these days. But yeah, there's no particular element of that going on. So that's good. All right. What do we got here? Rick Pellicciotti's, thank you for the donation. Matt Hagen says the only time I'd be okay with no-knock warrants is when CP is involved.
CP?
Child pornography.
Oh.
YouTube doesn't really like the phrase.
Oh, sorry.
So, no, it's fine. I'm not concerned about it. But if you make it like a focus of a show or a stream or whatever, they will demonetize the ad revenue from it. But
yeah, I mean, most of the circumstances people imagine no knocks might be good for, like kidnapping scenarios or hostage scenarios, would fall under exigent exceptions to a search warrant anyway, or an arrest warrant anyway. So really it's the drug cases. And I guess if you want to catch a really bad dude while he's sleeping.
Yep. And that's one of the things they try and do. Although so there's a reasonable time kind of window for warrants, and it's between I believe it's 9 a.m. and 8 p.m. is kind of the presumed reasonable time to execute a warrant. If you're doing it outside of those times without good cause, it would be considered potentially harassing because you're interrupting someone's sleep and you're coming in at night and it's disturbing and distressing and all of that stuff. So typically, the reason I'm bringing this up is to let everybody know that there are some sort of general practices on when warrants are served in a particular way so as not to infringe on the rights of people and not to escalate the situation beyond what it would otherwise be. But no-knock warrants are the exception to that, and they require a special level of permission because they are the exception. And the idea is that if we don't do it in this way, someone will be in danger, evidence will be destroyed, whatever it is.
But it becomes very pro forma in practice.
Yeah.
I mean, they just, the officers who want the warrant learn what words are going to be acceptable to that particular judge to approve a no knock, and they just use that same phrasing. I mean, if you look at the warrants, it's like one of these orchestrated campaigns on Twitter against somebody where it's the same tweet over and over again, same exact words from 1,000 different accounts. You look at these warrants, you see the same language every time, even though they're separate cases. It rarely feels like it's a substantive justification for the no knock.
Yes, and that happens with alarming regularity in all aspects of the court. I mean, we talked about it with the FISA court a little bit. The FISA court is this secret court where the government goes to ask for permission to put some sort of wiretap or communications monitoring on your conversations. And your attorney, you are not allowed to be at the hearing, nor is your attorney. The government argues both sides of a FISA warrant application. And that is probably a portion of why they have something like a 99% success rate for getting the FISA warrant. They are almost never overturned. Because shockingly, if a person is not able to argue against it, then they only hear the arguments for the action, then it sounds pretty good. Sounds pretty good.
Yeah, I mean, warrants in general are, I mean, how often does a judge say no to a warrant? I mean, because everybody knows what boxes have to be checked for the warrant to be approved. So you don't ask for it unless you can make some representation that the boxes have been checked. So the rejection rate ought to be 0 because you ought not be seeking one where you haven't checked the boxes that are going to be required.
Yeah, and that's where I was getting to. That the other kind of recent case on the channel where we discussed this was we mentioned it today with Kyle Rittenhouse. That was actually the surprise. This is not a warrant, but it was the charging document which contains a probable cause statement. And when you read that probable cause statement, you're baffled as to why they're bringing the case. And that's the rarity. What typically happens is that when they're writing up a probable cause statement, it's relatively slanted because all they have to do is give enough facts under relaxed evidence standards to show that they have probable cause to make an arrest or bring a charge. They don't have to prove out their case. So typically you'll see a very loosely and favorably worded probable cause statement. This person did this person did that. The government knows this is bad, so therefore we did this and this and this. And then the trial may be way more complicated than that. But in Kyle's case, the probable cause statement and the charging document were wildly in his favor, in my opinion. So it's weird to see that. But yeah, typically that's how they do it. I was telling a story to someone the other day about a case that I had where it was a drug raid on a house. They didn't find any of the drugs, but they found some CBD oil that my clients had, and then they determined that must have THC in it. And there's a whole bunch of wild screw ups and stupidity in this case, but at the end of the day, one of the things we went after was on their warrant request, they had a concerned citizen calling in, and we knew almost for certain that it was actually a CI and a confidential informant. And if you're basing a warrant request on a criminal or confidential informant,
and they didn't say that.
No,
Oh,
it did not. It said concerned citizen. And tell me,
that's
you
weird.
tell
'Cause
me.
normally, I mean, they'll just say a normally reliable confidential informant tells us, and that's adequate. So it's weird that they wouldn't bother doing that.
Well, there were a couple people present at the time that this happened, right? And I have a theory as to why they didn't do it is because I believe that the evidence that they used to sustain the warrant was actually planted by their CI, and they know it. The evidence, which by the way was not actually evidence, but it was a straw. It was a straw with a sweet substance in it inside of a garbage can that they pulled from the curb. They said that was indicative of methamphetamine presence. They didn't field test it for meth, but just a straw meth. If you don't know, guys, they'll put a meth rock inside a piece of a straw, drinking straw, and chop it off and kind of pinch the edges, and that's a carrying mechanism for meth. So that's why the presence of a straw can indicate that, I guess. But it was the straw that they found in my client's garbage was the person who was there the day of the raid, the person who was on probation for drug charges, and presumably in the presence of drugs. And after a phone call that the police made after arresting everyone, they uncuffed the person on probation and let them go. Kind of looked like a criminal informant. I mean, just a little bit. They also had pending custody issues that they were negotiating with the state for child stuff. But that being said, the other really interesting part of that was that all the state had to do to disprove my CI theory was to put a cop on the stand and say, no, we didn't use the CI, and they wouldn't do it. They would not do that at all. But ended up getting the charge dismissed on other grounds anyway, because it was CBD oil. And when I finally got the report, like 4 months after they did the raid, the report on the raid itself, and they wrote down the wrong tests. The field test packets that they used were for different drugs than THC. And the process they described for using those field tests were also incorrect. So it was just a complete disaster. They screwed that thing up. They were mad. There wasn't meth there. It was a setup. It was someone trying to get out of other trouble and selling other people upriver, and it backfired on them. So, but yeah. So that was a rambly story. Night of Knee says, I love this channel, brother. Hey, me too. Thank you. Scarlock says, is it just me or is the court composed of vampires while counsel is normal human beings? Are you talking about this Curtis Reeves case?
That's a
the
pretty
judge,
pale judge. I mean, pale. How do you stay that pale in Tampa, Florida?
I don't know. I mean, I managed when I go down there. I guess I kind of managed to stay pale because I sit in the shade a lot. But even I'll get a little color because you just can't be in Florida and not catch some rays.
Oh, it's so intense.
Yeah.
Yeah, I used to spend quite a bit of time, not so much in Tampa, but north of there in Hudson, Florida.
Man, I can't wait to go back. My parents live in that area, and they're just restaurants that I want to be eating at right now. Hawkers. Oh, goodness. Sorry. Even though it probably tastes bad to me right now, like everything else. Fair Frozen 55 says defense distributed already, going all the way to 0% with Ghost Gunner 3. I'm still waiting on mine. FGC and F Brandon. There you go. John Crump Live says, I have a Ghost Gunner 3. Cody Wilson is back in charge. Yeah, he was temporarily out as CEO of the company because, the pending case, they had the civil case still going on during his criminal stuff. They pulled him out, and then they had a lady in charge of it for a while, and then he came back after his case was done.
Yeah, I only met him that one time, and I mean, he struck me as an exceptionally smart guy. And the little machine he has, that Ghost Gunner, that box, I don't know what version I was looking at, but that was an amazing piece of equipment.
Yeah, if I understand right, it's basically a box. You put a particular size block of metal, and in this case, the Ghost Gunner 3, it's a 0% receiver, so it's not 80/20. And then it it picks it up and it mills or it holds it in place or whatever, and it mills out and drills where needed to be drilled. And what comes out of the machine is a ready to go lower receiver.
Yeah, I believe the one I saw was making a 1911 frame, but
Yeah,
it was
yeah,
just
'cause
amazing.
it can do, you
Maybe
can
it was an
load
AR
in.
receiver. I don't really remember. I think it was a 1911 frame.
Well, I think you can load in different CAD designs and it'll just do it. It's technically just an automatic CNC machine,
right?
When you get down to it, it's not actually a gun specific thing, but that's what it was designed to do, was the gun things, but it can do other CNC stuff. It's crazy. I think it's fantastic. And yeah, Cody is certainly, I've heard interviews with him and stuff. He certainly comes across as a very smart guy. And he's wildly interested in the idea that they can obviate the Second Amendment by making enforcement impractical, by saying anybody anywhere can make their own gun. What can the government even do against that? Are they going to make metal illegal? And the answer to that question is yes. I'll just tell you right now, that is what the government will intend to do. If they need to, they will just make metal illegal.
I mean, the barrier to bad guys getting guns is zero, folks. It's
Right.
literally zero. When I worked as a diesel mechanic in Harlem, New York, and they just pull into the yard with cars and open up the trunk and it'll be full of guns. I mean, you buy whatever you want.
Yeah. And that's always been the case. The restrictions on gun ownership are restrictions on the law abiding. And that's, yeah. Morgan Babcock says Rumble has just offered Joe Rogan $100 million to exclusively platform with them, with a commitment to no censorship, as they put it. What would that situation look like when dealing with the standing contract with Spotify? Joe Rogan should argue that Spotify is a material breach of that contract, and he has every right to pull out. I mean, I don't think he wants to do that at this point, but if he did, they just pulled 130 episodes.
It's unclear to me if he consented to that, though.
Yeah, it's possible that he did, but I'm saying if he wanted to, and even if he did consent, by the way, he may argue that there was that he was compelled to consent to that under the threat that his contract would be canceled or not honored, because they'd made indications that they were not going to honor his contract, or that he would be canceled or whatever. There was a big hubbub over it. So he's got some arguments that they had a constructive breach of the contract, and but they are arguments, that's to be clear. But if you wanted to switch to Rumble, I mean, those are the type of arguments you would make. You'd say that no, they had breach, or you'd argue anticipatory breach. They're going to breach my contract, therefore I get the right to pursue my options before the damage of their breach is done. That's what they would do. I think it'd be great, by the way. I hope, I don't think he'll do it, but I would hope he would do it. That's what I would want him to do. And Rumble has a better track record on censorship than Spotify so far. Not that that's all that hard.
Why wouldn't he just set up his own podcasting empire? I mean, he could do it by himself, right? He's show number one, and people would flock to it.
Yeah, well, I think part of the problem is just how expensive it gets to host that much traffic. And so if you can offload it to someone who's already hosting that much traffic and get paid for it, that's the way to do it. But did I see his bitch out N-word apology? I saw something, just a snippet of it, and if you haven't figured it out yet, your apologies will never be used to exonerate you. They will only be used to bury you. That's the way the apology culture works. They demand the apology, and then they say, see, they apologize. They did do the bad thing, and you should continue to hate them. So I thought Joe would have known that by now, but he's not returning my calls. Just kidding. Just kidding. He would always return my calls if I ever did. G Tugger 329 says, hey, Nick, I watched Predator last night. Oh, God, a great movie. You have to figure out a way to include Governor Ventura's lines in the helicopter at the beginning of the movie. Don't care how, but you must. Yeah, I don't know about those little F slur action going on in those lines. No, that was good. I love that movie. Next, Andrew Smith says, Ricada Law, hope you're having a good morning, bro. I am. Agent Zero says, Caucasoid touchdown unbreaded. Susan Croncord says, what are the rules when sweethearts encounter one person turning 18 before the other? Well,
Romeo and Juliet laws.
Yes.
Or what they're commonly referred to.
Most states have some leeway when you're within a couple years of age. So 17 and the other person turns 18. That's not gonna, in most states, that's not gonna do the cutoff. I think in Minnesota, it's like 4 years up. So if you're 16, you can technically get with someone who's like 20 or something like that. That's at least how it used to be. It's not legal advice. Don't do that. But yeah, that they had like a flexible sort of window right around the age of consent. In other states, they do it a little bit differently. In many states, if you have any sort of marriage, like sometimes you can marry someone who's considerably younger than 18, along with as long as they have parental consent. I think Courtney Stodden was married at like 14 years old or something like that, to that guy from American Beauty, the dad neighbor. You familiar with the movie American Beauty?
Yes, with
Kevin Spacey.
Kevin Spacey, right?
Yeah, the neighbor, the dad, who was the dad of the weird kid with the camera. He married. I think that was him. He married Courtney Stodden. She was 16.
That seems imprudent.
Yeah, but her parents gave consent on it. I mean, I guess. I don't think it lasted. But yeah.
So
sad. Could you imagine marrying a teenager like 18? Could you imagine marrying an 18-year-old?
No.
In general? I could not. I mean,
hey, listen, I'm only 50% on marriages, so
yeah, I know,
think
but
it's a high risk endeavor.
But even so, like, I just think now talking to any 18-year-old is a maddening, and I don't understand the language anymore. I've aged out of being able to communicate with 18-year-olds. Their memes are better than mine, so I don't know what I'd do. I could not imagine being at a disadvantage to my wife on memes. That'd be terrible. Jen Campbell MA says, which law school course did you each love and which did you loathe? Did you have a paper chase law school professor who inspired you? For me, I loved national security law. It's a great course. It was, and I loved my con law class. Both of them taught by the same guy, John Radson, former general counsel for the CIA and a nationally recognized expert on the drone program. You can find quotes from John Radson about drones when they were a little more popular to talk about in LA Times, New York Times, pretty much anywhere ink is printed. He was a great professor, though. One of the best teaching method professors I've ever encountered. Which course did I loathe? Oh God, I took a healthcare policy class that made me want to die. Property 2 was terrible. Civil procedure. It's kind of rough. What about you? What did you like? And
Worst uniform commercial code.
Oh God. Yeah.
That was terrible. Contracts, first year contracts was fun. My midterm was selected as the model for the rest of the class to review. So that was nice.
Oh, that's cool. Model,
but then after enjoying contracts, I took UCC, and that was the end of that career path.
Yeah, UCC's horrifying. Secured transactions was pretty boring most of the time. I actually liked negotiable instruments, which had a lot of UCC in it, but that was kind of an interesting class. But Secured transactions, that might have been my least favorite. That was brutal. Okay, sorry.
I mean, UCC is kind of the like accounting of law, folks. So if you're super nerdy, detail oriented, that's a good space for you.
Yeah. Yes.
UCC is Uniform Commercial Code.
Right, and it covers a lot of what you do. Going to a store, merchant agreements,
Titles, all kinds of stuff. Liens.
Andre the Giant 16-second fart says, "This is as boring as bread. Lucky enough. I love you, Kunz. Kunz, Cunce. I don't know what that is. Kunche. Must be Italian. No, it's this is the way it goes when there's jury selection going on and they deign not to televise it, hoping that they will get done with jury selection and then, start the trial proper. Because once they're done with it, it should pick up really, really quickly.
I mean, unless they're going to call everybody in the theater as a witness, it should not be a long trial.
Right. I was kind of actually thinking it's possible this thing's done before Friday.
I hope so. I actually put off my my Texas motorcycle trip by a week for this friggin' thing.
So there was again, I keep looking for articles. This one is from 8 minutes ago, but it's still just talking about why there's only 6 jurors on being selected. Not that they have been selected. Okay, Al Fivra says it came out over the weekend that from Gun Owners of America that the ATF has a searchable database of approximately 1 billion firearm sales. Was this in question? Wait, news said the plan is 3 weeks for this trial? Oh boy.
Well, then I'm going to miss the last week.
No. Okay. I'll be here. You can put a GoPro on your motorcycle and stream it.
Yes, for people in the comments, it is. I live outside of Denver, so it's cold here.
But yeah. So wait. So the ATF searchable database, is that news to people? Because to me, I mean, you signed the application to purchase a gun, which isn't in and of itself a record of the transaction. But when they trace a gun by its serial number, they know who bought it. It's a really easy thing to do. It doesn't always say who the current owner of the gun is. If there's a private transfer, that is not always required to be recorded. It depends on how it takes place. But yeah, of course, ATF has a searchable database of gun purchases because they always have. I don't know if that surprises me. That doesn't surprise me at all. I mean, I don't know why that surprises anyone else. Janet Morgan says they type everything they say in shorthand, then have to go back when the day is over and transcribe that into regular writing.
That sounds like a fun job.
Court reporter thing. Again, it seems wild because you could just record it, I guess. But again, maybe it's a failover sort of provision where if the recording fails, at least there's a person there. Not applicable says, I hope they defrosted those Hondurans afterwards. Oh man, I cannot imagine playing soccer when it was that cold. Mullenlabe says the court reporter keyboard isn't letters. It's all the syllables in the English language, and they combine the syllables to form the sounds words make.
Okay.
Cool. Not applicable says she has a Jamaican beat in her ears like Hermes. While she's typing. That's good. Captain Spire says, good morning, gentlemen. Question. Can't Gary from Nerdrotic purchase and own a shotgun for home defense when he moves to Texas? Not giving legal advice. I don't think so. He has a felony conviction. He would have to get permission from the ATF to have his gun rights reinstated. Typically after getting you'd have to get an expunge. You'd have to get your felony expunged or pardoned and then request permission to have your gun rights back. I guess the argument would be that Texas would have their own state specific thing. And the question of whether federal supremacy would take place there is a good question. But does Texas allow previous felons to buy a shotgun?
I think after a certain number of years following your sentence, believe it or not, for many years, Vermont had no state level prohibition on felons possessing firearms. So I used to have a friend of mine work for the FBI, and the FBI frequently works with local law enforcement as they put together teams for various things. And they'd go into someone's house, a convicted felon's house, find a gun, and the local cops couldn't arrest that person for that gun possession because no state crime no state law against it. But there is a federal law against it.
Yeah, and the feds don't mess around. They don't mess around. But yeah, he'd have to talk to a Texas lawyer on that one. I would recommend a specialist. But the other way to do it is to go, to attempt to get his previous charges expunged. They were very old. He's a completely different person. It happened in California, which I would assume has some permissive expungement. But yeah. Let's see. Next, Daniel Weimer says, always buy the unassaulted popcorn at the movies. True Anana Shabbat, bad pressure, bad calf care says, honk penguin bread. Blue-eyed Roofcree in the base says, Nick, can you ask Nate what the chances a bunch of transgender soccer players looking to join U.S. women's soccer are possibly being kept out? Scandal. Ooh. I think that's always a possibility. I think a lot of women sports players do not want trans women in their sports because, well, they lose. We saw what was happening with the swimming. Did you see that with the swimmer, the transgender swimmer? And they have now changed the rules at the NCAA and appointed a like a gender panel to independently review every single claim and determine if they are too manly of a former male woman. That's kind of amazing when you think about it. Like, well, your shoulders are still kind of broad and you have an Adam's apple, so you're out. I guess that's the new thing. So that'll be.
I mean, I guess the straightforward XX or XY standard was too complicated.
Yep. It is. Skeet Need says Nate looks like nostalgic critics black employee named Malcolm. Malcolm is a furry, just like Nate. Is Nate a furry? That's interesting.
Seems unlikely.
Nathan Levy says, Nick, tell Branca, as a Harley rider, he is 100% right. I like smaller Harleys, but I rented a R9T. I will own one day.
Harleys are good bikes. I've got nothing against Harleys. I've never owned one, but I've rented them. I've ridden them. They're fun to ride. I just don't like the foot forward sitting position.
Let's see. Lord Xenu Save says, dude was a retired police captain. It's a joke. Okay. The fact that he killed the guy over the popcorn is a joke, I'm guessing. I always have to try and infer the intent behind things, but I think that's what they're saying. I think it's I think it's an insane shooting just on the face of it, unless he can show where he was reasonably in fear, which is possible. I mean, I've only seen a tiny bit of grainy video, but the concept at the onset that this guy would have been justified to use self-defense against, some rogue popcorn kernels that's a bit much for me. It's a bit strong. Slash and Burn Theory says, when Binger held up that gun in court, I think that's when the judge was like, I'm done with this guy. Barry On says, was the popcorn checked for trans fats? We need to check Twitter for trans fats. Dragon's Treasure says, don't tread on tea. Lillian Short Timer says, aging is a bitch. Great job, guys. Oh, thank you. Lillian Short Timer also says, so take this. Patrick Allen says, old dude with cop complex thought he could intimidate someone, got mad that it didn't work, and resorted to pew pew. Old dude needs the chair. Oh my goodness. Florida does have the death penalty still. How do they do it there? Is it lethal injection? I would imagine so.
I don't know.
Most places it's still lethal injection. What do you think about death penalty methodology? Like,
you mean how the person's killed?
Right. Like, so they do lethal injection because it's presumably more humane or whatever. But like, if you had to go, what would your way be?
Oh, I don't care. I mean, really, they're mostly instantaneous. I mean, firing squads is as instantaneous as any of them.
Where the lethal injection one isn't instantaneous. That's what kind of bothers me about it.
I guess they put you to sleep first.
They're supposed to, but sometimes it doesn't work. And you just sit there and like your blood feels like it's boiling inside of your veins for like a couple minutes while you die. It's really awful when it doesn't work. But the other thing that they do, so it's a 3-drug process. The first one's supposed to put you to sleep. And the second one's a paralytic. And then the third one, is the actual like poison. But so if you're not asleep or like numbed out or whatever, but the paralytic works, you'd be sitting there unable to move and react, screaming internally and in intense pain, and no one would ever know. So I don't see why they don't just do a bullet right in the brainstem. I mean, or something like that. I know it's messy, and I think that's the problem with it. I think they equate messiness with inhumane.
Yeah,
but
I mean, just any rifle round to the center chest is going to kill someone instantly. So I always like the had they, at least I've heard this was the tradition when they had a firing squad, they would give one guy unknown, unidentified, randomly give one guy a blank round in his rifle, so that each of the men firing the guns, if they had regrets later in life, could think to themselves, well, perhaps I was the guy with the blank, that I didn't actually put a bullet into him.
There you go. That'd be yeah. I had heard it. I heard only one person had the gun.
Had the round?
Or had the round. But either way, same sort of idea. Let's see. I would not want the gas chamber, by the way. That sounds like cyanide gassing. Does not sound fun to me. On record. I wouldn't want hanging either. A lot of them I'm not preferable to their methods of killing me. Okay. Aaron Pipes says, is this the case where the crotchety retired police officer initiated a confrontation over a cell call and then shot the man because he threw popcorn? In essence, yes. That's it. Melissa Faust says, you shouldn't bring a gun to a popcorn fight. Evan S. says, who will J.K. Simmons play in the movie of this case? The bald lawyer or the judge? Alec Baldwin already has the defendant role locked down. John Bassinger says, is it just me, or does it seem like former LEOs are more likely to use deadly force during these types of situations as compared to regular citizens? I don't know if there's any statistical backing of that. Like, I'm not saying there isn't, I just am unaware, but I can conceptually see why that might be the case, right? If they're used to sort of the nature of defending themselves in this way, they have training, I guess, on it. They get kind of ingrained into the idea that they should defend themselves with deadly force. Maybe, I don't know. Any opinion on that or any data on it?
I mean, it's such a small sample size. I mean, certainly in the Ahmaud Arbery case, you have to wonder if, the reason the McMichaels pursued Arbery was, one of them had been a cop and had made arrests, presumably, in his cop career, and fell back into that role, even though he was no longer a cop.
Wait a minute. What is this about? Anders Breivik? There was just a ruling in the Anders Breivik case. 3-judge panel ruled that Breivik must remain in prison, saying there remains an obvious risk he could return to behavior that led up to the massacre. Anders Breivik is a guy over in Norway or whatever who killed like that. Shot up all those kids, like 70 kids or whatever.
Right.
Yeah, there were some questions about that because I believe Norway has a maximum sentencing of like 20 years. they could do. So now they've just decided to keep him in longer. So that's kind of interesting.
They just make up the rules as they go along.
Yeah. I mean, not that I think they should or shouldn't have that rule. I mean, that's the rule they've got. But if it's the rule you've got, then that's what you got. That guy probably should have been just executed. Frankly, he's a monster. He goes and murders 70 people, mostly children. I have no problem with just throwing that guy in the ocean. But if you're going to have a weird rule that says, oh yeah, well, 20 years is the maximum of any incarceration. Well, I don't know that you get to just change that.
Yep. Monsters walk amongst us, folks.
Let's see. Trying to keep tabs on this keep refreshing through all these things. Okay. Next. Trevor R. Oh, shoot. Always jumps down on me. Trevor R. says, every cop knows that there's only 2 laws that are punishable by death: doing drugs and standing up to tyranny. Everything else is incidental. Audra Wallace says, oh, hey, I didn't know Kat's mom's girlfriend was also a judge. That does look like her. Oh my goodness. A devoured troll says, hop over to Viva's channel. He asked them about this, and they're not taking the gas, just educating people. But people can still take them gas. Okay, so they're not taking gas away, they say. They're just educating people, and then those people are expected to give the gas away or something. Jensen Zeiger says, 2 things: always love the content, even when it's late, and also complaining about having to be up at 7:30 to 8. I need to be at work by 7 and drive 45 minutes to work. Don't be a baby. Well, do you stay up until 4 to 5 in the morning most nights, like I do? And I still have a nighttime show that I do, and that will be resuming tonight. Devoured Troll says, sorry about the spelling in the last chat. Currently at work trying to be fast. Mastaluck 5 says, support the Ottawa Freedom Convoy. Mandate freedom. Yeah, I agree. I agree. Mandate freedom. It's the only mandate. There's no name here. It's just a picture of like a cloud or whatever. But it says, do we know if the defendant left to go get his gun or if he had it with him the whole time? P.S. You guys are awesome. Thank you. He appeared to have it the entire time. When he got up, he went to go talk to a movie theater employee and then immediately returned to his seat, from what I understand. So he seems to have had the gun with him. But William Mitchell, School of Law and Crime, says Nick and Branca are an amazing complementary duo. Love this regular team up. I enjoy it too. Let's see. Kingslayer Damocles says, can you help me understand how Michigan versus Sitz and Terry versus Ohio don't cancel each other out? Like you need reasonable suspicion to stop someone, except you don't. Also ban roadside drug sniff from canines. Well, no, Terry versus Ohio, you do need reason. Oh wait, are you saying in Michigan versus Sitz? I'm not familiar with Michigan versus Sitz.
No, me either.
Let me see if I can get a quick summary of it.
Hey, someone in the comments was asking what my motorcycle is. I just pulled up a quick image.
If you share it, I'll throw it up on screen. Yeah, here we go.
So that's it. It's a BMW R1250 GS Adventure, folks, and I'll be riding around hill country in 2 or 3 weeks. So if you see me, give a wave.
Let's see. Facts of the case. In 1986, Michigan State Police Department created a sobriety checkpoint program aimed at reducing drunk driving within the state. Program included guidelines governing the location of roadblocks and the amount of publicity to be given to the operation. Before the first roadblock went into effect, Rick Sitz, a licensed Michigan driver, challenged the checkpoints and sought declaratory and injunctive relief. He was victorious in Michigan lower courts. Question: did the drunk driving checkpoints violate motorist privacy protected by the Fourth Amendment? In a 6-3 decision, the court held that roadblocks did not violate the Fourth Amendment. Court noted that no one can seriously dispute the magnitude of the drunk driving problem or the state's interest in eradicating it. Court then found that the weight bearing on the other scale, the measure of the intrusion on motorists stopped briefly at sobriety checkpoints, is slight. Court also found that empirical evidence supported the effectiveness of the program. Well, if it's effective, then it doesn't matter what rights are at all, of course.
Hey, for those asking on my Texas Hill Country ride, I will be recording it on video. So I usually just share that stuff with friends, but if people are interested, I'll put it up as some kind of blog post or something.
So short answer comparison of this drunk driving checkpoints versus Terry stops versus Map v. Ohio, which is not Terry stops. Map v. Ohio is the oh God, hold on. I'm mixing up my constitutional law. Map v. Ohio. This is evidence illegally obtained. Right, yes. This is the one that Don King was involved in. That's great case. But yeah, so Matt versus Ohio was requiring a warrant. You've got two completely different issues on their face, because one involves a home and the other involves a car. And you always have reduced privacy interests in your car. Even though you have privacy interests, it is reduced because you're on a public road. You're in a car that is an automatic exception to the warrant requirement because it's a motor vehicle exception. So you have very quick differences. The roads are considered a privilege, not a right. You have a right to travel freely. You do not have a right to any particular method of free travel. So those are some of the differences there. But also, I would suggest humbly that the court was likely wrong in the drunk driving checkpoints. And I feel like that decision's been pared back some, because I feel like they can stop you, but there's limits to what they can do. They can't ask you questions. They still have to go through. They can't just search your car, but they can stop you and just say, "Hey, let me see your license," or whatever. You can show up your license and then drive on, pretty much without doing anything. But I'm pretty sure that's a big part of the distinction as well. But I can't tell you without reading through all of that case right now, which I don't think anyone wants me to do. Alan Fogelson says, Andrew looks very lawyerly until he stands up and he has jeans on. Arc Cap says, have an assignment for rules of evidence. What's a type of judicial notice and an example? Well, you can, what we had here was they took judicial notice of statutes. They took judicial notice of a relevant decision that was made, a concurring opinion or a similar opinion from another court. One thing is you can ask them to take judicial notice of statements made under oath by your client or by a defendant at a different hearing or a different, in a different case. So they made this statement under oath in this thing, or you can have them take judicial notice of a published piece of journalism that you would intend to use to impeach someone's testimony, for example.
Sometimes they'll do it for various technical things too, like radar guns for speeding or DNA stuff. So you don't have to prove everything from first principles again every time it comes up in court.
Right. You would, yeah. You could take judicial notice that this particular model of radar gun has been used in all of these cases. Its constitutionality was challenged and it was upheld as presumptively constitutional. And then, of course, any attacks on it would have to be more specific fact-based attacks. Was it calibrated recently? Is it in good working order? Is it within operating parameters for temperature? All of those types of things. But yeah, judicial notice is just, it's any time you want the court to take official notice on the record of something, especially if you intend to use that something, and it might be more complicated or voluminous than just a quick statement would allow you to make. Patrick Allen says, Andrew, is it Branca or Branca?
We mostly pronounce it Branca, like bank, Branca, but it was Brancaccio originally before we got to Ellis Island, and they trimmed it down. So I don't take offense at either pronunciation.
Oh yeah, so that one guy would really like you, man, because I forgot you have the Italian origins.
Right.
That guy, he really hates Italian, mostly women though. I mean, he's talking about Italian women.
They're crazy.
Oh my gosh, that was so the other day I had this Andrew Smith guy on, and he was involved in that case of the kid who killed his parents and chopped them up in Wisconsin. Chandler Halderson.
Yep. Okay.
So this is the guy, they used to play video games together. They were friends through the internet, and he was stationed over in Germany in U.S. Army, and then he came back to the States and went to go visit him. He's like, hey, we've been friends for a while, and go visit. And he brings him and gives him an SKS because the guy's favorite gun in their games that they played was SKS, and he had one. He didn't really use it, so he's like, here you go. Gives him an SKS. That's the gun he ended up using to shoot the parents. And it was pretty wild having him on to discuss that. And why am I telling this story though? Where did I go? Where did I get there? He was great, and my brain just completely dropped why I brought that up right now. Well, that's what you get, guys. That's what you get. I have no idea why I was bringing that up. Cherokee Girl says Biden is circumventing Congress again to get ATF to keep a database on all registered guns, not just files of out of business gun shops. There you go. Italian women? Did it have to do with Italian women? I swear it did. It had something in there. Oh, yes, I got it. Thank you. Gosh, so he was talking about when he went up there and he got to meet, the people involved in this case. And one of the people that was very concerning to me in this case was his Chandler's girlfriend or ex-girlfriend, Kat. Because I think Kat had more to do with this murder than the state said. In fact, the state said she didn't do anything wrong at all, which made me immediately skeptical. That's when I thought she definitely did something wrong. But anyway, he was talking about when they went to Gander Mountain, and she's of Latina origin, we'll say. And he's like, yeah, man, she was crazy. She went and bought a whole bunch of knives. Sorry. I've ruined the whole thing. It was a joke about stereotypes and Latina women, how they'll cut you because you said Italian women are crazy. It's like, yes, it's true. Also, Latina women will just stab you to death over and over again. Well, now that I've ruined that, Suran Concord says, really, Andrew, simp to the ATF? They just came by and demanded to see all my shoes. Took all the ones with laces. Foxtrot, Alpha, Tango, Foxtrot. You missed the part where it was like, this is all unconstitutional, but this is to protect yourself from the amount of government intrusion that will be in your life. If you want to invite that into your life and home, I mean, just know what you're doing. That's That's the trick. So you advise our job. By the way, we're ethically obligated to not tell people to violate the law. For the most part, unless we have a specific purpose for challenging the law with a specific client in a particular way with their consent and all this stuff. Coy 540 says corrupt Andrew Moore get his legal opinion on Ralph's corrupt Andrew Moore. Oh, he wasn't calling you corrupt. He was telling me to corrupt you. Okay. Corrupt Andrew Moore to get his legal opinion on Ralph's situation if he would be justified in self-defense for the corn cobboning. There was a guy crying on a live stream that people dumped a bunch of corn cobs in front of his house. So he came home and they had dumped a bunch of corn cobs in his doorway or something.
For a reason?
It goes back to an internet joke about a corn harvest, an internet joke that set him on a downward spiral of self-destruction and devastation. I don't even remember the joke. It wasn't even a particularly funny joke, but it made him really, really mad. And then after that, it's the corn harvest has occurred. But yeah, so I guess he was saying that he was being harassed because someone left a bunch of corn cobs on his property. What do you think if you tried to say you come home, you're coming up to your front door or whatever, and you catch someone in the act of dropping off, I don't know, several corn cobs. Do you think you have a justified shoot at that point?
Probably not.
How many corn cobs would it take? That's what we need to. We need a number of corn cobs that will justify a bullet. I notice you're dodging the question as always. Who do you represent in this case, Mr. Branca?
There is no threshold at which corn cobs justify the use of deadly defensive force.
You would say that. You shyster lawyer.
Unless, of course, the corn cob is being used to inflict serious bodily injury. I suppose that's a possibility, hypothetically.
I can think of some very unfortunate ways in which a corn cob could inflict bodily injury. So, yeah. Mr. Hazo says to Andrew, I was in your January class. First time I took notes in years and gleefully so. Imagine earlier when you got up to get the con law book, failing to retrieve it, then showed your own book instead, you would have ascended beyond us.
Here it is, folks. lawselfdefense.com, autographed hardcover, lawselfdefense.com/gethard.
You would have ascended beyond us. I love the way the internet speaks. Carlos Estrada says in Kermit voice, the banging is coming from inside, Nick. Igor Ivanov says Frank versus Boogie with Branca, kill some time. Oh, we could talk about that. I think I mentioned it a long time ago and said I'd like to get your take. Let me find the video. Okay. All right, let me get to the video. I don't want Boogie's explanation. Oh wait, no. Dang it. Let's see. There's a bunch of boring takes on this. I just want the actual. I don't want that. That's too loud. Where's the actual just video? Long story short, there is a YouTuber named Boogie, and then another YouTuber named Frank Hassel who went to Boogie's house, and oh, is this it? Oh God. Okay, so that just a stupid trailer. All right, there's about to be a whole lot of profanity. But this is Frank Castle showing up at Boogie's house to make fun of him. And then what happens is a shooting. there's a shooting involved. But no one is shot, to be very clear. The shooting does not enter into any person. But here we go. So I want to get your opinion on this. This is in Arkansas, by the way.
Come on, you fucking pussy. What's the deal? Where's the gun at, you fat faggot?
There's lots of gamer words in this.
Open
it's
fire.
Frank.
Open fire. You're a fat pussy. You won't even open the door? And then what? You're going to shoot me? You're going to kill me? You're a fucking pussy, dude.
Very important to wrangle your dog before you shoot an intruder. Primary concern. You ready?
Yeah, open fire on a guy who's standing at your door. That sounds like a really smart decision. You're a fucking mentally retarded fat piece of shit.
These people have a lot of free time, huh?
This is the career. This is what you do. Dedalex, we'll get to that.
You're wasting my time, man. What's going on? What's going on? You're protecting your dog? You're a pussy. Yeah, on 3, pull the trigger.
Okay. Is this what I have to do?
You fat fucking fag. Oh my God. Is this real? Is this guy going to kill me?
Yes. He's here to look at the air conditioner, Sam. Is this what I have to do?
You're a fucking fag.
Is this what I have
Are you
to do?
going to shoot me in your doorway?
Yes.
You're fucking deranged.
I'm asking you to leave. This is my home. You are not welcome here. You have threatened my life. I'm asking you to leave. In about 30 seconds, I'm going to fire a warning shot.
Fire it now. Okay. Fire the warning shot now.
Is this what we have to do? I'm asking you to leave, Sam.
Sam?
Cameron, I don't know your fucking name. I'm asking you to leave. I'm asking you to leave, man. Please don't make me do this. Please don't make me do this.
Will you just leave this property so I can leave?
Why's this guy got a gun?
Because I feel threatened.
This guy's about to kill somebody right in front of you.
Why are you on his property?
I'll shoot to wound.
If you're going to shoot the wound, you should shoot yourself.
No, I plan to shoot you, bud. I'm
Right here. Right here.
Okay?
Right here.
Okay. I'm asking you to leave.
You pointing a gun at me?
Yes. You're on my property. You have threatened my life.
You are a fat fag.
Castle Doctrine.
You're a fat fag. Castle Doctrine means I get to take you inside and fuck you.
Okay. Sam, please.
Who's Sam?
I don't know.
Regardless, the cops are coming.
Okay. Have a good one.
Hey, leave the property. Go.
Fuck yourself.
Go.
Oh, thank you for bleeping that one out.
Keep walking.
Sorry. The taunting. The guy after you just did the gun thing. So that's it. That's that. I am not personally aware of the "you threatened my life" of where that ever occurred. What do you think at first glance? What do you think? Justified warning shot into the air?
No, the warning shot's not justified. No way. I mean, these guys are not out in rural farmland. That's a residential neighborhood. That bullet's coming down someplace.
It's not only that; it's in a school zone.
I mean, of course, we don't know any of the actual facts here. If there were credible threats of death and he shows up at the guy's home getting a gun pointed at him, yeah, I could imagine that being lawfully justified. Firing a warning shot, no way. And of course, firing a shot at him. It's the question's always the same, folks. Was there a reasonably perceived imminent threat of death or serious bodily injury?
The facts are certainly knowable. I'm not as intimately familiar with them as I once was, but the night before this, this goes back a ways. Frank had been hassling Frank Hassel, not Frank Castle, but Frank Hassel. He had been hassling Boogie online for some time, about a month, making fun of him, stuff like that on Twitter, right? And then so this is in Fayetteville, Arkansas. So then Frank goes to Fayetteville and is on like they must have like a uptown or downtown area or whatever, where there's like street performers and stuff like that on certain nights. And he gets a picture with like a snake draped around his neck. Right. And he posts something like, I'm in your town or something like that to Boogie and tags him. And that's about that. Well, then they go on a show of this guy named Keemstar and they kind of have it out and have their discussion. And Boogie says several times.
Why would anybody know that any of these people exist? Do they do something notable or?
Boogie has 4 million subscribers on YouTube.
No kidding.
Yeah.
Wow.
I mean, he doesn't have that kind of interaction anymore. But he was once was a very popular YouTuber. But that's, I think it's kind of faded off. He hasn't been doing as much and stuff like that. So I don't know what the decline of Boogie's channel was, but yeah, so he was there.
And what did he do that attracted 4 million people?
I have no idea.
Jeepers. Okay.
I think movie reviews or something. What did Boogie do, guys? I don't know what he actually did. But Frank is a guy who, are you familiar with Sam Hyde, the comedian?
No.
Sam Hyde?
Nope.
Okay. Whenever there's a school shooting and they always have the same picture of a guy, leaning out the window with like an AK-47 of a car. And it's the same guy pictured at everyone. There's a meme that says he can't stop getting away with, or can't keep getting away with it. It's Sam Hyde, and people will like Photoshop him in to places and submit him as the school shooter all the time. He's actually been questioned by the FBI and stuff. Frank used to do like comedy bits with, or help out with recording comedy bits and stuff for Sam Hyde. So I guess that's how he kind of got his thing, but he became notable, I guess, for just being an asshole. That's what he does. So I'm not aware of him ever actually threatening to kill Boogie or anything like that. I'm not sure where that came from. But the night before, they go on Keemstar's show and they're having a back and forth about it. And Boogie says, "Come to my house. Come to my house. I will kill you. I'm not scared of you. I'm crazy." Stuff like that. What would you recommend those types of statements to be made prior to self-defensing?
No.
It's not a good plan. At the end of the day, Boogie did call the police. The police came and they charged Boogie with aggravated assault with a deadly weapon.
Yeah.
So yeah, not recommended course of action, ladies and gentlemen. His trial is still pending.
Oh man. Yeah. Well, that's real prison time, folks.
Right. So I'm not sure what's going to end up happening. He still in theory could plea, but for now it's up in the air. So that was a good idea. Talk about Boogie. Starlaw says Daniel Turchio's shooting thoughts. Who the hell is that?
I don't know.
Raleigh police release body cam. Oh, that's the guy on the bridge. I think. Hold on, let me see. No, this is a different one. This is a different. I just want this video.
Never heard of that one.
Raleigh, North Carolina. There's a compilation of body cam footage. No, oh God, how annoying. YouTube. There we go. Yes, it has sensitive information and content. I got it. Okay, want to take a peek at it?
Yeah, sure.
Here we go. May as well. Warning, there's graphic content coming up. Probably going to watch someone get shot. That's why you're all here anyway. January 11th at approximately 1:32 p.m., RPD officers responded to a report of an overturned vehicle crash near exit 12 on I-440 westbound. Officers were dispatched in response to multiple 911 calls about the crash, including one caller who reported that the driver of the overturned vehicle forced him off the road and appeared to be intoxicated. Pursuant to the Raleigh Police Department's continuing efforts to foster transparency and trust in our community, RPD has petitioned to release body-worn camera and dash camera footage related to the incident. This video contains images and content that may be disturbing to watch. Viewer discretion is advised.
Let's start to a shitty video. Septic truck? Is that what that is?
Yeah. It looks like a septic truck, yeah.
Yeah, we got 4,000 gallons of shit here.
Story my Mondays. Okay, so overturned vehicle there.
That's bad. Is there no audio?
Oh, shoot. Sorry, I have it muted. There.
I mean, I'm not sure.
Hey, we got somebody coming
for
you. How many people are
So so only audio that's happened is he showed up and he said, "Is there anybody else in there?" They said, "No, we got everybody out." He's like, "Where's the driver?" And they said he's not here. So that's.
So who's this dude? He looks like he's cuffed.
I have no idea.
in this vehicle? Where you hurt? Where's your dad?
Maybe his arm's just broken.
Dad's up here?
Yeah.
Okay, how many people were in this vehicle? 4 in this vehicle. All right. You, your dad. Where's the fourth? Is that your little brother right there? Okay. Hey, where you hurt at? Where you hurt at? You're back. Okay, how old are you? 20. Okay, come to this side for me, okay? He's calling. How old are you? Hey! Okay, we're getting cut.
Yo venía manejando. Yo venía manejando tranquilo. Él me venía sacando el dedo. Él me venía sacando el dedo.
Pero deje tranquilo.
Hey, we're gonna figure it out. You need to sit down for me. Listen.
Yo no le venía haciendo nada.
Siéntese, por favor. We need ambulance here, okay?
Aquí mandamos nosotros.
Por favor, siéntese. Por favor, siéntese.
Eso fue lo que hice.
Charlie,
Eso fue lo que hice.
We're gonna need at least 3 ambulances here. We have 20-year-old complaining about back pain. We have a 6-year-old. We also have 1 male appears highly intoxicated. I'm trying to figure out. We're working on it. Okay.
Yeah, these guys need to be away from those guys.
Yep.
Hey, listen. Hey, we have an ambulance coming.
Oh, she got RFD pulling up.
Yes, sir. Okay.
I'm about to go.
Okay.
I'm about to give you a little statement.
All right, let me get your statement. Let me find my notebook real quick, all right?
Begins to get statements of the witnesses as other officers arrive on scene.
So you guys actually saw it happen?
No, I was telling telling the sergeant when I was coming down Jones Sausage, or come across Jones Sausage on 40.
Okay.
Coming up this way, Capitol Boulevard. He passed me. I was running 65, 68. He passed me with it. I mean, like I was standing still. And the truck was sitting there doing like this right here, where it was overweight, carrying all this marble and stuff, or granite. Okay. And then
Welcome to the show, Ron.
How you guys doing?
Good. We're about to watch a police officer involved shooting.
When I come up and was trying to get the patients out the car, out the vehicle, the guy with the necklace and stuff was behind the driver's side. He was on the driver's side.
So everybody was already.
He was not the one. He was not out.
So the guy with the necklaces, he was.
Hey, see.
Okay, so he's got the knife there.
Come here. Come here. Put the knife. Come here. Put the knife down. Put it down. Put the knife down. Put the knife down now.
I'd clear out that background, folks.
Yep.
These cops are going to shoot each other if they're not careful. What's the deal with the firemen? You couldn't keep me within 10 feet of a guy with a knife.
Well, those are cops, I think. They had police written on their jacket. But still.
Drop it! Señor! Drop it!
I'm sorry. I have to really suppress a laugh every time I watch someone drop from a taser.
When they work really well.
I guess it's the exceptions that we sometimes see are like PCP situations where people are just like superhuman.
No,
baggy
not really.
clothes.
It's normally when the probes don't engage correctly.
Yeah. There it happened.
Officers at 10-4, subjects down. He still got the knife.
He still got the knife.
He's got the knife, but he didn't have his life. It rhymed, so it was true.
Watch it!
Yeah. See, that's another problem with tasers. Is,
oh, go ahead.
Once the probes disengage, there's no neutralizing effect anymore. The juice is off. The effect stops instantly. So he's back in the fight.
I mean, he just swung that thing right at that guy's neck.
Hey, is everybody good?
Yeah, I see nothing wrong with this shot so far. I mean, it seems entirely justified. The other problem is they can't really run in and get to administer aid because just a second ago, while he was down, he came right back up and, you know, he attacked from the ground after it almost looked like he was kind of feigning injury, or not feigning injury, but he went from
Playing possum.
Yeah.
I mean, he's air conditioned now, though, right? I mean,
Yeah, he's not going to last long. So he drops the knife.
Nice, clear, clear. I got you right here. I think it was a back left.
Yeah, that's it for that.
Yeah. And this guy's going to put on gloves and try and administer aid. But, I mean, those were center mass body shots.
Swung it, but I'm good.
I mean, those cops were a lot closer. I mean, that's a guy with a knife in hand and a free hand to grab you with is just such a lethal threat. It's unbelievable.
especially
that knife came really close to that one guy's throat.
and he's giving every indication of desperation here from go. So it's not just a guy with a knife; it's a guy who's clearly desperate for some reason.
Everybody good. Where's the knife?
I keep this on. Knife on the board right here.
All right. Y'all want it rolled over?
Backside. Right shoulder, you got one here.
Right shoulder, left chest.
What do you want? Over.
Got any? It looks like it.
Lizzie, he's down from several shots, at least 3. It looked
At least
like
3, yeah.
So, I mean, to me, that looked like completely justified self-defense, or not self-defense, but a completely justified shot. I don't see any problem with that. Did you see anything, Andrew?
No,
Ron. Any reason that guy? Again, I'm always hesitant when the state kills a citizen. I always want to make sure that it's completely justified. That one I have no issues with that I can see. They seem to tried to get ample warning. The only minor thing was not on the cops really, but they really should have those people should not have been as close to that guy early on, but that didn't seem to be the problem. He seemed to have an issue with the police or whatever handling his younger son. So I don't know. That's kind of wild. But yeah, thanks for sharing that, Starlaw. Aluminum Tech says in Richard's voice, Your Honor, my client is a frail old boomer. So basically, even looking at him funny is like a threat of great bodily injury. Okay. So Ron, how you doing, buddy? Welcome to the show.
Thank you. I have been incredibly busy the last few weeks, but I got something filed today, and I'm glad to have it out of my life. And something else was filed last week, so I'm giving myself a little break before jumping back in and reviewing some little bit of deal work, which is I don't do a lot of it, but something I think I can handle. So I'm all right, thank you.
You're doing a little break, and you choose to come hang out with us. Oh,
Yes,
that's
no.
nice.
Yeah, I like TV.
It's oh man, the case that we're sort of covering, there's nothing happening right now. We're waiting for the actual live streams of it to start. They're in jury selection. Is the case of Curtis Reeves down in Florida. He's a retired SWAT police officer. In fact, he founded the Tampa Bay SWAT team. Not Tampa Bay, but Tampa SWAT team. And he was at a movie theater, and the guy in front of him I think prior to the movie starting, got out his cell phone and was texting with the babysitter for their children or their child. And this guy complained to him and then went to the manager of the movie theater.
He complained over the light coming from the guy's phone?
Or whatever.
I mean, he was just texting, right? So it wasn't okay.
So then he goes to the manager or some, maybe not a manager, but a movie theater employee who does nothing. Then he comes back. They get into a further argument. The guy takes the popcorn from the old man. The guy with the phone takes the popcorn from the old man, throws it at him, and the old man, boom, shoots him, kills him.
Oh.
So the thing that makes this kind of interesting is in Florida, there is a defense against a violent felony. And because of his age, what would otherwise be a misdemeanor battery is aggravated to felony battery in Florida.
Is that, in other words, is that an aggravating cause in Florida?
Yes.
Statutory?
Yes.
Because it's the old people's state.
So technically, the guy, under some read of the law, could have been committing a felony battery by throwing popcorn at this man, which would otherwise not be anything other than, some sort of misdemeanor. Technically. Now, of course, the jury has to buy it. He tried to win this at a pretrial motion to dismiss and lost.
Yeah,
so
that's a big ask. That's a big ask.
Yeah. But yeah, so now it's going to trial on, they have a traditional sort of self-defense theory argument. And then they also have the argument that under this Florida law. So
in Florida, they do voir dire the old-fashioned way, that unlike in the states where I primarily practice, New York and New Jersey, where the judge conducts voir dire. In Florida, the litigator, the lawyers who are representing the parties at trial ask the voir dire questions. And when I tried a case down in Miami in front of an incredibly incompetent judge, about I guess it's now 3 years ago, it was the first time in my career I'd done that, because it's not the practice around here. So I guess that's why we're not getting that we're getting even less of the jury selection than we might otherwise get, is because it's.
Did they do jury questionnaires, or is that just up to the court itself? Or
this was federal court, and we did have questionnaires. Yeah.
Okay.
I mean, I know in the George Zimmerman trial they televised voir dire.
Yeah, go figure. Go figure.
Yeah, they Court TV said they said that their cameras would be there, starting at 8 a.m. 9 a.m. Florida time today, and so I was hoping we would have actual footage of the voir dire, but it appears that we will not. Now I'm just waiting to see, for the court day to end, because in theory, if they get done in time, panel of jury, they could have opening arguments. I mean, they still have a couple work hours. What?
Well,
they'll
depends
go to for my time.
Depends how long arguments are. I mean, people sometimes go very long. I don't really understand why people would ever try to ask a jury to pay attention to them for hours on end, but I seem to be in the minority on that. It seems to be a very common practice.
I would never ask anyone to pay attention to me for hours on end.
No, only 3, right? Or 4. Is it 4?
Right now we're an hour
5.5.
Is it 5.5? Yeah, 5.5. So, I might be sympathetic to the argument.
Well, all right. I thank you for giving me a chance to have a cup of coffee and smoke a butt with you guys, but I do have I think
back
I'm
to the grind.
Back to the grind, or the couch. That just not a good look for me to do this from the couch. So
if you want to come back anytime this week, we should actually have trial footage once that fires up. So
footage, man, you're such a boomer.
Sorry, we should have trial streaming video in H.264 or whatever.
All right, guys. Have fun. See you later.
Take care,
See you
man.
later, buddy. Thanks. What, lady? Why?
I don't know. I'm just trying to be in there and having fun.
Is mom here or Miss Cheney?
No, only you.
Only me?
Yeah.
Okay, gentlemen, Mr. Branca, I'll be right back if
Sure
that's
thing.
okay. I gotta go
Yep.
resolve a conflict.
All right, guys, you're stuck with me. May as well pimp some stuff. You can get the Law of Self-Defense softcover book for free. That's at lawofselfdefense.com/free book. We do ask you to pay the shipping and handling. If that makes you uncomfortable, I guess you could order the book from Amazon for $25 plus shipping and handling, or just get the book for free, lawofselfdefense.com/free book. Or if you prefer the hardcover, autographed hardcover, lawofselfdefense.com/get-hard. Or if you don't want to spend even a penny, you can download our Law of Self-Defense 5 Elements of Self-Defense Law infographic. Doesn't cost a penny. Free download at lawofselfdefense.com/elements. If you happen to be an instructor and would like a poster size version of this, we have those too. Those are not free. Of course, we have to print and ship the posters, but you'll find information about that at lawofselfdefense.com/elements as well. And for those of you who are familiar with Texas Hill Country, I'll be taking my motorcycle trip down there in just a couple of weeks or so, depending on departure is variable, depending on the weather here in Denver. Any suggestions for places to see, places to eat, things to do, feel free to put them in the comments, preferably as a super chat for Nick's benefit. If you preface with THC, we'll know it's specific to Texas Hill Country. So that's always appreciated. And let's see. Yeah, not a shill, a grifter, I guess. I don't know. So let's see. So, some people don't understand what shipping and handling means. We have people who work in our warehouse to ship out our materials. They need to get paid too, folks. It's not just the shipping. It's the shipping and handling. That's what the H part of S&H is. Paying the people who take the book off the shelf and put it in the envelope and print up the label. That takes human beings, and those human beings are entitled to get paid for their effort. But if you don't want to pay the shipping and handling, don't get the book. It's okay. Let's see what else we have. I won't be at the Alamo. Sorry, not going to get that far east. Let's see. The perfect age to get married so you can get it out of the way for the second. Yeah, very important to get. I always recommend people get married young so they can get that first horrible marriage out of the way and be well positioned for the, at least in my experience, much, much better second marriage. Yeah, I won't be getting as far as Austin. The furthest east I'm going to get is Fredericksburg. Uncivil law, Kurt is going to come out to Fredericksburg. We're going to have dinner. But I won't be able to get into Austin, so he's coming out to Fredericksburg to see me. Let's see. I saw Texas. Louis Muller's barbecue place. All right, I'll check that out. Thank you very much. Let's see. Thoughts on the CZ? I'm not really familiar with CZs. I mean, I know they exist, of course, but I don't believe I've ever even fired one. Yeah, I'm coming from south of Denver, so the riding here, when it's not snow and ice, is world class. But I've not yet been to Texas Hill Country, so I know I don't want to do it in the summer. I have a week or so coming up free, or that I can free up, depending on if I can get out of Denver between snowstorms. That will be great. I'm going to ride straight down to, I think, Amarillo, probably, in a day. And then from the second day, Amarillo down to Junction. I'm going to be mostly based out of Junction for this ride around Texas Hill Country, but I'm spending one night in Fredericksburg. Let's see. I've ridden in Virginia many, many times, folks. I used to live on the East Coast, taught periodically at the FBI Academy in Quantico, would always take the bike down for that. So Virginia, nice riding in Virginia, the western part of the state, all up and down the Appalachians there. Great, great roads. Although when I last rode there, I took signs of myself and my bike next to passes that were 3,000 feet or so and thought I was touching the sky. And now I live at about just under 7,000 feet altitude. So there you go. Hey, Nick, welcome to the show. Glad you could join us.
Thank you. I'm so glad you had me on as a guest today. It's really nice. Really, really glad to be on the channel. Sorry. I don't know why my daughters had a conflict over one of them being in the room, and they were spraying like a hairspray at the other one because they weren't being allowed in the room, but then actually no, they were being allowed in the room, and they were spraying the hairspray before that. I don't know. Who knows? And I'm like, hey, I got an idea. How about you don't spray anybody with hairspray and you let the person be in the room? Oh yeah, okay. It's like, oh gosh, why did I have to go up and?
That's why you're a lawyer, Nick.
Yes. There you go. There's my alternative dispute resolution. We didn't even have to take this case to trial. We got this thing solved right away. That's the kind of quality representation you get here at Ricada Law. Yeah, I don't know how. I'm kind of annoyed because it would be nice if there was any sort of announcement about what was going on this case.
Yeah, I mean, I think the jury selection will be pretty boring, probably, but at least it would be something to talk about. But I do want to catch the opening statement. So
me too. I think we can infer that they're just not going to do the jury selection, right? Like that's task of find a fair jury begins 2 hours ago, Tampa Bay Times. Pool of 50 potential panelists lined up outside the courthouse by 7:30 a.m. First potential panelist told a judge she considers the shooting murder. Well, not the best start for that one. Let me see what the rest of this article says. I have to go to the old archives for it. Not archived.
So I see someone recommending in the comments, I reach out to Bunker Branding in Bernie. You spelled it wrong, but that's how it's pronounced. Bernie, Texas. Bunker, he's a prominent gun YouTuber. And I have, in fact, reached out to him. So I've emailed his office, and if he wants to get together while I'm down there, that would be awesome.
Man, I'm jealous. You're going to go down, hang out in Texas where it's warm. I'm going to Texas on Friday. For Friday.
Yeah.
And then I'm flying back on Saturday. So
it's not that warm there right now.
Oh yeah.
But,
Good. They can suffer.
But yeah, it's an oven in the summer.
Yeah, I know. It's horrifying. Gosh. What temp is it there now? Because it has been so cold this winter up here.
Yeah, I think it's in the 40s or 50s right now.
I
think it's gonna when I go down in a couple of weeks, I'm hoping it's in the 50s and 60s. So a little cool on the cool side for riding, but manageable.
Ona Wall says potential jurors being questioned individually. So they're doing individual voir dire like we did with the Kim Potter trial. That can make things take a little bit longer. Waiting for the archive to archive this page, but it doesn't seem like it's going to happen. I'm number 1,161 in the queue for an archive. But sometimes those go really quickly, and other times they go like today. So I'll keep looking here. That was just the most recent news story that I found 2 hours ago. But yeah, I mean, I would like to see voir dire just a little bit. I do assume it would be boring because it's pretty much always boring. But there's a midday update. Why can't I hate everything that does this? So here we can check the Fox midday update. But it, you know, it's a video. God, I hate that. I just want to read the story as quickly as possible. I don't want to watch the video. I say as a man who
Inside
makes
a Wesley
videos.
Chapel movie theater, former police captain Curtis Reeves is heading to trial for the death of Chad Olson. Reeves says it was self-defense, but now a jury will decide. Fox 13's Gloria Gomez joins us live at the Pasco County Courthouse in Dade City.
Tell us about it, Gloria
what's the latest on the
Gomez.
jury selection.
Well, as you know, it's going to be a long and monotonous trial because of jury selection. That's expected to take close to a week. They have a pool
Wait,
of about
what?
250 potential jurors. Out
For
of
this
that,
trial?
they will pick 6 jurors and 4 alternates. But Linda, I got to tell you,
That's
the
what they
headline of the day
said.
has to be seeing Curtis Reeves for the first time
Oh my
in a
God.
while. He walked into the courthouse here in Pasco County, sat next to his defense team. He is now 79 years old. The last time we saw Reeves, it was during his stand your ground hearing when he told the judge that he was in fear for his life the day he shot and killed Chad Olson in that movie theater. In fact, investigators say back in 2014, the two argued over a cell phone. The next thing you know, popcorn is thrown, and then Reeves pulls out a gun, shoots and kills Olson. He says it was self-defense, but the judge at the time said she did not buy that in fact, she believed that Reeves' testimony did not match the evidence presented. Therefore, she did not grant him immunity. So now here we are all these years later for a trial. Keep in mind, though, Linda, that when it comes to jury selection, it is really a long process. They will have to interview a lot of these jurors to figure out
Doesn't need
who
to be
can
a long
fair
process.
and impartial, what they know about the case, whether or not they can set those feelings aside. That will clearly weed out a lot of the jurors. But of course, we'll be here and let you know how it all plays out today.
Well,
that changes things.
That's going to be, we might have to postpone coverage of this until something actually happens.
Yeah.
I figured 6-person jury. This
I
case
thought they'd pick
doesn't
it this
seem-
morning and we'd be in opening statements this afternoon.
Yeah, that's what I thought too. Well, let me do this. I'm going to go ahead and read out the super chats and we can wrap up. If this thing is going to be that long, there's no reason to sit here, and I can actually help my wife out with some stuff around the house and with the kids, because apparently our babysitter is not here today. So with that, we'll move on through this and we'll get on with the day. So sorry about that, guys. There was no way I thought that a 6-person jury was going to take a week, much less a day.
And especially in the case that happened 8 years ago, is not, racially politicized. It's no reason it should take a week.
It's not like this guy is an active police officer. I mean, he was a prominent police officer, but even 8 years ago, he was retired for several years.
Yeah, he was 72 already, right? 71, 72.
Yeah,
They just
71
said
'cause
he's
he's
79.
Yeah, it's
So he'd been
crazy.
retired at least 20 years.
Yeah, this is very wild. Vintage Mom says one spouse is a felon and one spouse is not. How does the couple proceed so that the family can protect itself? Well,
It's tricky. The non-felon spouse has to basically keep the gun secured in a manner that's not accessible to the felon spouse.
Right.
Like a lockbox or a safe to which only the non-felon spouse would have the combination. If the felon spouse can access the weapon, they have constructive possession and they're at risk of a felon in possession charge.
Yes. It's really tough with spouses. The advisable way to do it, the legally advisable way to do it would be to not. I mean, I know that sounds awful because that is impacting one spouse's gun rights constructively, but that legal advice does not mean that that's the thing you have to do, but you tend to advise people conservatively. And so you would say your safest bet on this is probably just to not have a gun. Find alternative methods of security, lots of security cameras, locks, things like that. But yeah, if you are going to have a gun, you're going to have to secure it, a biometric lock that maybe the other person doesn't have access to, something like that, possible. but what a mess. Anani 14107 says, "Hey Nick, will you cover the Kim Potter sentencing on or around February 18th? Any predictions on the length of her sentence? Glad to see Andrew Branca on the show." I would love to. We'll see what's going on February 18th. If they've impaneled a jury here, who knows? The sentencing hearing will probably be about an hour to maybe 2 hours tops, depending on how much. Actually, with Regina Chu, the sentencing hearing will be 2 to 3 days long, but it really shouldn't be longer than about an hour. That'll allow for victim impact, which they already gave on stand, but they'll give again for a couple of the victims, the parents, maybe the 1 week long girlfriend, I guess, so she can talk about how much she loved them. And then Potter will have the ability to give a statement on her own behalf, and they'll go through the PSI and everything, and then the judge will render the
Give her the
decision.
maximum.
Yeah, very possible.
I mean, that's the track record in these cases.
Yeah, because so if I remember right, the maximum would put her somewhere, because there are aggravating factors.
Right.
There are. You have a police officer. Minnesota recognizes being a police officer as a position of trust. I disagree with that default assumption. I don't think that Dante Wright was in a position of like trustful custody with this police officer. I think it was kind of the opposite, but that didn't matter in Chauvin and Floyd, and it won't matter here, most likely. So I think it's what, like 12 years, because it gets so third degree. Did she get a murder charge? I can't remember what she was actually convicted of.
No, but they do it weird. They're like second degree murder is really a manslaughter conviction.
Yeah.
They call it murder, but it's
Right,
really reckless manslaughter.
But the second degree murder has a 20-year sentence on it for
Yeah.
the unintentional. Is that what she got convicted
I'd
of?
have to look. I honestly don't remember. But I mean, Chauvin got 22 and a half years.
Yeah.
So for effectively a reckless killing. So
First and second degree manslaughter,
right,
is what she got. So hold on. So the statutes, manslaughter. This will be the relevant one. Manslaughter in the first degree. Not more than 15 years, or to payment of a fine of not more than 30,000 or both. So you can expect a sentence somewhere in the neighborhood of 20 to 30 years, I would think.
Yeah.
With the aggravating
low
factors.
20s. Yeah.
Yeah, the judge, one aggravating factor would justify up to doubling a sentence in Minnesota. So and with several of them, you could triple it. I don't know that she'd go for triple here, but one could certainly justify up to doubling. They have multiple on this one. So that'll be a mess. But yeah, I'd be happy to cover it. If not, if like there's if we've got a live trial going on, I'll probably cover the sentencing that evening or the night or whatever. But yes, I'll cover it for sure. Mandy Karavicha says, when they execute Curtis with the electric chair, could he be holding an unpopped bag of microwave popcorn? Let's light that up. Oh my gosh. Adam Trapp says, death by snoo snoo. I am nobody says the eight. Oh, that's the way you'd go. That'd be good. I am nobody says the ATF FBI searchable database is a specifically prohibited registry. I don't think it's a surprise so much as that we now have an admission. I mean, again, I don't know. I get that it's a prohibited registry, but how do people think that the BCA tracks gun purchases when a gun is found at a crime scene? Is it that the ATF has it rather than just the Bureau of Criminal Apprehension? Is that the idea, or is it that that the feds have it rather than the individual states having it? I'm kind of curious.
Listen, I would agree the federal government should not have this kind of registry for sure.
Right.
But if they don't have it, it's not because it's against the law, and it's not because they don't have the means. If they don't have one, it's because they don't want one. If they want one, they have one.
Yeah, and I was always under the assumption they did, because I know how gun tracing works. Whenever they find a gun, they run a gun trace. It's through ATF, and they go through and they find the serial number and where it was purchased, and if there were any registered transfers after purchase, and they can go investigate the owner of the gun and ask them, hey, where'd it go? Oh, where'd this gun? What's up with it? Where is it? That's actually what happened in the Chandler Halderson trial. Chandler Halderson, the SKS that he used to kill his parents was found in the barn. They found out where it was. They found out it was registered to Andrew Smith. They asked him questions. He showed them the picture of the driver's license of Chandler Halderson next to the serial number, said, I sold it to this guy. That's how they find these things. Scooter McDude, I missed this one earlier. He says, everyone takes a buttering sometimes. Phil Harrington says, Florida allows the soon-to-be departed to choose between the needle or the electric chair. The chair was made from the wood of a scaffold when they stopped doing hangings. Ooh, so it's like double haunted. Maybe that is the way to go. So you can be bound into the wood of the electric chair with all of the other murderers. Christy in the Carolinas says, South Carolina just implemented the firing squad. I think that I'd go with the firing squad. That seems like the way to go to me. Or guillotine or something. Daryl Conger, thank you for the donation. I am nobody, says, on the subject of how to go, nitrogen gas is supposed to be painless. Discovered this researching and persuasive speech on the death penalty. Yeah. Have you ever overdosed on nitrous oxide, Andrew?
No. I guess it's the safe answer.
Yeah. I was at an oral surgeon. I had to get a tooth removed as a kid, and it was like a complicated pull. And they gave me, I was on the gas for like a really long time for whatever reason. I don't know if they got wrapped up in someone else's room. I started hallucinating. It was terrifying. I was not a big fan of that. I got really sick afterwards.
Yeah, but I think they're saying literal nitrogen, just nitrogen.
Rather than nitrous oxide. Yeah.
And the way that kills you, folks, nitrogen kills people every year in America, mostly in labs that have big tanks of nitrogen that leak. What'll happen is the nitrogen displaces the oxygen in the air, and your body doesn't know that it's breathing nitrogen. Your body can't tell the difference. So you feel like you're respiring normally, but you're not actually getting any oxygen. So you lose consciousness, you fall over. You're breathing nitrogen until you stop respiring.
Most of what we breathe is nitrogen. North of 70% of what we breathe in is nitrogen. Very little is oxygen, a little bit less carbon dioxide and other elements, but nitrogen's the primary thing. So yeah, it makes sense that your body wouldn't really know the difference.
I mean, when people think they're not getting enough air, what's actually usually happening is that your body detects carbon monoxide buildup and carbon dioxide buildup, I should say. So if you're like in a sealed room and it's running out of air, it's what's actually happening is the carbon dioxide is building up, and that's triggering your brain to let you know you're not getting enough air. But if there's no carbon dioxide buildup, you don't know. Your body can't tell any difference.
Okay, so next we've got Asp says you can only bring in gas and fuel for your vehicle only. You cannot supply it to anyone else, per numerous cops on Viva's stream. Man, that'd be amazing. You know, just if a cop, like, imagine if you were bringing gas to a friend, the cop's like, nope, sorry, because they're Canadian. You got to bring your own gas there, eh? Sorry, he ran out. He'll have to die in the street there. Next, we've got Ricky Hendricks says, did you hear of the Israeli execution decades ago of Arab terrorists with bullets dipped in pig's blood? I've heard of rumors about that. I don't know, who knows if that's true. Blaine Storm says, when did Les Busey from Canterbury become a judge? American legend, welcome to paralegal status. Alfiver says the ATF is only supposed to keep paper records, not electronic registry. They're supposed to go to the manufacturer, then FFL for records. Okay. Not applicable, says Hassel's now the. I believe you. If anybody's surprised that the government has kept a list of guns, I have a FISA court to sell you. Not applicable says Hassel's now the one that sent Boogie to prison. Good game. Brandon James says stop Gunt crime. I am nobody says Branca on Demo Ranch would be hilarious. Do it, man.
I've reached out up to them.
Koi 540 says on the topic of tasers, can you look up and play the 17-second video? I'll get you, bitch. Note how the person surrendered after the tasering, unlike the guy with the knife. I mean, I don't need to pull that up. We saw the guy get tased, and the typical response from someone who gets tased, because it hurts and it's unpleasant, is to surrender. That's the idea behind the taser. But you know, if they don't, they don't. And some people react and they choose violence. So at our homeschool co-op on Thursday, there was a cop from the sheriff's office here, the local sheriff's office, and I looked at his taser, and I noticed he had it cross draw, and it was solid black. It was not the type of taser Kim Potter had. The handle looked like a gun handle. It was not. It was, you know, hers was like a little fatter and stouter handle. This is a longer handle. It was all black. And I was like, everything's wrong with this. And so I went up and I said, I noticed you wear your taser cross draw. And he says, yeah, we do that so we don't have an incident like in Kim Potter. I was like, that's weird, because I was under the impression that support side straight draw was the preferred way to prevent the Kim Potter situation. And he said that maybe that's how they do it in their town. Maybe they're doing, but ours, they're required to wear it cross draw. So it was kind of interesting to see the completely different perspective that they had on the tasers here in my county. Outnumbered Mom says local affiliates on Twitter are saying jury selection Monday through Wednesday with opening arguments on Thursday. Well, we'll see. We'll see. I'll monitor for it, and if they think they're going to get done, then we'll fire up the stream. Cameron Nelson says unbreaded. Take these popcorn bullets, boomer. Blammo. Request denied. C. Neil says, bring your leathers. It's not a dry cold. Look at the ride between Utopia and Leaky. Great tide. Might be great ride, but it says great tide. Corn dogs akimbo. Machine is here. I have approximately 30 0% lowers, 70-75 aluminum in our material rack. At what point will this be a felony? Sooner than I'm comfortable joking about, actually. It's a matter of time. If they can get an 80% lower made illegal, I think they'll go further than 80%, but I think they'll, 50% or something stupid. But if they can do that, it's just another
numbers
step.
game at this point. I mean, it's ridiculous. I mean, first of all, there should be no restrictions on 100%, right? But even if we accept that, if it's 99%, it's not a working gun.
Okay, you want me to actually look this up? Is this real? This is a real thing? Okay, well, I'll pull this up. I guess this is an actual real thing. This I'll get you bitch taser clip. We'll pull this up real quick. Here we go. It's pretty short. Here we go.
Just got dispatched to a domestic disturbance where a male is chasing a female down the street.
What's going on? I ain't got nothing to say to you.
I'm not going to tell you again. Sit down on the curb.
And what are you doing? Don't be grabbing on me. I just asked
You're going to get
you.
tased if you don't sit down.
I ain't did nothing to you.
All black taser.
I'll get you, bitch. Charlie, when I get out of here, I hope your punk ass is gone. I don't never want to see your bitch ass again.
Well, That didn't. That taser was not effective. Not effective at all. That guy just stood there like.
It happens a lot.
Happening.
People have big, loose shirts, loose clothing. The probes get in the clothing, but don't get into the skin. They don't work.
Yeah.
So.
Okay. Tara Rayner says, if you want to have a giggle, excuse me, I sent a video on Facebook DMs. I'm filing a complaint on the Ottawa chief, but the board that investigates them has 2 city council members, including evil Diane Deans, compromised like your FBI. Just Dawn says, supposed to be 72 here Friday. Please pack accordingly. Not applicable says, rights. Blocks of metal illegal. Get USSR'd. Laura T says, Nick, did you watch any more of the Travis Ranking trial? Do you think he was legally insane at the time of his shootings? I want to. He was not found to be legally insane. And legal insanity is a really, really high bar. It's not a simple thing. It's not they're acting crazy or even they are crazy. They have to be legally incapable of knowing the rightness or wrongness of their actions, not of the facts related to their actions, which is a weird distinction. If they think they're shooting, like Hitler, but they know that shooting and killing someone is wrong, then they're not legally insane. As weird as that sounds, for the purpose of their crime. So I have not watched the thing, but I heard the defense expert was kind of a disaster, the defense psychologist expert. So I might go back and review those on a night stream sometime soon. Maybe I'll have Ken Jennings on to help me with that, because he was sending me some stuff and suggesting that there were some problems. So we'll see. Okay, I have to check Odyssey real quick, and then we'll probably be done in just a bit. Rodimus Supreme says, first time I'm able to throw money at Nick, not doing it on YouTube. They aren't getting my banking info. Keep it up, bro. Nipple Salad says, fuck GoFundMe, honk honk. Del Frickin' Tree says, nobody likes N-words. 2 second Cuphead brother says, Gunt just misses you, Nick. He was angry at Jim because he didn't get to make out with him for years. Dude, that was the most sad, pathetic thing that could have happened on YouTube on Saturday, and it was glorious. Sword Caliber says, what's 6 inches long and makes every guy groan when a woman touches it? Answer, the gear shift. S Duster says, Smitty, General Sam, or Aqua FPS. Oh, that was from 2 days ago. Okay, never mind. There we go. That's the chats. Oh, I Am Nobody says they're restricting basically all partially complete lowers. 80% is just an industry term, not a legal one. The rule is available on the Federal Register. Yeah, we'll see. We'll see what happens with it. Hopefully it'll be challenged, but they'll just say Commerce Clause. They determine that this is an item in commerce that Congress has the power to regulate, just like they did with marijuana, for example, or for a time they did alcohol with the constitutional amendment, so that was a little bit different, but or they do with guns already, or anything else. So eventually it'll be a mess. But that's all I've got for today. Mr. Branca, is there anything you want to say before we head out?
Thanks for having me on. And,
yeah, well, thanks for sitting through the slog. I mean, there was I can't believe they're going to take 2 to 3 to 4 to 5 days to do this jury. It seems crazy. But yeah, well, hopefully it'll pick up. I'll watch the news. If you see anything about them finishing jury selection, let me know.
Same.
And we'll fire up a stream the second there's opening statements, because I would love to see how this case plays out. I think it's going to be fascinating. Other than that, guys, as far as daytime shows, stay tuned. I probably will not be doing a show starting at 7 a.m. if we don't have a trial to watch, but there will hopefully be some afternoon shows coming up this week. Other than that, you can catch me at 11 p.m. And finally, make sure you check out Andrew's channel, Law of Self-Defense, in the description. And until next time, peace.
Take care, guys.
Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lethbrook. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lost-plaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lost-plaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no